o'clock, we'll get the show started. So I declare open this public hearing of the Joint Standing Committee on Aboriginal and Torres Strait Islander Affairs Inquiry into a Truth and Justice Commission Bill 2024. I'd like to begin by acknowledging the traditional custodians of the lands on which we meet today, and I pay my respects to their elders, ancestors, past and present. I extend this respect to all Aboriginal and Torres Strait Islander peoples and their cultural and spiritual connections to Australia's lands and waters. On behalf of the committee, I welcome traditional owners that are here today. Since we've only got senators here at the moment, I remind senators that proceedings are to be conducted in a respectful and courteous way. And I remind senators that this is a workplace, and this is especially true for the public officials and stakeholders who are present before us. It is essential that they are treated with respect and that they feel safe when they present to the hearings before us. As Chair, I will be particularly vigilant in ensuring the cultural safety for First Nations people and culturally and racially marginalised groups that are appearing before us in these proceedings. In accordance with the Committee's resolution of 7th of September 2022, this hearing will be broadcast on the Parliament's website, and the proof and official transcripts of proceedings will be published on the inquiry website. I remind members of the media of the need to fairly and accurately report proceedings of the committee. And I'll invite members of the committee to introduce yourselves. I'll start on my right.
Senator Cox from Western Australia.
Thank you.
Senator Kerry Middle, South Australia.
Thank you. And we're just checking to see if anybody's joining us by teleconference. Okay. I think we're okay.
Chair, you do have some of us on the phone.
So, Deputy Chair Melissa Price. How are you going?
Good morning, everyone.
Matt Burnell, Federal Member of the Bench.
Excellent. Excellent. Thank you very much. I now welcome our first witnesses to give evidence today. For the Hansard record, would you please state your full name and the capacity in which you appeared before the committee? I might start on this side first.
I'm Alison Whittaker. I'm a Gomeroi woman, and I'm here representing the Jumbunna Institute for Indigenous Education and Research at UTS.
Good morning. Ms. Chloe Farkas representing the National Justice Project.
Excellent. So, although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. And I think we're okay for transcription in terms of stating your name before you speak, but it might be useful for Ms. Price, who is joining us via teleconference, if you could say your name before you speak. And I now invite you to make a brief opening statement of no more than 2 minutes before we proceed to questions. I might start on this side now. Or
Chair, we will be doing a joint opening statement.
Sorry. Yep.
So just for people online, Alison will be starting off the opening statement.
Great.
Thank you, Chloe. This is Alison speaking. We're speaking today on the lands of the Gadigal people, whose sovereignty was never ceded. We pay respects to Gadigal elders past and present, and we celebrate their ongoing custodianship of land and sea and sky. We also honour the enduring resilience and strength of all First Nations peoples in the ongoing fight for truth and justice. We speak here today as the National Justice Project and as the Jumbunna Institute. We're two separate organisations brought together by our alignment to a social justice agenda by and with First Nations and First Peoples. In our work, we each seek to bring First Nations and First Peoples truth into legal, policy and research domains. We don't do this for the sake of truth alone. All this work is done with the same goal in mind: justice. I'll hand over to Chloe.
Thank you, Alison. This bill offers a space to speak both to truth, telling and justice in a moment where we must take neither for granted, and when we see some state and territory-based truth-telling processes have been demolished in the early stages. As organisations, we both deeply support a Truth and Justice Commission, and thank you for the chance to speak to it. Like many organisations you'll hear from today, our concern is not on should we have a Truth and Justice Commission at the Commonwealth level, but on the question of how. A truth-telling commission is purpose-built by design. For this reason, we raise the importance of having a truth-telling commission with a clear purpose. One that is purposefully designed to produce future outcomes or opportunities for justice, rather than to issue findings of fact. Apologies. There is a temptation for commissions to turn into fact-finding institutions, particularly because they are so familiar to the executive and royal commissions. Exclusively prioritising fact-finding carries its own risks and preferences the idea of new knowledges and narratives over a space for healing and truth. Much of what any truth-telling commission will hear is already known by First Nations people. We ask this committee to think about what becomes possible if we free ourselves of the mandate to uncover facts and instead think more broadly about hearing truths and the mandate to do something about them. In exploring purpose, we raise the importance of outcomes, genuine actions and respect. In our submission, we put forward the comparison between the recent parliamentary inquiry into missing and murdered First Nations women and children and the Canadian National Inquiry into missing and murdered Indigenous women, girls and Two-Spirit LGBTIQ+ people. This inquiry required deeply personal evidence and families relived the effects of violence on their missing and murdered loved ones. This cultural and emotional load was carried by families and community, as will be required of this Truth and Justice Commission. After 2 years of inquiry procedure, the final report released outlined 10 recommendations, none of them holding institution and systemic injustices to account. In comparison, the Canadian counterpart final report included a total of 231 recommendations titled Calls for Justice. The report also spoke to genocide and colonisation as a tool for gender depression. The inquiry included aftercare support post the inquiry, and this comparison provides a contrast for the respect and outcomes given to families who ultimately have to commit to any truth-telling process. The end goal must be that people believe any commission operates from a place of care and respect, with a genuine vested interest in having truth-telling. Actions will always speak louder than words in this process. Though these are early days, there is a solid foundation for purpose-built truth-telling within this continent. The Europe Justice Commission has started and provides a blueprint for what has been successful, but also are transparent in offering their insights for what can be done better. There are points we want to raise. The establishment of Europe is one that recognises and supports shared decision-making. The First Peoples Assembly of Victoria as its own party to the agreement and kept separate to government, all operating independently. Self-determining frameworks need to be present when wanting to unpack historic and ongoing injustice. The Truth and Justice Commission cannot have a framework that upholds traditional power structures present in current government decision-making. The Europe Commission intends to make recommendations for healing, systems reforms and practical changes to laws, police and education and matters for future treaties. This is a critical path of direct and effective action. Any practical changes to law must be presented and responded to with the urgency they deserve. If governments choose not to implement recommendations, they are at the very least must be mandated to give reasons why this was the case and what other actions they intend to do working towards policy recommendations. And I'll pass it back to my colleague Alison.
If the committee will indulge us, we have an extended opening statement, but if you prefer for us to move on with questions.
That would be great if you can table it, because I know there's going to be plenty of questions from the committee. That would be great. And I will proceed to questions now, and I'll start with Senator Cox.
Thank you, Chair. Thank you for your submissions to this inquiry and just recognising the ongoing work of both John Barner and the National Justice Project in what you do. Your submission was very positive and provided some really useful, constructive criticism. You mentioned the idea that we consider looking for ways to appoint members of the Commission other than through the Attorney-General and Minister for Indigenous Affairs. Are there any mechanisms that you would suggest?
We have no examples to point the committee to at this point. We can take that on notice if receiving models is desirable. I think the question of appointment points to maybe an overarching concern that we have with the bill, which is that these things need to be driven by community design, and ultimately how members are appointed is going to be a matter for the communities that this commission would serve, in our view.
Is that, yeah,
would agree with that.
Similar, great. Yeah, if you have any idea of different models that can be used, that'd be great. You also caution in your submission against creating an offence for false and misleading evidence. Why is that?
We think, if I may speak, Chloe. Sorry.
State your name before you.
Of course, sorry. This is Alison Whittaker speaking from the John Barner Institute. We think the function of a truth-telling commission means that the remedy for someone giving false or misleading evidence is ultimately to make a finding that they've given false or misleading evidence. We think that a truth-telling commission is going to deal with heavily contested knowledge that's going to be contested not only outside of our communities but within them as well. And we think that creating criminal liability for presenting contested information presents an issue with community trust.
So does that include for officials? Because obviously making false and misleading statements also extends to those government officials that would be attending on behalf of governments across the country, who, without causing any or making any disparaging comments, but we have seen, and history presents itself very clearly, that governments like to stretch the truth when it comes to what is fact, and going back to your opening statement around the way in which Indigenous people have been treated in this country. And it's usually through the lens of their own bureaucracy that they create some of those. So I'm keen to understand that. You're obviously talking from a community perspective, and what we know tips the justice system in a different way. But in the feature of design, I mean, removing that would then obviously continue a pattern of that behaviour. Would you agree?
If I may, Alison, this is Chloe Fragos from the National Justice Project. I think when looking at these design elements and what could be possible, certainly looking at the York Commission and them needing to be directions hearings because government failed to produce documents, and holding the state to account is very important. And I guess what we're speaking to are two separate audiences or two separate parties, and that would be very important to keep. And we see this as well with coronial inquests we do as an organisation, of processes being dragged out or bureaucracy getting in the way of truth-telling, and having families have the full opportunity to speak to truth. So I think where we stand, if it can be split, or if it can be, I guess, really clear that community aren't held to that same level of vigour, and criminal liability not be attached to community, I think is something we both agree on.
Yeah, thank you. That's helpful, obviously, splitting those. I think it is, as you said in your opening statement, quite difficult to create a federal process then, with it being for mob but also being for the government, who are, as we said, by design, may not give us a true reflection of what actually happens. There's also been a suggestion previously around the chair of the commission being an experienced judge with First Nations identity, or that an experienced judge, qualified First Nations person, be co-chairs. Is there a view from either one of your organisations in relation to that?
If I may, Chloe Fragos from the National Justice Project. I did look into this with the Canadian inquiry into missing and murdered Indigenous women and girls, that as much, I think this goes back to being community-led and designed, something was put forward similar, where how we embed cultural safety into that process may not always match having the cultural safety outcome. If that is then replicating a similar process but having further training, or people represented at that level as well, it doesn't always guarantee that cultural safety. I think it's looking at the whole of design system, and then also being led by community. I guess what we speak to a lot in our submission is trust, and if there's trust in the process, then there's trust in the outcomes as well. So I guess from the National Justice Project, we can't speak to that specifically as that being the hard done that will fix, but I think that ongoing conversation of how does that look like with community.
Ms Whittaker, did you have a comment about that?
My view is it's very desirable to have a First Nations judge as the chair of this commission. My caution is that's an incredibly small pool of people to appoint from, who are already, I would say, quite burdened with significant work for their communities, and the question of whether their impact is better as chair of this commission or perhaps on the Supreme Court, I guess a question for them as their approach for appointment.
Okay. Thank you. In other submissions, there's a suggested amendment to this bill to specify that the Special Minister be appointed to oversee and guide the truth-telling process through Parliament. Do you have a view about whether that should be someone by special appointment or special appointments as a design feature of this bill.
Could you tell us more what you mean by special appointment?
So actually having, specifying those particular roles, that whether it be co-chairs or commissioners or whatever the name that it lands, actually be an appointment by the Crown versus, or by the Governor-General. I think in your Rook they use the letters patent in order to achieve that. So I'm not sure whether both of your organisations have a view around whether that gives it much more trust, but also much more investment from the government's perspective as a partner in this, but also the way in which the community perceive this is not just another commission, this is not just another process, that actually it takes on a different connotation when the Governor-General is providing letters patent for a particular process that has the powers of a Royal Commission. So I'm not sure if you've looked into that, but you may have some views that you want to share with the committee.
I personally, so this is Alison Whittaker speaking from the John Bunner Institute. I personally haven't looked into it myself, and I'm happy to take this on notice to form a more sophisticated view. But I think given what we've seen recently in Queensland and what we've seen previously in the Northern Territory, to have, I guess, a more firm institutional support for these truth-telling commissions, that is harder to undo with the government whim or the policy of the day. That's a desirable thing, and I think that could build community trust.
Thank you. My final question, Chair, and I'll hand it back to you. In your submission, you say that we should outline the immunities and the liabilities of the Commission members explicitly. Can you tell us what you mean by that?
Sorry, I might have to refer to my submission. Could you refer me to the page to say that?
I don't, sorry.
Not a problem.
Please.
Oh, here
These
we
are
are.
special questions that unfortunately weren't written by the Secretariat.
Not a problem. So again, this is one I can take on notice, and I hope you'll forgive me. I've just gotten off a plane from the States.
It's under 2.2, miscellaneous feedback. You've got immunities and liabilities.
Thank you.
It's like you've only got a sentence though before you go to cultural safety.
So from memory in our drafting of this, which was late last year, it refers to, there's a very small section within the drafted bill about immunities and liabilities. We think they need to be outlined explicitly rather than from memory, subject to regulation. But I will take that on notice and form a more grounded view.
But I think from memory as well, Chloe Fragos, I think the issue was there wasn't much detail at the time, and this was more about what will this look like, and yes, that's correct.
Okay, thank you, Chloe. That's great. Thanks, Chair.
Thank you, Senator. Thank you for appearing today. Your submission talks about not making the terms of reference too prescriptive, but I'm interested in understanding what parameters do you think should be put around what could be presented. I go to things like age, experience, issues, government representations, individual representations, organisational reputations, activist lobby group representations. Should there be any parameters at all around those things?
So when we mentioned not being prescriptive as to scope, we refer to the subject matter of the Commission. So I can't remember the section, I'll pull it out in front of me. But it's not, we don't seek to have a completely expansive sense of who can and can't be represented. But as I said earlier in response to Senator Cox's questions, we think this needs to go back to a broader consultation on community design, because commissions are often surprised by the things that they encounter that become relevant, that may be excluded when you're too prescriptive with the scope at this stage of design.
I'm just trying to understand if you've got a sense of how anything that would come from a Commonwealth Commission would be the information it gleaned would be any different because it is Commonwealth compared to, say, something that a state and territory might do.
I'm a little confused by the premise.
So I'm trying to understand about avoiding duplication. What sort of issues would a Commonwealth Commission draw out that wouldn't be drawn out in state processes if they were going down that path?
I'm uncertain. I'm not sure that's something I can answer off the cuff. But I'll happily, as I said to other questions, we'll take it on notice.
Native title.
Native title, yeah.
And I think, if I may, Chloe Fargos from the National Justice Project.
Witnesses, yeah.
This is something that has been brought to our attention. Yes, there has been other processes as well, but through the work that we do at the National Justice Project, people come to us all the time wanting to seek truth, and it's not so much that people don't want to continue that truth-telling and justice and seeking justice because they don't feel like there has been justice. Often where the sticking point is outcomes. So I think for me, it's not a matter of are we duplicating, but are we doing a robust outcome that will really get some actions, some very practical changes at the attention of a national level, which I think it deserves the importance. This deserves the importance at a national level.
So have you given any thought to how to potentially remove risk of individuals who have a belief, genuine as it might be, about history that is presented that that might be in conflict to other evidence that somebody might put up? So you end up with a contradiction of stories. We see that between families, we see that between communities, we see that between Aboriginal groups. How do you deal with that conflict, and is that just evidence given, and who makes the decision about validation of whatever that evidence is if it's conflicting or wrong or not factually based?
This is Alison Whitaker from the Job Institute, and this is one of, I suppose, the core tasks of a truth-telling commission, and one that we think should be explored further in community development, with mind that what we're trying to design here, or what we think is trying to be designed here, is a truth-telling and not a fact-finding institution. And I think in a truth-telling institution, it is open to that institution to hold multiple truths and to think about the desirability of whether or not it needs to reach findings about contradictory information where it might not necessarily be relevant to what it's inquiring into. Yeah, but we appreciate that as a question that goes to the core of what exactly is this commission trying to do. And we think, I mean, personally, my personal view is it's possible to hold the complexity of multiple stories together. And indeed, there's a therapeutic and a justice interest in being able to hold complex narratives without trying to resolve them.
So have you given any thought to what might be off limits in this kind of structure, in this kind of forum?
We imagine that anything that doesn't concern the Commonwealth would be something that would be outside of scope of this potential commission. Other than that, it's one of the reasons that we've recommended putting the scope to community consultation, is that ultimately it's a broad project considering what people want to hear and tell the truth about. It's not something that we can prescribe at this stage of design.
In your submission, you talk about strongly advising against the creation of criminal offences and creating an offence for false or misleading evidence. I go to some of the things that happen in communities where people will challenge people's validation of identity. How do we actually prevent those kinds of things coming up in this process where people are left without any potential to address their justice?
What do you mean by address their justice?
What I mean is, if I'm an individual and somebody is questioning my identity in this forum, as an example, where do I go? If the evidence that is given in that forum doesn't allow me to seek recourse for something that is potentially going to be kept in history, and I have no recourse to challenge that in criminal or civil proceedings?
We would again say, I think, speaking on behalf of the Jump On It Institute, that that's a matter for community design. That's a question for down the road. I agree that it is an issue that individuals should be able to seek recourse, particularly in the information that's shared about them. But as I said earlier in response to Senator Cox's question on this matter, a truth-telling commission that is issuing findings can remedy false information before it by issuing a finding that it was false information. I don't think either your concern or the presentation of false information to the Commission is remedied by the creation of a criminal offence. Indeed, it wouldn't actually address your concern in correcting the record. It would just criminalise the person who has done it.
Okay, I just want to ask, I guess, a question about the community consultation process that you talked about in terms of design. I've heard criticisms of previous processes where they've said, despite the best intentions, it was a bit like going to a court. It was structured and set up like a courtroom. How do you actually address this not becoming essentially a process that looks very much like a judicial process?
I might briefly say what I would like to say, and then I might hand over to Chloe, who I think is uniquely equipped to answer this question. There are incredible grassroots community truth-telling practices that we think this Commission could draw inspiration from, as well as international examples. But I think beginning to reframe again what is a truth-telling exercise versus what is a fact-finding exercise would help in the design of the Commission in terms of whether it needs to implement such a rigorous process as to appear like a court proceedings, or if it can do something that's concerned more with repairing community buildings, similar to the Mile Creek Massacre memorial process. Yeah, that's ultimately, I guess, a matter for community design and the Commission, but I'll pass on to Chloe.
Thank you, Alison. And I think when looking into the inquiry that occurred in Canada, looking at also Indigenous knowledge and worldviews must be foundational to the whole process. And I think then that really speaks to the reshaping of power and how the whole process looks altogether. But similar to what my colleague has said, is I think going back to what is the purpose, and is it truth, justice and healing? Is it truth? Is it justice? Is it all three? And I think when you factor in all three together, there's many things that can be done to support that, such as long-term aftercare, artistic expression, other ways of people presenting information. We are conscious that a lot of the time people feel quite extracted from through submissions, giving oral evidence, but there's a lot of other examples that have occurred nationally and also internationally of getting creative with that process that also allows, and maybe speaking to your previous question, for that healing to occur individually and collectively. But again, how best that is up to community-led design, and also really looking at those structures in place for this model has to have Indigenous knowledge as at the foundation of that, not just replicating processes that already exist.
I'm just trying to understand where the belief is that some of this information, and in some cases all of the information that's required to satisfy legislation, and I'll give you an example in land councils, particularly some of the largest ones, they have huge historical collections. They've been collecting over the years. Some of the material that's in there is disputed because it's been collected by anthropologists that made friends with people, and that unfortunately has become evidence. At what point though in that process do you say, well actually where's your evidence? If I was to come to a commission, where's your evidence to validate what you're saying or rebut what is being presented? Or is it just you go along and you speak about your memories, how you feel, how you think you might be affected? I'm just trying to understand evidence versus people describing how they feel or what they believe to be the case.
And we think that goes to, as maybe it would sound a bit like a broken record, goes to the purpose of a truth-telling commission. If there are issues to be disputed that are particular, if there are factual disputes that need to be sought out, then we would suggest the forum for that would be an inquiry or a commission. There's a fact-finding institutions that are available that exist already, or the opportunity to create them is already available. We think this provides an opportunity to imagine a different kind of institution that's not necessarily concerned with disputing fact, getting to fact, resolving history, but going to the broader purpose of what it means to tell a story publicly, to ventilate truth publicly, and what that could mean in terms of justice and healing for the community that ventilates that truth. Ultimately, it's a question of design and ethos. So I can understand why maybe our submission might be unsatisfactory on the question of how do we resolve disputed facts, but we think ultimately that's not always the concern of a commission of this nature. And I think just to quickly add, Chloe Faragos from National Justice Project is part of that. I think we have no doubt there may be protests involved, or it's not linear, the process, but that's also part of any Truth and Justice Commission, that there won't always be, you know, a monolith or a singular story. So I think we see that as part of the process as well, not necessarily as a deficit, but as something that is very real and very present. And again, it's the ethos, the purpose, and as best those designs elements that help support the journey for people that choose to engage with the process.
Thank you, Senator Little. Deputy Chair.
Thanks very much, Chair. And I'm coming to you from Perth, so it's very early in the morning. Thanks to Chloe and Alison for the submission, which is excellent, and thanks for your excellent attempts at answering all of these very tricky questions this morning. And I think what I'm interested in, I think I'm having trouble hearing, but I think you may have already touched on this, but I just wanted to have another go at it just to make sure. As you say, you're particularly interested in what is important is the design of the commission. That's super important. What I'm interested in is around the environment in which people are giving their truth, giving evidence. Make sure that it's properly safe. I think I'm not entirely sure, and you may have some international examples of what is that culturally safe environment. Clearly, we don't want it to be like a judicial environment, like a courtroom type of environment, and any other sort of international experiences of sort of after people have given their truth, their evidence. We got some examples of how people have been supported after that opportunity to provide their truth. Thank you.
Thanks, Deputy Chair. You were a bit patchy there. I'll invite the witnesses to kind of respond to the question that they picked up, and if there's any further follow-up, it's probably just because you were a bit patchy. So I'll invite the witnesses to respond to what we were able to hear in the room.
I think if I heard correctly, I think there was possibly two parts to that question. Senator, if I believe, do apologise. I think in terms of international examples and processes and what that looked like, I think what's become really clear with the readings that we have engaged with is people just do not want to have a repeat of colonial constructs, or a really eloquent quote was not replicating an ivory tower of placing people to do the white man's job. So I think it's that complete reimagining, and look, we don't have all the answers of every design element of what that looks like, but I think what we really wanted to push forward in our submission is to really encourage and stretch this Truth and Justice Commission to be as imaginative as possible, and to go beyond what has occurred previously, and take elements of other best practice and what's occurred, of course, first and foremost led by community. And I do apologise, I did miss the second part of the question.
So I'm hoping that you might be able to hear me slightly better now. I think you have answered it. And then the second part was really relating to any international experience of what type of support people should be given once they've given their evidence, once they've given their truth.
Thank you. I guess I can refer to what we put in our submission of what occurred in Canada with their missing and murdered Indigenous women's inquiry. And what was really critical and what really jumped off the paper was that there was that long-term aftercare. So it was during and after, and didn't just stop once the inquiry was finished. And where it also got more imaginative was funding for cultural supports that weren't limited to constraints of professional counselling, although that was also included, but also services were allowed to be funded as chosen by individuals, such as traditional healings, ceremonies, teachings and dialogue. Again, it's that looking at, let's be a bit more imaginative and expansive of what's been previously offered to people through this process. And that inquiry has also long now finished, but those supports are still offered to people to this day. And there's also family support and care as part of those services offered. Transportation, so people that live remotely can get access to supports and services as well. And again, I think what really stood out was the gallery of artistic expressions and looking at art as a tool for commemoration. I think that also provides a really long-term and very poignant opportunity to have this moment live on past the inquiry as we want it to do. I'll pass over to my colleague if she has any further comments.
I think Chloe's covered it all. Thank you.
Okay, thanks very much. Thank you. Thanks, Chair.
Thank you, Deputy Chair. A couple of times you've talked about it being community-led and designed, and I suppose my takeaway from that is that your comments kind of make me think that you might think there's a step before a bill gets introduced or gets passed in the Senate that needs to be undertaken before it gets to the Senate. Can you, I suppose, kind of describe to us what a process might need to look like for it to be community-led and designed based on examples that you know of or best practice? So I know that's a big question too. So.
And the magic words, we're happy to take it on notice and we can return with more detail. Yeah. But I would probably refer this committee to the process of designing URUC, as well as the process, to a lesser extent, of designing the Queensland truth-telling process before.
Yeah. And are there particular things that happened for the URUC process and then the Queensland process that you'd like to draw the committee's attention to?
We think consultation has to be, in order for it to be relevant to the communities that this commission ultimately serves, as well as to be culturally appropriate and significant, need to be highly localised. And I think each community is going to have a different idea, and it's the very difficult task of somebody to harmonise those ideas of what a commission needs to look like for them. So we don't, I agree with the premise of your question, which is that we think that before a bill is presented, it would need to go through this process in order to receive the support of, not necessarily the unilateral support of, First Nations communities here. Build some kind of consensus, yeah.
Yeah.
And Chloe Farquhar speaking, I think that was present with the URUC Commission as it itself came from First Peoples Assembly's calls for the government to commit to the process. So I guess that answers it in that it came from the First Peoples Assembly itself. I guess to me reads as it did come from community as an idea brought forward, and then that early on from the process had that community engagement.
So that's really clear in the URUC process?
Yes.
You feel like that's, yeah, okay. And there was another thing that you were saying before that's just slipped my mind. You've already answered my questions about the arrest warrant stuff. And I suppose the comments that you've just made go to the point about why it's important to have a formal agreement. And maybe you can unpack that a bit more for me. Like why is that formal agreement really important before then proceeding with something like this?
It won't receive the truth if people don't trust it.
Yeah, and can you retrofit it? Like, can this pass the Parliament and then be retrofitted, or no?
It's ultimately a question for drafters, but I think if something like this could be kept broad and preliminary and then negotiated through either regulation or other instruments, that could be a possible way forward, with, I suppose, the desirable consequence that it would be refined later on through legislative instrument.
But sounds like there's risk to that.
Of course.
Yeah. Yeah. Okay. You kind of talked about a little bit about cultural safety. Why is that important in this process?
I'll let my colleague.
Of course.
Yeah.
It's essential that this process doesn't produce further harm as it hears the story of previous and current harm. It's also if the truth is told in a way that is not culturally relevant to us, then ultimately we haven't told the truth. It's not just about the facts that we lay on the table, it's how we tell it. And if we can't tell it in our own voices, if we can't tell it in our own ways, it's not going to be relevant to us at all. And I think, in effect, it would be a wasted exercise.
Yeah.
I support Ms Whittaker's comments.
I think you've kind of answered my questions about the kind of risks of it not being a bottom-up process. That's the thing that came to my mind earlier. You talked about the kind of the scope of a process like this being just the Commonwealth, things that are within the Commonwealth scope. In one of the other submissions that this committee has received, it talks about the need for it to be less rigid, because it then leaves, I suppose undesirably, like a fragmented story of truth telling. I suppose I wanted to get your comments on that. I suppose the kind of, if we're keeping it in its kind of compartments, what are the risks of doing just a national truth telling process here and a statewide one here and a local led one here? And like, yeah, I think I can see why we might want to go down that path, because it might suit the Commonwealth or the states to have something that's clearly in their jurisdiction. But I suppose I'm interested in the kind of experience on the ground. Like, how might people? What are the risks of doing that? I suppose is my question.
I think the risks are, as you've identified them, I think there's a risk of fragmented storytelling as different jurisdictions kind of see something as like, well, that's a Commonwealth problem, that's a New South Wales problem, as well as dealing with, and this is something as we were first looking at the bill that became apparent to us, is often the blur between government action and private action. For instance, it's hard for me to imagine having either a state or a Commonwealth-based truth-telling process that didn't also talk about gender-based and sexual violence. You know, perpetration is kind of split between the state and private individuals. It's an unenviable task, I guess, trying to figure out that scope, and that's one of the reasons that we've suggested kind of keeping it non-prescriptive until community can tell the Commonwealth exactly what it is they plan on saying. Yeah.
And then would you foresee being able to make findings that relate across all jurisdictions? Or, because I suppose my concern is that even on a kind of, like, I suppose we can see it because we're in the federal parliament, people don't necessarily know the difference between state, federal, local governments. And so they could be coming to, tell their truth about things that have happened at a very local level or a state level. And it would feel like, to me, that would be an injustice for them, the committee not to be able to make this commission not to be able to make a finding about that. Or what would be, I don't know, maybe there's a mechanism to do that. I think people already have a lot of mistrust in Royal Commission processes and not delivering the justice that people have expected. How do we protect against that? It's a big question, I know.
Yeah, no, it's
I
a
just
big question.
put it on you. I want to protect, mob who come and.
Chloe Farquhar's here speaking. I think going back to what we put around respect and also outcomes and actions, I guess another a way to possibly answer that question as well is what happens at the end and what happens after, as opposed to where it sits. And continuous consultation, yes, that's happened at Commonwealth and state level to date, but it's like, what's going to be the difference about this process because of outcomes, and what does that look like, and how does that present at the very least, but also tangibly what can be achieved, and if that's, I think, made clearly what the Commonwealth can do and speak to of the outcomes of this process, that may bridge that understanding or build more trust as well. But I think a key component to that is also outcomes.
Yeah.
This potentially may be a question for drafters, because I don't know necessarily what's possible in terms of division of power between states and the Commonwealth. I think
it's tricky, right?
it's so, and I think it is a completely unenviable task, as well as for finding ways for, I think other submissions have pointed to, in order to integrate and honour already existing locally driven non-government truth-telling processes that desire to be heard at a national level but have otherwise, I suppose, because they're grassroots, no governmental framework. Yeah, exactly, but deserve, I suppose, the national platform without wanting to unnecessarily replicate their work to be able to elevate it. My instinct is that it would require a lot of state-Commonwealth cooperation. It would also require state infrastructure to already exist for truth-telling, which, as we know, is not universal, is quite scattered, and would involve maybe some kind of agreement-making once that institutional structure is in place. But that is looking, I think, decades into the future, or hopefully not too long, maybe a decade into the future, maybe less, hopefully within our lifetimes. It's difficult. In truth, I don't know.
Yeah, okay.
Can I just ask one clarification?
Sorry.
When you're done.
Yeah.
And if I may, I've just got to make one more comment. I guess in terms of what could be achieved at that Commonwealth level, and what's happened in other inquiries, it also allows for an analysis to be in line with international law and looking at frameworks, and I guess where does Australia as a Commonwealth sit in our obligations to international law, and having that accountability to that as well, and UNDRIP and other mechanisms that cannot be applied to a state level, state and territory level. So I guess thinking of what's possible when you have it at a Commonwealth level invites different instruments to be involved as well.
Yeah. Okay. And you've got a clarifying question, then I've got one on notice. So.
That was actually my clarifying question.
Okay, great.
Is the example that you gave around the Canadian experience of Truth and Reconciliations Commission, the C-15 bill was the precursor to that, and the Missing and Murdered Inquiry or Commission, which meant that there was a lot of political will to get this done and to hear people's truths, because it's one thing for us to tell our truths, but the other for it to be heard and listened to, and that justice is a Western construct which doesn't fit with mob. But my clarifying question was, when there's no UNDRIP, when there is no commitment to actually hearing First Nations voices, is this process completely going to fail because of the outcomes that you mentioned? Because no one's actually going to hear that.
I think your question might speak for itself, to be honest. I don't know how best to answer that in terms of, I think there's a lot in your question, as is, so.
But no
yes.
UNDRIP,
No.
no bill to enshrine UNDRIP, which means we have no international mechanism to hold anybody to account. Previous Royal Commission on Deaths in Custody, which National Justice Project are dealing with cases time after time after time around deaths in custody. Bring them home report, recommendations, even late as last week, we're still having this conversation, and yet the Commonwealth put billions of dollars into closing the gap. Successive governments. And representatives have no will to change the dynamic, to hear the truth from grassroots communities. So what is the international mechanism now when there's failure for political will to give us a platform to do that?
Yeah, thank you, Senator Cox. I guess how the National Justice Project does our work, as you've already alluded to, sometimes it doesn't always work that we use instruments here in Australia, and we have gone to the UN and made UN complaints because of this reason, because of that lack of political will. So that's evident in our work, and I guess it's then evident in policy and the way government decision making has been previously. So I completely hear your point.
And just one question on notice, because we definitely have run out of time now. I suppose my kind of therapeutic mind is thinking about what the aftercare looks like. So keen to get from you, what that might look like in a process undertaken, from a commission, based on what you've seen happen on the ground here and also international examples. Be greatly appreciated. Thank you very much for your attendance here today. If you have been asked to provide any additional information, which you have, would you please forward it to the Secretariat by the 5th of March? You'll be sent a copy of the transcript of your evidence and will have an opportunity to request corrections to any transcription errors. Thank you very much.
Thank you very much.
Thank you so much, Vinnie.
Might just pause the Hansard for a couple of minutes until our next witness comes. All right, we will resume. I now welcome our next representative to give evidence today. For the Hansard record, would you please state your full name and the capacity in which you appear before the committee?
Anne Dennis, I'm an elected councillor with the New South Wales Aboriginal Land Council, so I'm one of 9 elected councillors across New South Wales, and I'm the councillor for the North West. So living out at Walgett, North West New South Wales, the communities, there's 16 communities across the region that I represent, from Ngonia down Burke, Brewarrina, up to Toomala, Boggabilla, Mungandai, round through Moree, Barradine, Canamble, and everything in between.
It's a big patch. I've got a little spiel I need to get through before we invite you to make an opening statement. Although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. Since you're here on your own, you don't need to say your name before responding to each question. But I'll invite you now to make a brief opening statement.
First of all, I'd like to acknowledge country and pay my respects to the Gadigal people of the Eora Nation. I'm a Kamilaroi woman, born on Namoy Aboriginal Reserve, one of 2 reserves in Walgett, and 1965 moved to Dewhurst Reserve in the township of Walgett. Yesterday we actually commemorated 60 years of the Freedom Rides out at Walgett, and it was an amazing celebration, I suppose, particularly when the Freedom Rides exposed that social and human injustices, the issues around housing and education, racism and discrimination back in 1965. The New South Wales Aboriginal Land Council is a peak advisory group. We're under legislation, so since an Act of Parliament since 1983. As I said, there's 9 regions across New South Wales. There's 121 local Aboriginal land councils with 30,000 members representing local Aboriginal land councils. The New South Wales Aboriginal Land Rights Network is a vehicle for delivering the goals around tangible social, cultural, economic outcomes for Aboriginal people. Each land council is autonomous, which has a membership base, which elect their board, which employs their CEO. The New South Wales Aboriginal Land Council, we're not government funded. We have a statute fund which we really have to live off the interest and support the network of 121 land councils and all Aboriginal people across New South Wales. Really, I suppose as Newswalk, we've worked within local legislation, state legislation, also Commonwealth legislation around, and supported in total the Uluru Statement from the Heart around voice, treaty and truth, and Makarrata in people coming together after a struggle. The Aboriginal Land Council and the First People of land, we hold undeniable and unbroken connections to country. As I said, I was born on Namoy Aboriginal Reserve. My grandfather was born in 1905. My father, still living, born in 1940, and those connections are so strong. New South Wales has provided, recommendations and a submission around the Truth and Justice Commission bill. Newswalk recommendations are not isolated. They are strongly echoed across the submissions today and in the hearings in Victoria and Perth. And our recommendations include that the Commission must reflect the intent of the Uluru Statement from the Heart. The appointment of commissioners must be Indigenous-led, and long-term guaranteed funding for the Commission is, really, non-negotiable around that. We outlined 4 recommendations in our submission. I won't go through them. And really, I suppose, as Newswalk, we want to see real, lasting action. We do not accept the symbolic gestures or empty promises. The Truth and Justice Commission is an essential part of this journey, and it must be established with Aboriginal leadership and adequate resourcing. Truth-telling is not just about the past, it's about the justices today and sovereignty into the future through truth-telling and lasting impacts of Australia colonial history, and the injustices faced by Aboriginal and Torres Strait Islander peoples can be uncovered in full, setting the foundation for healing, sovereignty and self-determination.
Thank you very much for that. We'll proceed to questions and go to Senator Little.
Thank you, Councillor Dennis. I wanted to ask you, this committee has been established because of a bill that was presented, and that bill is seeking to establish the Commission to make recommendations to Parliament on particular matters relating to historic and ongoing justice matters. We're hearing slightly different things as part of this process about what the actual action and outcome of this would be. I just want to understand from your perspective, and I understand you have many hats here. You're a councillor with New South Wales Aboriginal Land Council, and you're an Aboriginal woman. I just want to understand what is the risk here of this trying to do too much and disappointing so many people?
Really, I suppose the risk that we have is the complexities around government and the government of the day actually trying to implement processes through either a legislation or a program or funding. And really, if we look at the heart of what we as Aboriginal people need and what we want, is the action around how we actually address the social issues, so adequate housing, really around employment, education, and how we actually contribute in our communities to be able to live a safe and successful life. And really our children are our future, so how do we actually nurture and work through that at a state level? Because like here we're talking about Commonwealth, and under the jurisdiction, we, like in the state of New South Wales, we also work under state legislation, and then we also work under local legislation, and the Aboriginal Land Rights Act is very much like a vehicle that really was established in 1983, and native title coming in 1993, and activating land for, because really under the land rights legislation we're able to claim and acquire unused, unneeded Crown land for economic purposes, social purposes, cultural purposes and spiritual purposes. And so really Commonwealth legislation should not be, it should actually be a vehicle that empowers each jurisdiction and each state to be able to work to deliver on the outcomes. It shouldn't actually contradict and be like a barrier or a restricting tool around it, because to try to activate Aboriginal land, it could take, like, you know, we've got something like 40,000 land claims that's backlogged in the New South Wales Parliament to you know, that we've had under claim, and the first land claim in 1983 at Brewarrina still hasn't been addressed. And then, you know, like, and when we look at how communities evolve, like, I used to do cotton chipping as a young person to, you know, subsidise our economy. Like, cotton chipping is no longer available in our communities. Our communities at a local and regional and remote level, they're getting smaller and smaller, and Aboriginal people are moving to larger communities for, you know, betterment so that their kids can access education. So, you know, like, we should be able to live a quality of life in our community and get an education, have adequate housing, water, and protect and promote the cultural interest. And we've lived with development all our lives, you know. So really now it's about how do we get on and address the many issues that we actually see and that we actually live with in our communities.
Just go back to the bill that we're looking at. It is actually about making recommendations to Parliament on particular matters. Do you see this as being permanent, or do you see this as having a task and then it's dissolved?
I think the principles would be permanent. It's the processes and strategies at a local level that really will change over time in how local people address their needs and basic requirements. So to me, the bill will be permanent. Like, you know, I think the Aboriginal Land Rights Act is permanent, but how do we actually do what we say we do? Because one of the biggest disappointment, I suppose, and also a shock, was that the parliamentarians don't even understand a bill through the New South Wales Parliament under the Aboriginal Land Rights Act. A lot of people haven't even heard of it, and yet we're an Act of Parliament. So here's a bill that's actually going to look at truth-telling and how people, Aboriginal people, how we actually look at how we look at, you know, collecting that, but really it's also about how government agencies really work to tell the truth about how they are delivering and what they're actually doing in our communities, because, you know, it's place-based. So when government comes into our communities, really, you know, like through Commonwealth, state and local, it should actually be addressing the needs of what we need to deliver.
You talked before about the role of the Land Council here in New South Wales, and we've seen an example very recently of a dispute between the Orange local Aboriginal Land Council and an Aboriginal corporation with intervention from the Minister. How do you actually ensure that organisations that should be making representations are at the forefront of making representation at a commission, as opposed to others that might not be seen as valid? How do you make sure that happens, and how do you make sure that organisations don't essentially control the narrative and ensuring that there is a place for alternate views about issues within something like an established commission? Really,
Again, you know, like we've actually worked and lived under legislation, whether it's local government, whether it's state government or Commonwealth government, and the Aboriginal Land Rights Act you know, like, and the local boundary of a local Aboriginal land council, you know, there's that clear and defined definition that we are to protect and promote cultural sites. And when we look at New South Wales, you know, like we for 20, 30 years and even longer, we've cried out for the protection, standalone legislation for the protection of culture and heritage. We've asked for this. At the moment, it's embedded in the National Parks and Wildlife Act, and you know, there's a small component in the Aboriginal Land Rights Act that we you know, that within the local boundary that we can actually protect and promote. And really, it's about communication and the transparency and people working together to be able to come to you know, a decision around how we actually move forward. That's, you know, but when one party or another, and usually, you know, like they'll pit Aboriginal organisation, land councils off against each other, really, you know, like it's about how we actually protect and promote what's left, because there's not much left. And when we look at Australia in itself, there's 250 nations of Aboriginal people, you know, 800 Aboriginal languages and dialects. Which one is more important than the other? Because, you know, like, and this is why place-based arrangements and working with local people to be able to work through that, and the situation that's in Orange, I'm sure they'll actually work through that process, but we've got to respect the mechanisms that has been established, and as I say, they'll also work through the native title. Because, you know, like the Land Rights Act was amended with Section 42D around that, you know, we can't activate land even for housing needs unless we actually work through the native title process, which then goes through the court, and the court's got to give a determination. So it can take 40, 50 years for Aboriginal land councils to actually be able to activate.
Thank you. I'm just conscious of time. We've got a number of other people who want to ask some questions. Thanks so much, Senator Little. I'll go to the Deputy Chair.
Thanks very much, Chair, and thanks to Ms Dennis for appearing today, and thanks to the New South Wales Aboriginal Land Council. Obviously, the design of the Commission is very important to ensure success. So I note that the submission recommends that clause 7, open brackets 1, that the Commissioner's appointment should be led and agreed by Aboriginal and Torres Strait Islander peoples and their representative structures. I just wonder, Ms Dennis, what are your thoughts on how that might work practically in terms of the role of the peak bodies in particular?
Really, I suppose at that Commonwealth level, you know, like, you know, a recommendation, I suppose, around the person who actually leads and be able to work through those processes. It's critical in the sense that they're aware of historical issues, legislation, and be across, you know, many different jurisdictions. Because when we're looking at the Commonwealth level, then we've got state and jurisdiction at different levels. Like, you know, some like when we look at New South Wales, we've had established organisations in New South Wales for over 50 years. When we look at the Aboriginal Medical Services, when we look at the Aboriginal Legal Services, when we look at New South Wales Aboriginal Land Council, we look at the Aboriginal Education Consultative Group, we look at the organisations, and these organisations were established in response to the needs of Aboriginal people. So again, you know, like at varying different levels, and then the layer that we've got around Close the Gap. And so, you know, like the Coalition of Aboriginal Peaks. So Aboriginal peak organisations, and there's 9 representatives. at the moment make up the coalition of Aboriginal peaks in New South Wales, and we've got a national coalition of peaks. You know, and when we look at other states and territories, they haven't got those organisations. You know, that there are established organisations, but really, I suppose the structures that we've worked so hard for in New South Wales, you know, Commonwealth legislature. This process shouldn't actually undermine the structures that we've actually got in place. It should allow us to work better to really put in place those programs to address, you know, the many social needs and to be able to address all the issues that we've got. But when we look at, you know, a comment like, you know, it's got to be local decision-making model. You know, like what we get the New South Wales government, we get government agencies then put in place a strategy like OCA to set up LDMs. So they'll set up another layer of, you know, all right, it's got to be local decision making, so not look at the structures that we've already got. Let's set up another process of community working parties, of regional alliance, of Encara. So it's layer after layer of how we actually work together. So really, you know, the commission, the Truth-Telling Commission, someone that actually leads that needs to be able to provide that advice down through the jurisdictions to be able to strengthen what the various jurisdictions have put in place so that we actually start to get to the point of what we need to address within our communities. And we've got these structures. As I said, we've worked through this for a very long time.
So my question really was around the appointment of the commissioners, which is, you know, the bill doesn't suggest a role for peak bodies. So I guess I'm trying to understand, just from a practical perspective, would we choose a selection of peak bodies to like form another committee for the appointment of commissioners? I'm just trying to get, you know, your views on how that might work.
Really, we've just, and there's 3 treaty commissioners in New South Wales. Again, like as I say, if there is a person appointed at a national level, they've got to be able to work through those processes so that we can actually that we're working on the ground, place-based arrangements, working up through to be able to ensure that we can. It's not another barrier that's going to be put up. So really, I suppose what I'm saying is government need to be clear about the processes and how they're going to work across the various jurisdictions, so that local people, Aboriginal people, can contribute and we actually see the impact of that truth-telling and how we work through that in community. But government's not clear to me about, you know, when they implement something, because voice treaty truth, coming from the Uluru Statement from the Heart, obviously the voice was you know, thrown out because we didn't get that recognition in the Constitution. So now, like, we're looking at treaty and truth-telling, and government need to be clear about those processes and how how we can work through that. And that's the missing link in that sense, that government's not clear about how they're going to address that, because they'll say that our issues are too complex.
Okay. All right. Thank you very much. Thanks, Anne. Thanks, Chair.
Thank you. I think you've kind of talked a little bit about this in some of the responses to the questions that you've asked, but I suppose I'm keen to understand, you know, what might be, the New South Wales mob's expectations about engagement on a bill as significant as this? Like, what would you like to have? Like, what would you like to see happen in terms of engagement and consultation and co-design?
Really, I suppose the consultations, like we are continuously consulted, and really, I suppose, community, we'd like to see action in how we actually move forward. As I say, 250 nations, the different dialects, and the principles around self-determination, autonomous, and that we actually contribute and we protect culture and heritage, that, really identity and language is connected to our land, our country, where we're born, and government policies over many years, whether it's a stolen generation, government policies have moved us around, whether it's through the judicial, through jails, Aboriginal people have been locked up, removed from country, so set up in other areas. And
so sorry to interrupt, but how do you think people should be engaged in designing something like a Truth and Justice Commission? Kind of going to your point that people are moved around, people often consulted on lots of different things. Like a Truth and Justice Commission is a pretty significant thing for our mob. So how would you want to be engaged in that process?
So around setting up the principles around that.
Yeah.
Because then strategies, strategies and programs will change according to where people actually live and what is actually needed at a local level. But the principles around, what the Truth and Justice Commission will actually establish will be critical. Because again, identity. There needs to be a process around, do you have Aboriginal heritage, or are you an Aboriginal person? Because when we look at the penal colony or the colonial impact, that men from jails come on a boat, no women. There's a lot of people in Australia who's got Aboriginal heritage, and we don't deny that. But being an Aboriginal person and put on a mission and coming under that, we weren't allowed to speak our language, and that discrimination and that racism, and really there are no benefits to being black. There are no benefits to being an Aboriginal person. Everything, we come under every law in Australia, and we are means tested. But there's this perception that we get everything for nothing, that we get a house, we get a job, all of this. And these are not things that we actually inflict on people. So really, I think that's got to be clear about, is there Aboriginal heritage and Aboriginality? And
I might give you some questions on notice. I need to share the call in a second. So I'm going to, on notice, give you a question around why it's important to have cemented in legislation, I suppose, a commitment to engage in community-controlled organisations. And I'm also keen to understand from the Land Council's perspective what cultural safety would look like for you. But I suppose the question that I want to ask you now, so I've given you two questions on notice. The question I want to ask you now just is kind of building on what you've just spoken about, which is, I suppose, the education component of this and breaking down lots of those misconceptions about who we are and how we contribute to our economy and the nation. How important is education to a national truth-telling process?
Education is the key. Really, And, you know, like, because it's so intricate around, you know, like, you know, if there's inadequate housing, then that will impact on education. You know, if there's inadequate employment and social benefits, and then we've got all the social issues around alcohol and drugs and things like that, that will impact on education. But education is the key. And, you know, like, again, you know, like, we've got a, you know, truth-telling around, I suppose, the Department of Education and the responsibility around, you know, like, the teaching and you know, what is actually taught around, you know, being an Aboriginal person.
Yep.
You know, so again, you know, like, and it's that stereotype that we are all the same. And, you know, like, when we look at the different nation, the different languages, and you know, like, and you know, because, you know, because I'm also the Vice President of the New South Wales Aboriginal Education Consultative Group, and very active at the local level. Really, you know, like, what we look at with culture and language is around it. When our kids are engaged in culture and language, it increases attendance, it increases participation, and it increases engagement. But when we come from a history where my grandfather, my father and that, we weren't allowed to speak language, and, you know, and like, you know, we don't belong, and even the comments and the stereotypes today, people don't want to identify as an Aboriginal person. So I think it's important that education is the key. And again, you know, like, the Department of Education in all jurisdictions really need to be clear about you know, like, how they, you know, provide a scope and sequence, I suppose, around how local people can actually engage with. And it doesn't matter. Like, when I was a teacher at Redfern Primary School, I taught Pitjantjatjara language back in the 90s because it was important that you know, cultural aspect around, you know, hearing that language, and kids were singing of all different nationalities, singing in language at that time. So it's critical, and community will come to an agreement around that because they want to see their kids engaged, they want to see their kids participate.
Thank you. I'll share the call. Senator.
Thank you, Councillor Dennis, for appearing today. I just want to draw you back to the submission, and in your submission you stated that the principles of the Uluru Statement from the Heart needed to be expressed through this bill. What do you think needs to change in the bill, essentially, to ensure that that's reflected?
Like, I haven't read the bill, so I'll have to take that on notice.
Yeah, that's fine.
But working through the Culture and Heritage Bill and the principles around, you know, that autonomy, about self-determination, about place-based arrangements, it's critical that, you know, we have a bill that provides a guidance, because, like, we've known nothing other than working through the laws of the land. So, you know, we're quite resilient, we're quite adaptable, and, you know, like, we work through that. But when the goalposts shift, and, you know, we've got government agencies that don't work and uphold what the bill actually says, it actually leads to that mistrust. And, you know, like, you know, our communities will say, oh, they're coming talking to us again. Nothing changes. You know, I've got communities where, you know, like Collarendobrine, northwest New South Wales, they're at the back door of Walgett and they're at the back door of Moree, and nothing happens in that, because government will come into Walgett, they'll come into Burke, they'll come into Moree, you know, and you know, like it's a band-aid approach of, you know, they seem to think that funding will actually, and it's not about the funding that comes into our community, it's about how we actually work together with the funding that's there now to achieve the outcomes. And, you know, like we look at, you know, working with state government, we do that through the Coalition of Aboriginal Peaks. You know, like what I see as the Commonwealth to be able to then provide that leadership, I suppose, around how the states or the jurisdictions are achieving the outcomes, what each of the bills, you know, and this bill would actually provide, or what are we trying to achieve with it? And I think that's important.
Great, thank you. Also in your submission, you talked about amending Clause 35 to make provisions for long-term funding for the Commission. How long do you think the Commission should be funded for?
Really, without adequate resources, you know, like you wouldn't be able to achieve, you know, what you need to think. So the life of the Commission, the life of the bill, is critical around the adequate resourcing, and that's something that you're going to have to work through once you've got the idea of what that Commission would actually look like. It would need to be adequately resourced to be able to. But, you know, more importantly, I think, you know, when we look at, you know, like the Commonwealth, like the resources we'll need for, you know, the staff, the people in there to be able to work with the jurisdictions so that we're actually working on the ground to be able to achieve what we need to. And, you know, like we know, particularly around the Aboriginal Land Rights Act, like we've got a statute fund, which we're not allowed to spend. We've got to live off the interest. And let me tell you, since COVID, the interest has been quite poor. But our investments do better than government investments, yet it's still not enough to be able to address, you know, the social conditions around water and sewage, around roads, around infrastructure that we actually need. We've got to go cap in hand to government agencies, and when government actually set up other alternative mechanisms to fund communities, like it just makes it quite difficult. And, you know, it's that band-aid approach around what's being delivered in our communities, and we're at the whim of government. So, you know, like, you know, Commonwealth 3 years, state 4 years, government changes, and we're back, and it's another program and it's another policy. So again, how does government actually put in place a structure that's going to go across, you know, decades really, to address the, you know, those issues?
Thank you. And I suppose that the Commonwealth has constitutional responsibility for all Aboriginal and Torres Strait Islander people in the country, and it is their responsibility to provide that national leadership, which is why this bill is about a federal truth-telling and Truth and Justice Commission. Given that part of this, and I think Senator Little's very first question she asked you when you sat down was around the representations, and I appreciate that you're in the state legislation quite a bit, and that there has been a lot of shifting sand in relation to truth and treaty at a state and territory level, and we've seen the erosion of that because of the change of government, as you just said. If there was a federal Truth and Justice Commission that could formally record all of the history to protect and preserve what is cultural heritage, native title, the big pieces of legislation that sit at the Commonwealth level versus how they trickle into the states, would you agree that it is beyond time now that we actually do that, so that we don't have to keep consulting with our communities, that it's just there and that we continue to refer to it, and that we don't get a change of politicians and change of governments who will continually contradict that information and say things like, this didn't happen in history, this wasn't the way things happened, and that there were, in fact, good things that came from that when we are still living in the third world conditions that we are as Aboriginal people in this country.
So just a comment, I suppose. I understand that it's constitutional. I suppose I'm confused that with the recognition and the voice not being passed, are we actually recognised in the Constitution? And we're at the whim of government what they actually want to put in there because the Constitution didn't change. So and then if people are actually elected to the commission, now we've already been down the road with ATSIC, and people were elected. That's where the definition of being an Aboriginal person, that you are of Aboriginal descent, you identify in the community and you're recognised in the community, ATSIC was abolished. And that legislation, that three-part criteria that Commonwealth actually introduced there was when ATSIC was abolished, was actually thrown out. So again, the processes, and look, there's a lot of other smarter people out there than me. There's a lot of lawyers and things like that. I think we can actually work through the process of how we actually set up a truth-telling commission. But the government's got to be clear about, the parameters, the boundaries, and what this commission will do, and how you're going to do it. And then how you're going to work with the states, or how the state's going to work up through, or the jurisdiction's going to work up through, to be able to get the credibility and we start to get the traction on the ground. Because, I heard earlier where you talked about the black deaths in custody, the recommendations, the bringing them home report. A recommendation is just that, a recommendation that doesn't have to be enacted by government. And we're sitting on the ground talking about, don't like turning the telly on at the moment, because, everything that's happening, it's just, why would you want to be an Aboriginal person? So I think those processes, I think it's great, and we will work through this, and we'll work with the Commonwealth, and we'll work with the states, and we'll work with local government. But you need to be clear about the expectation, and you shouldn't expect us as Aboriginal people to solve the issues that government has placed on us all our lives.
Yep.
Thank
Great,
you.
thank you. Thank you.
Unfortunately, all we've got time for in terms of questions this morning, but I want to say a big thank you for your attendance here this morning. If you've been asked to provide any additional information, which you have,
Yep.
Would you please forward it to the Secretary by the 5th of March?
Will you send a notice for that?
Yeah, the Secretary does, yeah.
Thank you.
And you'll be sent a copy of the transcript of your evidence here today, and you'll have a chance to request any corrections to any errors that you see in that evidence.
All right then. Thank you.
Thank
Thanks a
you
lot.
so much. Thank you. We've got our next witnesses online. Just going to do a quick sound check. Do we have Professor Gabrielle Appleby and Professor Megan Davis?
Yes, this is Professor Gabrielle Appleby online.
Professor Davis?
Professor Davis is calling in from Boston in the US. She just might be having some trouble getting through, I think.
That's right. We might take a short suspension while we sort out the technical issues.
Perfect. Many thanks.
Right, Professor Davis, is that you joining us?
Sorry, yes, it is.
Oh, excellent. Excellent. All right. I now welcome our next witnesses to give evidence today. For the Hansard record, would you please state your full name and the capacity in which you appear before the committee? I might start with you first, Professor Davis.
My name is Professor Megan Davis, and I'm appearing as a Professor of Law at the University of New South Wales.
Thank you. Professor Appleby.
My name is. My name is Professor Gabrielle Appleby, and I'm a professorial research fellow at the Pro Vice Chancellor Society, UNSW.
Excellent, thank you. Although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. To assist with the transcription of the public hearing, it would be appreciated if you could please state your name before responding to each question. And before I invite you to make an opening statement, I'll just let you know who's in the room. So you've got the Chair, Senator Jana Stewart, you've got Senator Dorinda Cox, Senator Karen Little, and also joining us on the phone is the Deputy Chair, Ms Melissa Price. I'll now invite you to make a short opening statement.
Thank you, Chair and the committee, for the opportunity to present. I'm going to start and hand it very quickly to Gabrielle. We wanted to begin by reiterating that the submission that we made and our comments today are informed by the work that we did with more than 1,200 First Nations delegates at the First Nations Regional Dialogues and the National Constitutional Convention across 2016 and 2017 that delivered the Uluru Statement from the Hearth. The statement called for structural reform, voice and Makarrata through treaty and truth. In relation to this, we note that a number of the submissions to the inquiry on the bill have prefaced their support on the basis of the call for truth-telling in the Uluru Statement. For that reason, we think it's really important in understanding the nature of the call for truth in the dialogues, which isn't well understood. So we draw the committee's attention to two preliminary matters in relation to the importance and nature of the call for truth in the Uluru Statement. I'll talk to the first and then hand it to Gabrielle. The call for truth emerged independently and locally from each of the dialogues. A formal government-led truth-telling commission or institution was not an option on the table that was put to the delegates. Rather, during the opening plenary discussions, which were premised on the question, what does meaningful recognition look like to you in your region, each location, independent of each other, raised the issue of Australian history. And I should make the point here that none of the dialogues knew what any of the other dialogues had said. So the first time they heard about what people had spoken about was at the National Constitutional Convention. So all of the dialogues separately queried why Australians had sought recognition of them in the Constitution when so few knew about Aboriginal history and the place of Aboriginal people in Australia. The plenary in the structured dialogues had to be extended in time because of the amount of commentary on history. Delegates spoke out on their own local histories, and they spoke also about initiatives in their own regions where local communities were working with local First Nations people on this history, recognising this history. There's very organic activities around Australian history and truth-telling. The language of history and Australian history and Aboriginal history was used just as much as truth-telling. Each location spoke about the need for a genuine local truth-telling process that would lead to a change in the understandings and relationships between First Nations and Australians. And, and that emerged locally in each region as a priority. As we have written elsewhere, Professor Appleby and I, delegates desired for local truth-telling to be eventually shared with Australians, if they so choose, via a national mechanism that would allow communities to elevate those stories, those local stories, to the national audience and to the Australian people. There was a view that this process of history telling or truth telling could be overseen, but not necessarily conducted by an institution. A commission's role would take a centralised role, such as providing resources and institutional support to local truth-telling initiatives, while also importantly providing a national repository or record of the more diverse and contested history of Australia, and an organisational point for future use of that record, such as informing national and state policy and future educational curricula, especially history. In these senses, the call for a Makarrata Commission and truth-telling was an example of a self-determined reform tailored for the particular issues confronting First Nations communities across Australia. Post-dialogues have kind of been reshaped into a conventional transitional justice model and system, and in some ways, in our view, downplayed or negated the bottom-up vision of Australian history or truth-telling. Nevertheless, it was the view of the dialogues that work being done now organically on the ground would be fed up into a national institution, and those histories would be utilised for the purposes that were advocated for in relation to the Makarrata Commission. Gabrielle, I'll hand it to you.
Great, thank you, Megan. So the second point that we wanted to draw the committee's attention to is that this call for history or truth-telling was prioritised at the national meeting, the First Nations Constitutional Convention at Uluru in 2017, where all the regional dialogues fed in, where for the first time in Australian history, Aboriginal and Torres Strait Islander people were invited to participate in constitution building. The Constitutional Convention was guided by a set of 10 principles that the delegates all agreed to. Importantly, one of those principles, number 5, is that any reform must tell the truth of history. But also those principles included, principle number 1, does not diminish Aboriginal sovereignty and Torres Strait Islander sovereignty. Principle number 2, that any reform must involve substantive structural change. Principle number 3, any reform must advance self-determination and the standards established under the UN Declaration on the Rights of Indigenous Peoples, or under it. Principle number 7, that reforms don't waste any opportunities of reform. And then principle number 9, that reforms must have the support of First Nations. The reason I draw the committee's attention to those guiding principles is I think that they reinforce that any truth-telling model that is designed needs to be taken back and assessed against these principles. And it needs to be ensured that the design of a truth-telling model or commission must be led, must be supported by First Nations, and it must be connected to meaningful structural reform for Aboriginal and Torres Strait Islander people. So having given that introduction, we did want to note in the opening statement that we do support the introduction of the Truth and Justice Commission Bill. But in light of this emphasis in the dialogues of truth-telling being locally led and locking in for future structural reforms, we've made a number of suggestions for the model that's proposed in the bill. I'm not going to run through those suggestions in detail, but just in brief, I'll just list them out. First of all, they include that representatives or members on the Commission must have legitimacy and authority within the First Nations communities across Australia. And we've noted a few shortfalls with respect to this in the bill. Firstly, there's no anticipated separate representation of Torres Strait Islanders. Secondly, there's no explicit consultation requirement with First Peoples for the government appointments. And thirdly, there is no First Nations appointment. All appointments are made by government. So the second point is that we think that the terms of reference in the bill are both unnecessarily but also unhelpfully limited to what's termed injustices in the bill, as well as limited to matters that are perpetrated by the Commonwealth Government, its bodies and non-government bodies. We are really worried about these limitations. We think that they are going to create legal contests over jurisdiction for any commission, but also we think that they're going to be very unhelpful. They may limit, fragment what is needed to be a holistic and contextualised truth-telling in any particular region, which will involve Commonwealth, colonial, state, territory, local government issues. The third concern we have in the bill is the requirement for the Commission to report on what's referred to as findings of fact and make recommendations. And we are concerned about this. We think it's a commission, as was conceived in the dialogues, really had this role in providing a record for contestation over what might have been seen as facts, and that a commission's role is more about providing a repository and a record of contested versions of history, denials of some of those versions historically, and reasons why those versions might have been denied, and importantly, how that has affected different groups and individuals, and what to do from here. The next point
can I just interrupt for a second? I'm just conscious of the fact that we've probably got about 30 minutes left with you and 4 members of the committee who want to dive into some questions with you. Is it okay if I get you to pause your opening statement there and we proceed to questions?
Sure, very, very happy to. The other points to make are obviously in the written submission as well. Yeah.
Thank you very much. Appreciate that. We'll proceed to questions and go to the Deputy Chair, Ms Price.
Thank you, Chair, and thanks to Professor Davis and Professor Appleby for being with us today, and thanks very much for your excellent submission. Very important contribution from both of you. In your submission, there's a discussion around, once the truth has been told, the importance of the storage of the evidence is obviously going to be very important. So can you give us some further views on how the Commission should collect, manage, store, and what the use of the material evidence that's gathered, and how this connects to or can ensure data sovereignty?
Yes, absolutely. Thank you, Deputy Chair. I will make some comments, and of course Professor Davis can add. In the submission, we make the point that the bill currently has no provision for custody of material, as you referred to, like being a repository of this material. But the regional dialogues really emphasise the importance of a national repository, an ongoing role, and that ensures that that these truth-telling exercises are not lost to history. So often inquiries have been lost to history, but it also ensures, if it's designed properly, what you refer to as data sovereignty, that the First Nations people who are involved in the truth-telling exercise should have control over what happens to their material. And so there should be an appropriate process of permissions about how the data can be used into the future. Now, that's an ongoing role. That's not time limited. One of the concerns that we have with the bill is a 4-year commission that reports and recommends and then it's finished, whereas the concept of makarata, a change in relationship, a new relationship, and it's an ongoing role to continue to see what happens, to continue to oversee what happens with this data and make sure that First Nations are in control of it.
Mm. Okay. Professor Davis, do you have something else to add to that?
Not really. I mean, I've been involved in a lot of the data sovereignty work since it was adopted in Australia in an academic sense, and has obviously been taken up by the public service and other institutions. There's obviously, I was involved with the framework for governance of Indigenous data that was developed through the APS, and when you look to, commissions of inquiry like York, many of these institutions are adopting various protocols and frameworks around data sovereignty. I mean, I think in the setup it will be central to the discussion. If I can give you an example in the dialogue, one thing that emerged was a concern across the country about the collating of massacre sites by non-Indigenous scholars and the identifying of those sites on a map and photos being taken of sites. And that's one example or a tactile example of the kinds of things in relation to Australian history or truth-telling that will emerge. And part of the bottom-up kind of sentiment I picked up in those discussions was that people wanted to have the ability to decide what goes up the line and what doesn't, and have that flexibility and choice. So what that looks like on the ground as opposed to an institutional framework such as the Australian Federal Public Service or Victoria, I'm not sure. I know there's a lot of activity across the country in relation to this at PBC levels, organisational levels. So obviously it'll be a really central aspect of the Commission's work.
Okay, all right. Thank you very much. Thanks, Chair.
Thank you. Senator Stewart here. I'm keen to understand what feedback you received from delegates on locally led and bottom-up truth-telling approaches.
Sorry, Senator Stewart, you mean feedback from the actual dialogue process?
Yeah. What was it that you heard from delegates about the importance of it being, bottom up?
Yeah, so I mean, I think one thing to keep in mind is that it wasn't a truth-telling transitional justice type institution wasn't kind of put on the table and presented to the people, and people spoke about that. The issue of truth-telling and Australian history, as I said in my opening statement, really dominated the opening session. Yeah. So, I mean, that 12-year history of constitutional recognition in Australia, it was the federal government and both, bipartisanship that brought constitutional recognition to Aboriginal people. They put it on the table, and the processes that worked towards that was ascertaining from our people what that form of recognition was. So when we went into the dialogues, the first step or hurdle before we could talk about constitutional measures was this lament that Australians didn't know anything about Aboriginal history. And then people would talk about the kinds of historical work that is done, in their local areas. For example, native title is a really good example of the way in which people have been working through their local histories. In addition to that, they talked about working with local historical societies and local libraries and local governments on all different iterations of history. Some of it might be families of, or the descendants of families who massacred Aboriginal communities who wanted to make amends. So there's a lot of those kinds of healing ceremonies that happen, a lot of things that happen in that period that people, non-Indigenous people, want to talk to and heal with First Nations people from. And so I guess what we found in those conversations was people were already kind of doing things like this, unresourced, and so their kind of vision, the way they spoke about truth-telling, was something that was very much bottom-up. Once what we did left the kind of dialogue space and went into the Uluru Statement, went out into the public and there was several inquiries into it. I think at that point, academics who specialise in transitional justice and other theories internationally around these kinds of institutions positioned it as primarily a commission of inquiry or a royal commission or some sort of institution like South Africa, which would lead that discussion. I think one of the things Gabrielle and I have been trying to say for 7 years, I think, is that's not necessarily the way in which communities spoke about history. It doesn't diminish the need for a national institution. It's just talking to some of the granular, nuanced ways that people spoke about history. And it's no surprise to anyone that non-Indigenous, Indigenous communities alike want to have some control over the way in which their stories are told and what elements of those stories are told. And I think that was at the substance of the bottom-up approach. Gabrielle, did you want to add to that?
Yeah, look, I'd just say one of the things I was struck by so many dialogues is that delegates spoke about really local issues. They might talk about local figures or local statues or local ceremonies that might take place, and the concern they had that people in their local community didn't know the history, didn't know the truth in relation to what happened locally, and the need for their kids locally to be better informed. And so whilst there was a sense that this was about a national reform agenda, as I said, it was about a constitutional recognition and structural reform agenda, it was very much a conversation about how within their community they were concerned about the lack of knowledge. So it's about truth-telling about local issues, but truth-telling to local communities as well was what I was struck by in relation to what people were asking for.
Yeah, I definitely want to ask some more. Like, maybe it's a question on notice about how you how you kind of bring together those really kind of local, truth-telling, sharing of history in very local circumstances, and how that might translate to a national process, and what expectations might be from a national process. I'm just conscious of time, and I.
Could I quickly? Sorry, Senator. Could I add to that? Or not enough time?
There's probably, if you can take it on notice, just because I don't have enough time. I've probably got one more question that I've got to ask before I've got to share the call. So apologies for the short time. I'm particularly interested in your comments in your submission about sequencing, and you talked about, I suppose, the careful kind of sequencing of the Uluru Statement from the Heart, and you, in your words, you talk about the danger that confronts Australia is the temptation that in the face of the referendum loss that we kind of go down this truth-telling path. I suppose I'm keen to understand, in the absence of the constitutional change, what your views are on what's possible in a kind of careful and considered way, or what are the risks and what are the considerations we might need to take in pursuing something like this?
Yeah, it's a good question. I mean, I think constitutional voice is one thing, but the referendum, losing that doesn't diminish the need for some kind of representative political entity, which the Australian country, like the nation, has had since 1967, right? As a consequence of that particular referendum, every federal government has required a representative entity that can give it advice on policies and laws. And so we don't have that national entity, and that I guess that's a risk for truth-telling in relation to the faith and trust that First Nations communities have in a process when they're not sure that the people at the table are representative of communities in a kind of, as I think Gabrielle referred to the word, legitimate and culturally authoritative, and nor can the Australian people be reassured that the people at the table are representative in that way. So that is one, I think, kind of risk, which though, to that end, the national institution of, in relation to just truth-telling, the national institution brings some coherency to truth-telling in relation to the activity that goes on across the Federation, and that is still important, and partly because Section 5126, 1967, it does put in our federal system the Commonwealth as the driver in space, and that's important in relation to this work because it should involve all Australians. It shouldn't just be a First Nations thing. the sequence, I think, has been overdone. I think the process was for a constitutional form of recognition. I think 12 years of process has got us to a position where communities wanted a voice, and then the kind of work of the Makarrata Commission that came out of the dialogue, the first constitutional process of its kind in Australian history, was to pick up on the need to address unfinished business in a coordinated and coherent fashion in a federal system that requires coherency of leadership.
Thank you. And I'm going to have to share the call, and I certainly invite you to put any kind of further information on notice if you haven't been able to add the information that you wanted to. I'll now go to Senator Cox.
Thank you, Chair. Thank you both, and thank you for your submission to this inquiry. One of the questions, and I just want to pick up a point that Senator Stewart made in relation to sequence. Within the Uluru Statement from the Heart, it says voice, treaty, and then truth. And I know internationally there are other examples in relation to truth-telling being done last. In fact, the Sami people have their voice, or to the Sami Parliament that exists, but also have treaty and treaties that they're brokering across the nations. And is that, I mean, when we think about the design feature of this, is the sequence so important that we actually, when we talk about the principles that you've outlined, Professor Appleby, around sovereignty and making sure there's not wasted opportunities and supporting First Nations people, is that about our sovereignty being recognised as individual entities and treating with each other before we can actually do the next part, which is seeking a federal treaty and or doing truth-telling at the federal level? Because I think what I picked up from your evidence already in your opening statement in particular was that grassroots engagement, people telling their own truth, but in fact dispelling some of those myths that we are a homogenous group of First Nations people. And would you see treaty being an important part of that?
It's a difficult question to answer. I'm teaching a course on this here at Harvard, actually, because, I mean, our constitutional system is so different to those countries that had first contact treaties and post-colonial treaty systems that are actually predicated on constitutional rights. We just don't have that right framework. I think, just on your first point, there really is no process I can point to in the world where truth was done first. I don't believe truth-telling processes have to occur before you move on to substantive kinds of recognition, legal recognition, which can mean anything from treaty to voice or other things. And history is eternally contested, so you're not going to get anywhere in that space, as Canada's found out after multiple truth processes. I agree with you. All of our communities are very, very, very different. All those nations are very, very, very different. And part of the voice design was to capture that in a model that would be designed and elected by the people for the people. And so you would have that nuance and granular difference coming through in a democratic fashion. And how that's done in relation to treaty, treaty it's a very, I don't know, Gabrielle, you want to jump in, but it's a very complex form of recognition in our kind of federation so late in the day, particularly when treaties provide a form of legitimacy from the outset at the creation of state formation. As we saw with the referendum, we don't have that, which is why it's occurring at a state and territory level, aligned with Labor government. So I think the mail's still out on that. I think Victoria is succeeding because they set up a voice first. I think setting up that framework, that democratic framework to anchor any of this work is really critical.
Yeah, Sorry, Professor Appleby, were you going to add to that?
I was just going to add, pick up on Professor Davis's final comment, and I think also to pick up the Chair's last question. I think one of the risks and considerations about pushing forward with truth at the point we are in Australia is the risk that it doesn't have legitimacy and authority within First Nations communities, because there isn't that space, there is a representative entity for Aboriginal and Torres Strait Islander people to come together, a locally representative body, but able to speak to national issues, to create that space for conversations to be had, to work out what the ask is from government when you are talking about a national truth-telling process. And in the absence of that entity, in the absence of that body, how do you go about setting up that has the legitimacy and authority across the country? Because there's no one that you're going to be able to consult with in terms of setting it up. I mean, you're obviously going through that process right now with this inquiry, or that's been your experience. The intention of the sequencing was both at the setup that the voice would provide the input from local Aboriginal communities to make sure it's set up and designed in a way that they have confidence in it, but then also at the back end to ensure that what happens to the histories, the stories, the local truth-telling processes that might be captured at a national level are dealt with in a way that the people are comfortable with and are fed into reforms, but also the government reminded of these processes. So in the absence of that, you've got to design a system that still has that authority. It's very difficult, which is why the sequencing is so important.
This is my last question. I just think, and it's probably more a clarifying point around if we could point to any examples internationally, and I think we looked at, I think the magic number was about 42 different international models of both agreement making or treaty and truth, and how they've been done well. What would be one of the standout features of those that you could point this committee to ensure that this bill, should it be voted on the floor of Parliament later on this year, and or is with or without amendment capable of bringing together a process that is possibly agreed to by all parties, but also that has the ability to reach down into grassroots communities and bring everybody on the journey that is required, and at the heart of this, which is essentially how we get to treaties or agreements, and to ensure that there is federal responsibility for truth-telling.
Yeah, so there are many examples, like you, most I've studied over my career. I think that comparative analysis is really problematic in this space. We look to places like Canada and the US, and they're just miles apart because they have constitutional rights. I think the closest for us is probably New Zealand, and partly because the Waitangi Tribunal is about agreement making. So we take the word treaty out of it, which tends to be clickbait and inflamed. There's many agreements that are done between governments of every level and First Nations and urban communities across this continent. I think what is important about the Makarrata Commission is what was envisaged, the fast tracking of land, native title, the coming to a conclusion of a lot of these processes, and embedded in that is the role of history and truth in that. And so they go hand in hand, and I think the Waitangi Tribunal has done it really well. It's a much smaller country, obviously. They don't have a written constitution. There's all many differences, because of course we have hundreds and hundreds of discrete groups. But, and should I say, when we're talking about agreement making, I use the word agreement making because it's not just in relation to mining agreements, government agreements, and the agreements that PVCs and others will enter into, or ILUAs. But there's huge numbers of urban communities, urban First Nations communities, that aren't living in an environment where it's a landed environment, and it's about, the organisation is a land-based organisation. They are communities that have been moved there, live there, and they operate as communities, discrete communities, who need to be included in this process as well. And so I think that's probably the best example. It's not perfect, but it's the best example that I've seen.
Thank you.
Thank you. We'll now go to Senator Little.
Thank you, and thank you, Professors Davis and Appleby. I'd like to ask about this bill, because this bill gives effect to an entity whose purpose is to make recommendations to Parliament on matters particular to historic and ongoing injustices. What do you understand to be the tenure of this entity? Is it temporary, that just has a particular task, or is it something that is permanent? What's your understanding about what it is as represented in this bill, or what it should be?
Sure. Thank you very much, Senator Little. So our understanding reading the bill is that it's intended for an entity that's time-bound and task-bound to conduct an inquiry. There may be interim findings, an interim report, but then there is a final report that needs to be delivered within 4 years with findings of facts and recommendations, and then that will be tabled in Parliament. We are concerned about that feature of the bill as we understand it, and we really urge the committee to consider the conception of a commission which is much more aligned with what the delegate dialogues are talking about, which is a commission having an ongoing oversight role. It's not the role to determine facts and in that sort of sense of truth, but rather to collate, to become a repository for local truth-telling processes that are occurring, to support other local truth-telling processes to occur, to provide necessary funding, advice in relation to that, and then to have an ongoing role in terms of promoting what's been happening, releasing information, of course, the submission of the First Nations communities, and also then feeding into government processes. So it's not a one and done idea, but rather the Commission would have an ongoing role as a repository, caretaker and accountability mechanism for those truth-telling processes.
I've got a question about resourcing. Now, as you know, there was resourcing of the consultations that occurred around the voice and the statement from the heart. This proposal, as we have in front of us now, is about establishing a national institution, as you referred to it, by legislation. If there are any lessons that could be learnt from your experience of the process of getting voice to referendum, can you make comment about the consultation that's actually required to give effect to what's being proposed in this legislation? What are the lessons learned is what I'm actually asking you.
Yeah, so, I mean, I can only speak to the First Nations regional dialogue process and the resourcing of that. I think it was a historic consensus of First Nations people, and I think the effectiveness of that process was that it wasn't bureaucratic run. It wasn't bureaucrats didn't design it, and it was held at arm's length from the bureaucracy, and I think that was a really key I think that was a really key thing in relation to the success of the dialogues and the outcome. I've been involved in the expert panel as well that was resourced and was led by bureaucrats, and they're two very different things. And so I think what's important about that is the fact that it was we spent 2016 designing it and asking communities about the design of that process. I'm not saying everything that this commission has to do has to be just Indigenous communities, because of course the success of it is dependent on Australians being involved and listening as well and contributing as well. That's so critical. But in relation to the kind of Indigenous component of recognition that we worked on, I think when you're able to have we had a subcommittee and consult the mob, you find that our mob are really wise and judicious about how consultations should run respectfully. And we know that that's not the case when, by and large, they're led by bureaucrats. And so I think that, to me, is a lesson to be learned, that it's important to trust and have faith in the design capacity of communities.
So what's the risk here of, this is an idea, it's come after the referendum, it's come after your dialogues. What's the risk here of what is being proposed falling short? We've had many submissions that have actually talked about the statement from the heart. What's the risk here of this falling well short of expectations, and is this really the risk of having something better, being better than nothing?
I think I don't think we've done this before in Australia, not in any kind of organised or sustained way. And so, you're right that, our people don't really have anything to compare it to. I suppose some people compare it to the Royal Commission into Aboriginal Death and Custody and the Bringing Home Report, which were forms of institutions. But I think, and I guess it goes to the core of Gabrielle and I, when we use that language of caution, it's just really critical for this to be a very Australian institution, meaning to ensure that we don't overplay the lessons that have been learnt in, Latin American commissions and American commissions and Canadian commissions, but that we're actually listening really carefully to what it is communities say, critical, things that are critical to the success of this institution. And I think the risk is, again, not trying to diminish bureaucrats, but getting consultants and bureaucrats to do desktop research papers on how it should or shouldn't be designed. I think the risk there is that, it will fall over because it's not really tapping into what it is that First Nations people say is needed and non-Indigenous Australians say is needed. And I think that's really the key to its success. I just don't think we should cut and paste the template from another country.
I want to ask about, there's reference in the bill around the period of appointments of people who would be represented. We've seen that there's a report in 4 years, but I think the bill doesn't make it clear that that's when the term of this commission would end after 4 years. There's appointments that could be 2 years, but they can be an additional 2 years added to that, which means that you could effectively see the same people on this national institution or entity for the entire period of the 4 years. Where's the essential criteria in here that resists a situation where you have the amplification of people from peak body representations as opposed to people from a broad sector of community with diverse positions and interests in this? How do you make sure that there is opportunity for everyone to speak on this?
100%. That's my. I think the bill can correct this by emphasising, and I return to Gabrielle and I's original point, it really needs to be driven by community people. And I think something that is just, dominated by the peaks isn't something that's going to hold the confidence of our communities anyway. And so being vigilant to that is really critical to the success of this process, because even though as service delivery organisations, the Coalition of Peaks are something government relies on. It's not necessarily something that First Nations people see as representing their voices or visions in relation to this matter. So it is important, and whether Gabrielle can talk to the drafting, whether this is built into the bill, that we find a way that grassroots community voices are not just, they're not the people that are called on to talk and tell their stories all the time, but people driving design, people sitting on the commission. That is really key. That integration is really key for this to have legitimacy, not just for First Nations, but for Australians as well.
Yeah, thanks. I just reinforce how important that legitimacy and authority of membership of the Commission is for success. And I think that Clause 7 of the current bill really does need to be reworked in that respect. You've got government appointment of 10 members. There is some skills, knowledge or experience that are listed, but there's no requirement consultation with First Nations people. It just says relevant stakeholders, and making sure that it's not going to the same groups, whether that be people organisations or other groups and individuals who already have quite a lot of access and influence, but it really needs to be able to tap into First Nations communities' desires for who they want to be on this commission. That needs to be redesigned. There needs to be, in our submission, much stronger consultation requirements for First Nations communities, and even the potential for First Nations appointments to be made onto the body. How that would be done, whether it would be through nomination or even potential election, that's something that needs to be considered, but it's a real challenge with the current drafting, Clause 7, and it will be key to the success of it.
Thank you very much. Unfortunately, that's all we have time for in terms of questions. I want to thank you very much for your attendance here today. If you've been asked to provide any additional information, or you would like to provide any additional information, would you please forward it to the Secretariat by the 5th of March. You will also be sent a copy of the transcripts of your evidence, and will have an opportunity to request corrections to any transcription errors. Thank you very much. We will now take a short suspension for morning tea and return at 11:30. I now welcome our next representatives to give evidence today. For the Hansard record, would you please state your full name and the capacity in which you appear before the committee?
Hello, I'm Karen Mundine. I'm Bunjalung from Northern Rivers and I'm the CEO of Reconciliation Australia.
Hello, I'm Kate Clark. I'm here representing Reconciliation Australia and I'm the General Manager Community Impact.
Thank you very much. Although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. To assist with the transcription of the public hearing, it would be appreciated if you could please state your name before responding to each question. I now invite you to make a brief opening statement of no more than 2 minutes before we proceed to discussion.
Thank you, Chair. I'd like to begin by acknowledging that we are on Gadigal country and acknowledge the elders of the past. I think it's important, particularly here, as we think about the site and place of the early colony and the impact that those early relationships and the things that happened in this place have had onto the ongoing relationship of First Nations peoples across the country. We really appreciate the opportunity to appear before this inquiry. As the national organisation promoting reconciliation between the broader Australian community and Aboriginal and Torres Strait Islander peoples, we acknowledge your work and the importance that it has. Truth-telling is, as we see it, fundamental to forging a path to reconciliation and justice. And in fact, our predecessor organisation ourselves were established out of a truth-telling process from the Royal Commission into Aboriginal Deaths in Custody. We believe that it provides healing and a collective pathway towards stronger and more cohesive communities. In 2016, our State of Reconciliation in Australia report identified historical acceptance, as we termed it then, as one of the 5 conditions for reconciliation to occur. And the idea that it promotes widespread acceptance of our national history, an agreement that the wrongs of the past will never be repeated, and that it is a pathway to justice, truth and healing. In our most latest research, that's not yet public, but our latest reconciliation barometer found that 81% of Aboriginal and Torres Strait Islander people and 71% of Australians in the general community think that Australia should undertake a formal truth-telling process to acknowledge the reality of our shared history. And that number goes up when we look at 18 to 35-year-olds at 89% support. In 2018, we worked with the Healing Foundation on a national truth-telling symposium just to start to unpack and identify what do we mean when we talk about truth-telling. And out of that symposium, there were a set of principles that frames and guides our future truth-telling processes at both a local and national level. The principles seek to ensure that the process is culturally safe, that First Nations led, and delivers a true and meaningful record with tangible outcomes, including mechanisms for justice, reparations and healing. And I note that many of these principles are reflected in the draft bill. As a result of that, our newest program is our Community Truth-Telling Pathways, which is in response to this symposium. This program is designed to respond to the research, and particularly that research we commissioned from Professor Heidi Norman and Dr. Anne-Marie Payne at UNSW, who I believe are appearing next. Out of this, our work is informed by the notion of community-led, place-based, strengths-focused and action-orientated truth-telling. And the program aims to provide resources to local communities so they can think about how they engage in this work themselves. The program is about raising awareness and about advancing culture, or the culture of truth-telling in this country. And just finally, I would say that we see very much a relationship between that on-the-ground local work and a national structure. When these things are done well and they have similar processes, there is very much to be learnt from both. Thank you.
Excellent. Thank you very much. Got a quick question. I wasn't thinking about asking until you talked about the data that you've got around support for formal truth-telling processes. I suppose I'm keen to understand how you got the respondents to that data. Like, are you? I suppose I want to know that you're not speaking to the already converted to get those types of statistics. Are you kind of how do you get that type of response?
So our reconciliation, Australian Reconciliation Barometer is a piece of research we do every 2 years. It's a national sample, so it's random. It's not speaking to a particular cohort. What I would say is that consistently, so we've been doing this since 2008, consistently tracking, there is a desire for this work, and I think people see the idea of truth-telling as a way to create actions and outcomes. Like everything, the more you go into detail, then it starts to change, but we're still working through what that means and within the data itself. But it is a national sample.
Yeah, okay, great. And the other thing I'm keen to understand, you would know this, but off the back of the referendum, I think lots of our mob are particularly traumatised and hurt. How do we kind of craft this commission in a way that doesn't re-traumatise people? And based on you talked about your kind of local truth-telling processes, like what are the kind of key ingredients, I suppose, to get that balance right?
Great question. Really having it First Nations led is very important. People need to feel that they have control or a say within the process. People, particularly First Nations people, and I think the research that Professor Norman will talk about, people are willing to work through their trauma because they see it as a personal healing process, but equally they need to feel that there is an outcome through this trauma. So people are willing to go through it to talk about things that are potentially painful if they think it will change things as a consequence of that. And so those outcomes become really important. So for us, those principles of First Nations led, connecting it to people and place is really important. Taking a strength-based approach. So again, there is a reason and a purpose for doing this. Putting cultural safeties around that and trauma-informed processes around that and support networks is really important for keeping people safe as you move forward. And as I said, outcomes-focused. I think that's particularly for First Nations people. It's equally true to an extent for non-Indigenous people, but I think the flip side to truth-telling is truth listening and truth acting. So for non-Indigenous people, having a relevance to participate, safety for them as they bear witness, but then them taking active roles in outcomes.
And you talked about there has to be kind of a purpose or an outcome to the truth telling. Is that, and maybe it's a combination, because there is some therapeutic benefit to telling your truth, and for some people, saying that out loud for the first time is really healing. And then the other part of it is that they kind of help shape findings and then recommendations that the government then acts on. In your work, what is it that people are looking for in terms of outcomes?
The outcomes can really, they're quite broad.
Yeah.
For some people, it is that just the healing and being able to talk about it. And I think back to the work that we did with Stolen Generations and the apology. It was a very important first step to be able to tell their story and have that story heard and believed. That sort of made sense of the trauma and pain that they were going through. But for many, it couldn't and didn't stop there. It's also about, well, if governments and the systems recognised that there were problems, that there were wrongs, what is being done to address that? What is being done to support those communities and those individuals? And I think, again, this is where people becomes very important, that it's not an abstract policy, but it is rooted and intended to support people coming through the other side.
Yeah. And what has your conversations and research showed are the barriers or challenges that people might face?
Again, we look at that in the context of for First Nations peoples. I think people are tired of telling their story with no outcome. People feel that they are not being heard or that things are not changing, and with that comes time sensitivity of people who are passing, where those stories are being lost or those opportunities to tell their stories have been lost. When it comes to non-Indigenous people, while there is an appetite or an intention that this stuff is important, having that personal relevance isn't always there. So their motivation to act or to change or to do something is also sort of tied up with that. If they don't feel that they can make a difference or that it's not impacting their life, there isn't really the incentive for them to participate in these things. So that's why our Community Truth-Telling Pathways program is about how do we make that engagement for local communities and local people. So rooting it in place, thinking about what that means where people live, where their children go to school, making it really tangible and relevant, but also the opportunity to make change or create outcomes is more within their control rather than at a very big, large, national, systemic way.
And what is what process did you undertake to engage and consult before you did your first truth-telling process? Like, how did you get the buy-in, I suppose, is what I'm keen to understand.
So we started, as always, with a lot of desk research to understand and go through all of the multiple reports that have been done to date, pulling out sort of, I guess, the key tenets and themes throughout that. Then the symposium that I mentioned in 2018 was to bring together lots of people who were doing work in this space. And while we didn't have a particular set agenda, what we were trying to understand is what do people want, and that informed the 10 principles that we came up with, which was around time sensitivity, all of those things that we've mentioned. That was part of the buy-in. And I think for us, it was also being very clear about what we were going to do with that information. So the idea that it was going to inform a program, which is going to help broader communities, individuals at a local level to think about what they could do, and if they intend to do truth-telling, what things they need to keep in mind, how they might do it, resources that will help them, connection to people who are already doing this work so that we highlight safety mechanisms, how to do trauma-informed, that kind of stuff. So it's a long process. We're only just starting to release some of that work. And it will go on at least for the next couple of years.
Yeah. And there was something that triggered my mind as you were talking, and now it's gone. And maybe if I ask this next question, it might come back to me. I'm keen to understand what are the lessons from the community truth-telling that you think are relevant to a national truth-telling process.
I think being really clear about purpose or scope, it's really important to set up front what you're hoping to achieve through the process. And again, this speaks to if people are to relive trauma, if people are to tell their stories, they want to know that it is in aid of making better outcomes. So being really clear at the scope, and sometimes that can also be hard because it may not be everything that people want out of the process, but if you're clear about what is possible through the process, it makes it a clearer pathway to what that outcome should look like. All of the trauma-informed, strength-based, but then the outcomes, the action piece is so important. It's got to complete the loop. And all of these things are interconnected, and there may be kind of things that will shoot off as a process, but for us in a reconciliation space, that relationship building is part of the outcome as well. So for some people, hearing it and being able to tell that story is enough. For others, it needs systemic change and outcomes and reparations.
And last question from me before I need to share the call. and this is a question that popped into my mind before, what do you do with the information and the data that's gathered at those meetings? Like I feel like we've heard a bit about data sovereignty and how important it is for First Nations people to own the information that they share. How do you ensure that in your processes, and how do you make sure that people know that, like that kind of informed consent?
So it's an ongoing piece of work for us as we kind of start this work, but of course everything we're doing is informed by data sovereignty and ICIP principles. It's through the conversation with communities. It's being very clear about how we want to use those stories, because for us that's helping us understand what's working, what's not working, and how that can help and assist others to do this work. So being very, very clear about that. Community absolutely, and individuals absolutely having a say on what is done with that information, and it always being accessible to people. And knowing also that at any time that consent can be withdrawn as well.
Yeah. Thank you. I'll share the call. Senator Cox.
Thank you, Chair, and thank you both for appearing today and your submission to this inquiry. I just want to pick up that point around data sovereignty to do with ownership, control, access, management and storage. What we've heard from previous witnesses is the importance of a federal Truth and Justice Commission to have a very clear role around how it is, I think the words they used was a national suppository in order to ensure that there is an ongoing role. Is that the view of Reconciliation Australia? That
Absolutely. And again, if we look at other jurisdictions, particularly Canada, with their all the evidence that was collected through their Truth and Reconciliation Commission inquiries. And I think it's important to have that keeping place, to have that suppository, but I think it's equally important that with permissions, things are done with that. So again, people share their stories because they want those stories told. So how that information, how that data informs not just policy outcomes, but the national narrative of the nation, and that story and that history is part and parcel of the story of Australia, or Canada in that case.
So just to clarify that point, Ms Mundine, is that the importance of this theory of change in relation to having good truth-telling that is both factual and a place of healing for mob must be grounded in a way that enables us to educate future generations, and that its importance must be told through the lived experience of First Nations people. Because I think you alluded to the fact that reconciliation and the movement of reconciliation was born out of the Royal Commission of Deaths in Custody, yet we still haven't closed the gap on that, and it's still going backwards. So how is it that we, with having this federal suppository, I suppose, how does that enable us? If there's no will of governments, there's no UNDRIP, there's no mechanisms to hold anyone to account right now around our basic human rights in this country, how is that going to make a difference?
It's an excellent question. I do think that having this suppository is one part of the bigger piece of puzzle. Having access, and this is partly why the work that we're doing is being focused around locals, so where can communities actually create outcomes and change? Certainly through our other programs like Reconciliation Action Plans, which focus on workplaces. Again, it's how workplaces can actually make change within their control. And I guess that's our kind of earlier point around a national commission or national body, is that there needs to be will and powers within it to actually create not just recommendations but implement change.
So just picking up on that point, and it was something that earlier witnesses raised today around those tangible outcomes, and linking very closely with that around the Closing the Gap agenda that we're currently in, importance of grassroots voices. I think Senator Little's comment earlier to earlier witnesses, how do we ensure that the right people are at the table? How do we ensure that we are getting a snapshot of grassroots communities and what that change looks like, whether it be through the right people, the right place, the right story, is not seeing this as a separate process. Is that, just to clarify what you were saying before, that these tangible outcomes are actually interconnected and interwoven into that policy frame?
That's correct, because the outcomes can be those policy changes. So yes, they have to link, and all of the work of reconciliation and the 5 dimensions I mentioned earlier, it's about these interconnected and interrelated impacts. So pulling a thread one way will have impacts to the broader fabric.
So we can't see government stand in the chamber and talk about closing the gap and not talk about human rights, and not talk about closing the gap for truth and justice, and not talk about Royal Commission on Deaths in Custody and the removal of children over time. They're all interwoven, and they're in fact the social fabric of our communities. Would you agree?
I would absolutely agree, and that is the basis of reconciliation as we think about how do we bring these things together and how do they interplay with each other, so that we either create better outcomes and change those systems, or create interference for systems and processes that are not working.
How do we measure that? What's the measurement? Like, how do we know that we've done the job? You know, we look back in 10 years and go, you know, like, wow, we've shifted the dial. I know you talked about 2008, that you guys have been doing this, and that there has been an incremental shift. But are there any things we need to bed down to ensure that we are actually measuring that, not just through the great work that RA do in your barometer, but more broadly, is there a government process?
Measurement is a tricky one, and part of it is it's only through time that we are able to step back and look back to see where things have shifted, because there are so many things that influence and impact that outcome. And I think the point is, and this is where truth-telling comes into it, is by grounding this around place and people. And part of that also then becomes, are we talking stolen generations? Are we talking about health outcomes? They all, if we talk about people and place, we touch on all of those things, because it's about people's lives and it's about people's stories and about people's history. And that's what truth-telling can do, is help to unlock those stories and help to unlock those pathways back into the socioeconomics, the experience of lived experience, the health outcomes, the education outcomes, the workplace outcomes.
Final question, and I know we've had some conversations previously about this, and previous witness, I'd asked the same question around the sequence of the Uluru Statement from the Heart is voice, treaty, truth. And are we putting the cart before the horse by doing truth-telling now and not bedding down our agreements in relation to treaty at a local level that enable us to ensure that we have a very strong, firm commitment to ensure that this has longevity?
I don't think there's a linear approach to these things. There is interdependence in all of this, but what I would say is that truth-telling helps to create the why the need for treaty, the why the need for agreements. By understanding history, by understanding what has gone before, it sets the basis and the platform for the conversation of what needs to be in an agreement or what needs to be addressed through an agreement.
Okay, great. I'll share the call.
Thanks, Senator Little.
Thank you. If you look at the list of people who are making representations, say just today, most of them are representatives of organisations. And one of the questions I've been trying to seek an answer to is what is truth-telling? We've seen people coming in here talking about truth-telling, talking about it in terms of an outcome. The actual legislation that we're set to inquire into talks about making recommendations to Parliament, but then you've talked about storytelling. So, you know, that's a lot of different perspectives on what should be an outcome, which could lead to a lot of disappointment. if this proceeded. So I'm just trying to understand, how do we make sure that peak bodies and key organisations don't dominate the narrative and people are left disappointed? How do we also make sure that we're clear about what the outcome is? Or is this just, going in, asking people to come forward with their stories, and we don't really know what we're trying to, what the outcome actually is? Is it recommendations, or is it just people telling a story? What is truth-telling?
I don't think there is a single definitive answer or definition. I think, and this certainly bore out through the conversations that we had done through the symposium and another engagement, lots of people see it and view it very differently, much like reconciliation. I think any commission needs to define for itself what the scope of its work will be and define for itself what will be considered truth-telling. It can just be people's stories, it can be memorials, it can be a plaque, it can be just an acknowledgement that in the building of a company, a whole heap of Aboriginal people were displaced, which allowed that company to go on and become the bigger company it is. Putting some guidelines around, having clarity of scope, which also then speaks to the clarity of what is possible through the process, is really important up front to help people appreciate what is possible.
The bill talks about the Commission having the power to appoint lawyers in relation to particular matters. One of the criticisms I've heard of the process has been a lot of lawyers in the room, as opposed to a lot of storytellers and a lot of people wanting to tell their truth from their perspective. It talks about giving power to issue search warrants for material. Does that raise any red flags for you in terms of if you're starting to talk about lawyers and search warrants and things like that, about its impact potentially on reconciliation?
I think this comes back to the clarity of the purpose of the Commission, and if it is to be a legal inquiry, then it needs to have legal powers enabled to do its work. That being said, there is still a narrative piece and there is still a piece for healing and for narrative and storytelling. I think it's really important to also say that while while truth-telling is fundamental to reconciliation, reconciliation isn't just about truth-telling. And so truth-telling has its own, it will stand on its own and in its own way and be defined by those that are engaging in the process. Probably not making myself clear, but the process is bigger than any one process or any one group of people. And I think if there is to be a commission, a clarity of purpose will help define what the expectations are of that process.
Do you have any comment about the proposition that there will be a report in 4 years, the membership can be appointed for 2 years by the Minister and I think the Attorney General, I think it is, but those people could be reappointed after 2 years for a further 2 years and then that's it. So effectively we could see the same group of people appointed initially across the entire process. Do you see that as being problematic?
I think not necessarily. It depends on the people who are there, and it depends on what is achieved through the first time that they're appointed.
Can I?
Sorry, Senator. I would also just say, I guess, truth-telling is an ongoing thing, and while I appreciate the limits of a commission in this process, one of the things that was made very clear to us very early on is there is both a quickening and a lengthening of time in this context. People want things to happen quickly because there is a time sensitivity of people passing and all people not getting to tell their stories. But equally, results, outcomes, while they're needed, sometimes they're going to take time based on the trust in the process, trust in the people, and the trust in and the ability of the people to work on their relationships. So while I appreciate a commission will have a time frame of its work, the ongoing work will continue with community. And I think that needs to be acknowledged somehow within the commission and within the legislation.
Can I ask, last week we had Sorry Day. Those people that were impacted by the specific policies are getting older and older, and those numbers are becoming less and less at those functions. I'm interested in understanding there's a 4-year time limit on this. Those people have had the opportunity. Some of them have taken it, some of them have missed it. Some of them, it's resolved, others it's not. We've had the Bringing Them Home report, we had the inquiry associated with that. Are there things or cut-offs in relation to are there things that people should be talking about in this and shouldn't be talking about this? And is there a cut-off point? So you will get a very different conversation from the people who actually lived that experience to the people who might have been intergenerationally impacted by their experience. Where's the cut-off here? Where's the truth? Because that might be the truth for that individual, but that's actually about the truth around people's experience under that policy position. They're quite different propositions.
They are, but from a community perspective, I would say that they see them as interconnected. And so there is no easy boxing of one against the other. But I would also argue that the anniversaries of the apology and the things that the Healing Foundation have been talking about with members of the Stolen Generation are that the issues or concerns that have been raised by Stolen Generations haven't been adequately addressed or resolved or dealt with. And so that's also why they continue to talk about these things.
I'm just trying to understand how it is. There are so many things that people may wish to raise as part of this process, how we don't end up with a whole heap of people giving evidence, putting up a proposition that actually is impossible to collect a view on or make recommendations in that time frame on.
So I think, again, this comes to setting scope clear at the beginning. I think it's really important to allow people, if platforms are being built, allow people to tell their truths, but again, throughout the process being really clear about what can and can't be addressed and how things can and can't be addressed, which then also speaks to there is a need to do something post the life of the Commission.
Thanks. I've got a couple of questions, and I know that Senator Cox has also got a couple of questions to wrap up, but I'm going to ask a couple of questions following on from Senator Little. My background is as a family therapist, and we'd often bring something into like a teddy or something into the room and stick a bunch of things all over it that weren't matching, and then depending on where you were sitting in the room, your description of the teddy bear in front of you would be really different. And I found it to be quite eye-opening for the family to say that actually you can have different truths. You're all looking at the same thing in terms of from your different perspective, but you're describing something different. And I suppose my question leading on from that is kind of how do you reconcile the kind of different experiences of people in your local truth-telling processes? And maybe I don't know, maybe you don't. I think the Victorian process allows space for people to have different experiences and different views about things without having to reach a decision about whose is. Yeah, I'm interested in kind of how you do that now.
Yeah, there is no absolute truth.
Yeah.
To that point, everyone's truth is their truth, and all that we're trying to do is create safe spaces for people to bring those truths to light. And hopefully through that process of hearing and listening to each other's truths, something else positive grows out of that, and an appreciation of those different perspectives, but also again the impact that has on a community or a place now and today, and what could change or what could be built upon into the future.
Thank you. And just one more thing from me before I share the call. In your submission, you talk about the truth-telling process as being a potent, I think you use the word potent force for change, if I'm not... Yeah, a potent force for change at the community level. I'm just wondering if you can give us a couple of examples about what leads you to say potent, I suppose. I'm keen to hear what the kind of on-the-ground experience is.
So I think one of the processes that we've been watching and participating in for some time is the Mile Creek Massacre and the long-term work of Auntie Sue Blacklock around memorialising that place, telling that story. And from a reconciliation perspective, where that became even more powerful was when a descendant of one of the perpetrators actually approached Auntie Sue and her group and said, I don't know if I'm welcome, I don't know if you will want to talk to me, but this is who I am, and I want to participate, I want to hear your stories, I want you to know me and my family as part of this. And Auntie Sue, who is a descendant of one of the two survivors from that massacre, could have easily shunned or been angry, but in fact embraced this person, this lady. And it's a really powerful story. People were crying. I get emotional when I even think about it. And hearing Auntie Sue tell that story, to see them together of how they collectively acknowledge what happened in the past, but also talk about how things have changed and what they want to do going forward. And memorialising and continuing to talk about what happened is really important part of that, but building these new relationships through that pain and that hurt, and that's coming back to the point of those principles. People are willing to expose themselves in these ways if they think there is a healing that comes out of it, or an outcome.
Thank you. Senator Cox.
Thank you, Chair. I just want to pick up on one of the points that was being discussed around a nuance between storytelling and providing recommendations and, I suppose, representations to the Parliament. In the work that Reconciliation Australia has done in truth-telling and thus far, would you agree that justice and the frame of justice, just outcomes, has a different connotation for mob than it does for broader public? Has that been raised in any of the polling that you've done?
The nuance of the differences hasn't necessarily come through in any of our polling, but I would say anecdotally, we do understand that the way community thinks about justice or outcomes can be and is often very different from the way it's expressed within an institution, whether it's Parliament, whether it's a workplace, whether it's law courts. So much of the work that we've done to date, which is really just the foundational pieces, is trying to define, when we use language, what do we mean by that? Because when we use language but have different expectations of the outcomes, this is part of the tension that gets created through a process. So trying to tease out some of those definitions, trying to be very clear about when a person says this is what they mean by that, to help in the process of truth-telling that people are really clear about, again, what they're talking about and also what could or should happen coming out of that.
I think, and just to sort of, I suppose, go one step further, we as parliamentarians have a very clear parliamentary privilege that we operate under that sometimes can allow us to say things that
have different meaning or different connotations to them. But for mob, that's not quite how that operates in our communities. And I think in this day and age when there's lots of mis and disinformation around the history in particular and what people skew as their own view about that, at this point in time, how important is truth-telling to our communities? Like, you guys have got the best read, I suppose is the word, on both what's happening in NGOs, in corporates, in wider spaces than we do, probably. But how important is it at this point in time for there to be a formal record of pre-colonial history, the impacts of the stolen generation? I think Senator Little alluded to the fact that we've had lots of inquiries. But what does that actually mean for a community?
I think it's extremely important at this point in time. As you said, there's been many different strands and processes that have happened, but there is nothing that brings it together in a national context, and that also at a national level is able to look at the impacts within that structural piece. So if I think about the work that we're doing at that local level, it's very relational. It is about those individual relationships at a community level. But then if we take that up to a national, there's nothing that pulls together what the structural changes need to be at a national level. And the principles are the same, it's just sort of how it's expanded from individual to a collective or institutional level. But it's very important, and we see time and time again through all of our work, whether it's with schools and early learning services, whether it's with organisations and workplaces, understanding our place and understanding what the relationship is between First Nations and other Australians and how we got to this point is really important in understanding why certain measures are being done within a workplace, why the name of a park is a particular name of a park and why that upsets or hurts some people versus others. People do crave to understand the place that they are in and to find that connection. And we think that community truth-telling or truth-telling more generally provides that connection for non-Indigenous people to place.
Yep. Great. Thank you. Thanks, Jeff.
Thank you. Thank you so much for your attendance here this afternoon now. If you've been asked to provide any additional information on notice, or you'd like to provide any more of your own kind of then would you please forward it to the Secretariat by the 5th of March. You'll be sent a copy of the transcript of your evidence and will have an opportunity to request corrections to any transcription errors. Thank you very much.
Thank you.
We'll take a short suspension while we welcome our next witnesses. We will resume. I now welcome our next representatives to give evidence today. For the Hansard record, would you please state your full name and the capacity in which you appear before the committee today?
Hello, my name's Heidi Norman. I'm a research professor at the University of New South Wales in the Indigenous Land and Justice Research Group, and my family, my mother's family from northwestern New South Wales, Gummeroi people.
Hi, I'm Anne-Marie Payne. I'm the Senior Research Fellow in the Indigenous Land and Justice Centre or Research Group at the University of New South Wales. I'm a non-Indigenous Australian.
Thank you very much. But although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. To assist with the transcription of the public hearing, it would be appreciated if you could please state your name before responding to each question. I now invite you to make a brief opening statement of no more than 2 minutes before we proceed to discussion.
Thank you very much for the opportunity to share our research with the committee. In 2023, we undertook research on barriers and enablers of participation in truth-telling and understanding Aboriginal history on behalf of Reconciliation Australia. In that research, we identified 3 dominant ways that truth-telling is discussed in the literature, and we also just added a 4th category. In the handout that we've shared, you will see what we refer to here as our truth-telling schema. And I thought for the purposes of the committee's inquiry, I might talk to the 3 or 4 elements of the schema. And why we think this is useful is because there's an enormous range of activity underway in the name of truth-telling. Truth-telling is invoked in different ways. So we thought about this schema as one way to help us understand what truth-telling is and perhaps even what it isn't. So truth-telling as justice. This is the dominant meaning of truth-telling in the 21st century. It emerges from the transitional justice field and sees truth-telling as intrinsically connected to justice. This approach to truth-telling is usually undertaken on a large scale. It's informed by human rights frameworks and aims to address systemic injustice at an institutional level. Examples include the Bringing Them Home inquiry, the Uruk Justice Commission. And if a National Truth and Justice Commission is established, it's likely its work would fall into this category. Secondly, truth-telling as healing and reconciliation. This approach is based in the official acknowledgement of the truth of victim accounts, which had previously been denied and is therefore frequently associated with healing. This form of truth-telling is most likely to occur at the local and community level, based on the understanding that relationships and dialogue can bring about change. It's less likely to be tied to formal outcomes, and some examples include the Healing Foundation, the work of the Healing Foundation, reconciliation, local acts of acknowledgement and recognition such as memorialisation, plaques and renaming places. The third, and this really touches on our area of interest as historians, is the idea that truth-telling is history. So there's a sense that a deeper understanding of history will help us come to terms with its legacy and what it means to live in Australia today. Over the last 5 decades, an incredible body of work has restored once omitted Aboriginal and Torres Strait Islander experiences to the national story. And what we would add is that further to this contact history, Aboriginal and Torres Strait Islander perspectives insist on a history that extends for thousands of generations, draws on a wide array of evidence to tell a story of an ancient land and its future, thus offering the possibility of connection to place that extends over much longer time periods. And finally, the how-to of truth-telling is a vital part of the process and where more work is needed. The strong consensus emerging from our research participants was that truth-telling in Australia must be led by First Peoples, engage with First Nations perspectives, recognising ongoing impacts of the past in the present, and must be ongoing, not a one-off event, and aim to achieve change, whether that's attitudinal, institutional or structural. Perhaps most importantly, truth-telling is as much about the future as it is about the past. So while acknowledging the challenges involved in truth-telling, it's important to remain optimistic about the possibilities for change. I'll hand over to Anne-Marie to cover off on some of our research findings.
Just try and be as brief as possible.
Because I imagine you'll also get lots of questions about it. So
Okay, well, do you want to just, maybe Heidi, do you want to just say something about the last bit about history, and I'll leave the questions about the research for the...
So I think you can,
no
you
problem
can include that into the actual response.
Do you want to do that last little bit? No.
I think that's okay. We can just go to questions.
Excellent. Thank you very much, because I think there's lots to pick out of your brains based on the work that you've done. And we'll go first to Senator Cox.
Thank you. Thank you, Professor Norman and Dr. Payne, for giving us a submission to this inquiry. And some of your recommendations, I suppose we'll call them, around how we might improve the bill. We've talked a lot this morning about referencing the actions of colonial governments and federal and state, and making sort of that explicit distinction and between what is the pre-colonial era and what is post-colonial within the bill, and the importance of that around truth-telling. Do you have a view around the scope of that, and whether that may, given the framing that you've just talked about in relation to truth-telling, do you think that would present any issues or any problems?
So your question is about, I guess, at time, whether truth-telling resonates differently in colonial and post-colonial periods.
And pre-colonial. This actually talks about pre-colonial. So in the bill, it actually sort of breaks it up in 3 different time frames. Pre-colonial, describing what history looked like for First Nations people in this country. The colonial era or colonisation as a process, and then post-colonial. And so I think your reference to truth being victim's account and healing, do you see that that would present any issues in the way that they're structured or broken up as part of the bill?
I don't think so. My sense is, if one of the reasons we developed the schema that says, truth-telling is very much a part of our time, that not everything is truth-telling. So, for example, a grievance, I'm just making up an example, a grievance that you might share about the operations of your Aboriginal Land Council, that's not truth-telling, that's a grievance. A concern about expenditure, you might think about that as issues of fraud. Perhaps there is some movement into truth-telling. So what we wanted to think about really is that truth-telling occurs at different levels, and that there's a human rights approach, which is the justice dimension. There's truth-telling, healing and reconciliation, which is a much more local level, relationship-based. It addresses a sense of hurt on the part of individuals and families. And then there's historical truths, which is thinking about history and a greater understanding of history to achieve change. And I think I could say in our work we would be inclined to think about continuity over colonial and post-colonial period. I mean, truth-telling is very much I think we would place that in the post-colonial context or decolonial context. And I think that the human rights framework would be post-colonial or decolonial.
Yeah, and in fact, maybe if I can just add to that, I think the truth-telling, healing and reconciliation dimension includes truth-telling about the resilience and survival of First Nations peoples and histories and cultures. And so whilst within the sort of transitional justice framework there's an emphasis on victims, even in the work we saw coming from the Uluru Dialogues, First Nations people also wanted recognition of their activism and agency and didn't want to be represented as victims. So I think at all those phases we would need to, we would truth-telling would want to recognise that it's not a victim framework, it's actually about empowerment and agency, as well as recognising the hurts and harms that have been done.
Yeah, I just want to pick up on that point, Dr. Payne, because in the evidence we got from Professor Appleby and Professor Davis just a while ago was around how that tips into structural reform and actually change. So if we had a conversation around both that activism and the resilience, celebrating that, First Nations people, how do we tip that into structural reform when we have a very broken set of cultural heritage laws in this country which don't protect any of the oldest, world's oldest rock art and remains and still doesn't allow us to have that agency to be able to ensure that we have legislation that's strong enough. And we keep blowing up caves and we keep destroying cultural heritage in this country because we actually aren't making the structural reforms based on that evidence or the story of truth. Is that what you're saying? Like, we absolutely need to ensure that not just is that somebody's account of we camp there, you know, there was ceremonial ground there and there are people who were buried and that rock art belongs to us because it tells a story, but there's actually also fact in that. And I think that's what we've heard this morning, is when it flips over into story, localised, telling people, and there's a historical element to that that is about fact. Where does that sit in the national suppository, I think was the word that they used, and into a way to change the system that allows it to be protected and preserved in the future?
I'm sure Heidi will want to talk about this as well. Thanks for that excellent question, Senator. I think, you know, one of the very strong findings from our research is that people didn't want truth-telling just to be a talk fest. They did want it to lead to some significant change. And so, whilst it's important to have the conversations, and I, you know, would call out and acknowledge the work that Reconciliation Australia is doing at that community level in building relationships, which I think are critical for changing, you know, hearts and minds, working for a better future at a local level, you do need systems and processes so that you can feed this important information into something, because we have seen, as other witnesses have mentioned, a legacy of a lot of hearings and commissions that don't lead to any substantial change. And I think we would want to avoid replicating that. Heidi, I'm sure you want to say something else there.
I was just thinking that, Senator, one of the themes we thought about closely in our research for Reconciliation Australia is the role of history and history education. And the story of Australian history is a dominant, you know, one of contact history, a dominant colonial story. In the last 50 years, there's been a phenomenal amount of what is termed Aboriginal history in response to that provocation of the Great Australian Silence. So there's been 50 years where you could say that the silences have been filled, right? Aboriginal history has been restored, and there has been a renovation of sorts of the story of the nation. But we are reminded, say, in the Voice referendum, of the lack of awareness. And we are reminded when our students join Aboriginal studies or Aboriginal history and politics subjects, they continue to ask, how come we didn't know this? So there is something there about what is happening in schools and in our universities and in our the wider public about the level of awareness of you know, Australian history as a shared history. And you know, I think one of the big developments in scholarship and in exactly what you were reciting there, in thinking about the importance of Aboriginal cultural heritage, is deep history. So it's saying that you know, it's not just the restoration of Aboriginal worlds in this contact space. It's saying that this is an ancient land that has a much deeper history, that Australian history has is continuous with. And thinking about that, we coined a phrase to describe what we observed. And do you want to elaborate that?
I'll just, so I guess, Heidi's been arguing, that Stanner's The Great Australian Silence has largely been addressed, but we still hear this lament about why didn't we know? And so Heidi and I are dubbing it the Great Australian Unknowing, which is this persistent resistance to engaging with Aboriginal and Torres Strait Islander histories and with being able to absorb for the non-Indigenous Australians. And that's been a particular research interest of Heidi's and mine. I think Reconciliation Australia spoke earlier, Karen spoke about, other witnesses have spoken about truth listening being as important as truth telling, and our research certainly identified a lack of understanding about truth-telling in the non-Indigenous respondents to the study, even though they saw themselves as being very knowledgeable and well-informed about Aboriginal issues. They said they didn't know how to get involved in truth-telling, and they didn't understand what the role of non-Indigenous people in truth-telling was. So there's a huge amount of education and capacity building work that we feel needs to go on to get that engagement from the broader community, because we think that's going to be the game changer, getting that broader engagement and people to get involved and to recognise the injustice of previous experiences and to want to see different outcomes in the future.
Great, thank you. You've also stated in your submission the legalistic approach to truth-telling may be a tension and desire to create a supportive environment in which witnesses, particularly First Nations people, can give evidence. Have you got any suggested changes? I'm happy for you to take it on notice if you don't have anything off the top of your head. But
yeah, we do have a couple of thoughts. So one is you're thinking about the operations of an inquiry. Anne-Marie can, I think you can cover off on some of those points, and we do also have some references back to the Bringing Them Home inquiry, the experiences in relation to that. In that process. But in terms of from our research, the main barriers to engaging with Aboriginal history, there are three key points that were raised. One is interviewees identified the impact of fear, guilt, shame and racism, failings in history education, and political contestation over First Nations history was seen as off-putting, and for some raised questions about the validity of these histories. But in terms of the legal aspects of the inquiry,
so just I've been doing a bit of research on the Bringing Them Home inquiry as we're approaching the 30th anniversary of that very significant moment. And so I guess when you look at how that inquiry worked, it made an effort when it went out all around Australia to gather evidence and to have hearings. It often held its hearings in Aboriginal community venues, and that was a deliberate attempt to try and actually make people comfortable with the inquiry and feel that it was happening in a safe space for them. So there can be small measures like that can make a really big difference to inquiries and to people feeling that it is a culturally safe space. I guess that particular comment that you're referring to, Senator Cox, was in response to the sort of some of the legal dimensions of the proposed commission. And I mean, Heidi and I are not lawyers, so we would leave that to other experts. But sometimes when truth-telling can be overly legalistic, it can, it's everyone, lawyers at 20 paces, and the truth gets lost amongst the fears about how is it going to be interpreted. And so processes where witnesses are cross-examined or need legal representation can be at odds with that desire for really honest coming to grips with people's lived experiences. I think the comment was made earlier about the difference between maybe politicians or bureaucrats giving evidence and community people giving evidence, and you might need some differentiation there. So I thought that was a sensible addition that was made this morning.
I think you covered that off by giving evidence in chief, which means it's not contested, or from my understanding. So, but if on notice you wanted to give any further detail about what that might look like, which might be helpful in the work that you've done to inform the committee, that would be great. And
Thanks.
I'm just going to pass on.
Thanks, Senator Cox. Senator Little.
Just wanted to talk about the model that I know that people who are not here can't see it. Is that that's what you've come up with in terms of what people have told you, truth-telling, kind of all the dimensions of truth-telling? Have you actually lined that up against what the bill actually says this will do, which is, you know, reporting on matters to the Parliament?
No, we haven't done that work.
Okay.
But
So
we would be happy to take another look at that and get back to you if that's useful.
So you've talked about the importance of people actually sharing their stories as part of reconciliation, and you talked also about engagement with Aboriginal and Torres Strait Islander people in response to what they saw that truth-telling as, and then you've got in here non-Indigenous respondents and what they saw. What jumped out at you as being the biggest difference in their understanding about what truth-telling is?
One difference that that comes to mind immediately is that for a lot of Aboriginal and Torres Strait Islander people, they describe truth-telling as an everyday practice. So we can talk about it, you know, obviously the National Commission is something quite different, but a lot of Aboriginal and Torres Strait Islander people said we do this every day. In every conversation we have with non-Indigenous people, there's an element of truth-telling, and so that was very different. Another really big difference between First Nations and non-Indigenous respondents is that Aboriginal and Torres Strait Islander people were much more likely to see truth-telling as interactive. They saw it as a two-way process of truth exchange, which I think is very much, you know, from my understanding as a non-Indigenous person, very culturally grounded in Indigenous ways of knowing and doing, whereas for non-Indigenous people, they saw themselves as passive participants in truth-telling processes. They're also very unclear about what is the role of non-Indigenous people. Are we there to listen? Are we there, you know, are we exchanging stories? So there was a lot of uncertainty about the protocols of how to participate in truth-telling by non-Indigenous people. And I know Karen Mundine from Reconciliation Australia spoke earlier about some of the important process work that needs to be done about being really clear about what forms of truth-telling, you know, from this model or otherwise, people are offering, so that people understand. If we look to the Bring Them Home inquiry again, some non-Indigenous people who sort of attacked the findings of the Bring Them Home inquiry based their criticisms on the fact that witnesses weren't cross-examined, and they didn't realise that it wasn't a legal inquiry. It didn't have that sort of evidentiary standard. It wasn't a beyond reasonable doubt forum. It was, you know, it was about people sharing their lived experiences. And so if there'd been more clarity about the process that was being used, people would have understood that it, you know, it wasn't a case of cross-examination of evidence, and that wasn't the appropriate process to use in that particular context. So I think that just speaks to the importance about being really clear about what it is you're trying to achieve and what processes you're using to get there.
So, given the narrative that is developing at the moment, is there a place for non-Indigenous people in the truth-telling process as it's currently being presented? Because there is a lot of participation from Aboriginal and Torres Strait Islander people about what truth-telling will look like, but it doesn't seem that there's a lot of shared interaction about what that should look like.
Yeah, that is something we've been thinking about, and if we go back to the Council for Aboriginal Reconciliation, they set out with 8 key objectives, and the top 4 of those objectives were really oriented around building awareness of Aboriginal and Torres Strait Islander histories. And one of those 4 was developing a shared sense of history, and I don't know that a lot of progress was made in that regard. I don't know of many examples of work that genuinely responds to a shared sense of history. And I think that if that is a relevant point, we might also think, you know, where are the non-Indigenous voices in truth-telling? There are a few examples, I think, if we look to, say, the Mile Creek Massacre Memorial. I mean, I was there at the opening of that memorial site in the year 2000, and one of the striking features of that particular memorial in northwestern New South Wales was the presence of descendants of perpetrators of the massacre, along with survivors of that massacre. And in my calculation, that was one of the rare example in Australia of a shared sense of history.
Thanks, Senator Little. In your research, how did you get the respondents? Like, where did they come from?
We had used social media, and we had a fairly extensive database, and we also relied on the database of contacts that Reconciliation Australia had available. Okay. So that there was some perceived limitation in those how we recruited participants, in that many of the participants identified that they had a good understanding of Aboriginal and Torres Strait Islander history. So in some regards, that we initially thought that was a limitation, but we ended up thinking that that was quite a useful cohort, because these are people who self-identified as having a good understanding of, Australian history, and yet even within that cohort, some really interesting things came out of the research.
I mean, I imagine you get different feedback information from people who perceive they know a lot about Aboriginal and Torres Strait Islander people, as opposed to people who would say they don't know anything. Like you would just get different information, and even the kind of, the kind of willingness to want to learn new things potentially. I'm keen to understand a bit about data sovereignty in the first instance. How important is that kind of data sovereignty, and I suppose what's your kind of understanding of what data sovereignty looks like in this process?
Do you want me to start? In this work that we did for Reconciliation Australia, I guess if we just talk about what we did ourselves. So when we obviously had an ethics process and the university processes of consent, but we also we interviewed a number of people as part of this research project, and so not only did we share the transcripts of those interviews with them and give them the opportunity to edit them, I guess as you're doing today, but we also shared the research findings in a draft form with people and asked them if they wanted to have any comment or input. So, I guess that's trusting the research participants and seeing them as a co-owner of the data that's produced. And
the next question, who owns it?
Exactly, and that is, these are their stories and their lived experience. We don't own that. We're contributing to disseminating that information through our research, but we're not the originators of that information, and so we always work to be extremely respectful of that. And I do think, certainly, again, if we look at the Bringing Them Home inquiry, some of my research looked at people who testified at the Bringing Them Home inquiry, and people who feel that their story, gets misrepresented, or that, I guess, that speaks to the importance of acknowledgement of truth, because if people don't feel their truth has been heard or that it's rejected or denied, that can be very harmful and cause a lot of re-traumatisation for people. And that's not only, from the example of Bring Them Home, but other processes around the world. In Rwanda, they had local Jakarta courts that did, trials of people involved in the perpetration, and, people participated where they had to give evidence, and people who'd massacred their families were sitting with them. And that's not a safe environment in which to speak your truth. I mean, that's a very extreme example, but, we do have, situations like Heidi has mentioned in Myall Creek, where you have, descendants of both perpetrators and victims of massacres who are living in the same communities, and, having to find a way to live together is really important. So I think I've gone off the topic, but data sovereignty, Heidi, did you want to add anything else?
Well, I think one of the things we highlighted in our submission and that came through in the interviews is that some participants raised concern about the potential for truth-telling to be an extractive process. So it was storytelling, sharing your story, and that one, it makes you quite vulnerable, and that the extent to which you can retain ownership and control over your story. So we highlighted the need for clear protocols around knowledge exchange and the subsequent use of any information.
And just on that front specifically, sorry, the groups like the National Library of Australia hold the Bringing Them Home Oral History Archive, and they have very strict protocols around whether the information is shared is for research access, whether people can then publicly use it, whether the person who is the knowledge holder has to give further consents for that to happen. So I think there are some good models that the Commission could draw on in that respect. Yeah.
And I suppose it kind of leads me a bit to my next question, which is about cultural safety in a process like this, because there have been quite a few submissions that have talked about cultural safety and how important it is in this process. And where is it here? Concerns about cultural safety, 72% from the people that you spoke to. And then even with non-Indigenous people, they had concerns about whether truth-telling would be culturally safe, which I'm interested in what they mean by that. Like, unsafe for them or unsafe? Are they concerned about Aboriginal people who are appearing? But anyway, in the first instance, I might get to my first question, which is, what did people, or did people, give you a sense of what would create a culturally safe environment for them to be able to come and tell their truth?
I think
and what were the things that made it unsafe? I suppose is the opposite to that. Like, what are the kind of do's and don'ts here?
I think there were two key themes that emerged from my point of view, and Ree might have more to add. One is that you were listened to, that you're heard, and that in sharing your story, your account, your experience, that it leads to action. It's not just a talk fest.
Yeah.
I guess specifically, one of the people that we interviewed had been involved in the New South Wales Stolen Generations reparations scheme, and also working with community around support for Stolen Generation survivors. And she spoke about some of the processes that they used at a local level. So again, I think there are really good models out there. So they had, elders in attendance. They made sure they allowed plenty of time. They provided food, because they said a lot of the important conversations don't happen in the formal part of the process. They happen over the break times. That there is aftercare. I think that's been raised already today, the importance of providing support for people. You need to protect the cultural safety of the people working on the Commission as well. And I know that was, again, an issue with the Bring Them Home inquiry, that people working on the inquiry got quite exposed to, got traumatised by listening to these very painful stories day in and day out over 12 months or more. So that's another important issue to think about.
Yeah, absolutely.
Specifically on that other question, though, I do believe a lot of
non-Indigenous people.
I do believe a lot of those non-Indigenous people were concerned that Aboriginal and Torres Strait Islander people would have their truth questioned, and that would be culturally unsafe, rather than feeling that their cultural safety would be brought into question. A lot of for example, why I think that is because when asked about questions like trauma, a very small proportion of non-Indigenous people were concerned about trauma, compared to a very large proportion of First Nations people. So it's something like 14% to 60%, 50%. So that makes me feel that people aren't responding about their personal cultural safety, but thinking more about how, because one of the other questions was, what happens when the truth gets questioned, which I know has been a bit of a question that's been asked here as well. And so people, both Indigenous and non-Indigenous respondents to the survey, were concerned about the truth-telling involving people's truth being challenged, and how you manage that in practice.
Yeah, I think there's so many people were concerned about cultural safety. Like, is also another indicator of the cohort of people that you spoke to, because I'm not sure that would be the, and maybe it is. Maybe that is what people in the broader Australian community would feel. You've talked about the it's kind of your first dot point here on your key findings, the importance of celebrating resilience and survival of Aboriginal and Torres Strait Islander people. Like 98% of people that you spoke to said that that's what they wanted to see. So much of the national conversation about First Nations people is in the deficit. Did people give examples of what that would look like? Like, they say these are the things they want to see celebrated in particular. I'm keen to unpack that a bit more.
I don't think we got specific examples, but things that came out. A part of the research involved a media analysis where we looked at any references made in the media to truth-telling over a 3-month period, and actually that was useful because it pulled out a lot of things that were happening in the community that where truth-telling is used as a frame to explain what's happening. So things that people, First Nations people, spoke about things like NAIDOC Week, which is a really important moment to reflect and celebrate on Aboriginal and Torres Strait Islander cultures, languages, achievements. That was a really significant moment. Some of these national moments, like the anniversaries of the Apology, Reconciliation Week, you know, some of the other significant dates are very important and provide a opportunity for the community to set the theme of what they want to have celebrated and remembered on those particular occasions. So there's just some examples that spring to mind, but we could probably give more thought to that one if you would find it helpful.
Yeah, I mean, because one of the most recent inquiries that this committee done was about the economic opportunities for First Nations people, and it's a truth that Aboriginal businesses contribute $16.1 billion to the economy, which is pretty great, and that's probably an underestimation. But it's not widely known that we are absolutely making an economic impact in this country. You're on a completely different thing now. Your submission refers to the UN principles and guidelines on the right to remedy and reparation for victims of gross and serious violations of international humanitarian law. Can you explain how these principles could inform the design of the national truth-telling process?
Well, to look at back to our schema, so we're saying that truth-telling, it takes an institutional form, that it seeks to provide redress for harms, and necessarily that takes a form of justice, but also reparations. So yeah, that's our key point there. And I think in the work we have looked at, in interviews and the literature, what came through very clearly is that that this is about making change, and part of that change is the necessary reparations to support people in their own healing, and to respond to justice claims.
Yeah, and if I can just add to that, I think that point really came out strongly from some of the international literature that, you know, truth-telling isn't an end in itself. Truth-telling in itself is not justice. It's a pathway or a process that leads to a more just future. It's not doing the truth-telling is not, there we go, tie it up with a nice neat bow, it's done. It's a way to get to what comes next, if that makes sense, not an outcome in itself.
Yeah. Have you, I won't ask that one. I suppose I'm interested in community attitudes towards truth-telling. You've kind of talked about the cohort of people that you've got as a part of your research. I suppose I'm interested in the parts of the research that are, I suppose, not supportive of truth-telling process, and what that told you about. I don't know where kind of people's minds are at. I suppose I'm interested in kind of what were the negative things that people might have said about the process, because I'm interested in understanding what are the barriers being able to bring everybody along on this journey. I think lots of the statistics here make us feel good about what truth-telling has to offer, and that's great, but we want everybody to come on this journey, including people who aren't convinced that this is a good idea. What did they say to you?
I'm just thinking of a few points. One is that the people we interviewed, if I'm remembering our research correctly, not all of them had participated in a truth-telling event or knew where or how to participate. So it seemed that there was, even though these were a cohort who identified themselves as having strong knowledge and interest and engagement, even that group found difficulty in working out where and how to engage in truth-telling related activities. So that was one point. And in our submission, you will have seen we looked at the Reconciliation Australia's data on the barometer, and I'm just looking through here to try and find that statistic. Can you recall that, Anne-Marie, where even though there was acknowledgement of the harms done over the past, there was less interest in thinking about how those harms can be remedied. So if you give me a moment, I'll find that data statistic. You know what I'm referring to?
I do. I don't know if I'll be able to pull it up immediately, but we can definitely, maybe we can take it on notice and submit it later. So, I mean, there was a concern amongst First Nations people who were, you know, within the context of an overwhelming support amongst our group of research participants for truth-telling. There was a concern, for example, 77% of First Nations respondents said that truth-telling might emphasise divisions and differences between First Nations people and non-Indigenous Australians, or they were neutral or unsure about whether it would. And that was far in excess of what non-Indigenous people said. So I guess Heidi and I, in discussing that finding, thought that possibly there were a few different things going on there, because, you know, part of the, I guess, the art of research is knowing what you've got, get these figures thrown up at you and what do they mean. But we did think it reflected that, you know, the First Nations community were very aware that there are a lot of challenging and difficult truths that needed to be told, and maybe part of that not knowing, the great unknowing that we're talking about, is that those non-Indigenous people who haven't taken the time to become better informed don't realise, you don't know what you don't know, so they don't realise that there's some of these hard truths are going to come home, and that we need to get through them to get through to a more just future.
Also, why should they care? Like, I think that's the other thing. If it doesn't affect your day-to-day life, why are you engaging in this process of national truth-telling? I mean, from my view, it's really important. You know, it's about who we are as a nation, but there are lots of people who don't see this as, I would imagine, as relevant to their lives.
Sadly, I think that's the case, and we do need to do a lot of work to build that understanding of why it's important, and to, you know, I mean, just even on an education front, some of the work that Heidi and I did about how you do engage non-Indigenous people, we asked these people who saw themselves as being very knowledgeable about how they had, you know, decided to get interested. So they spoke predominantly about the power of learning this history from the lived experience of First Nations people. And this might be through various forms. Sometimes it's elders visiting schools, workplace activities such as those organised through RAPS, you know, all these wonderful organisations out there doing a lot of work in this space. Some people spoke about reading First Nations scholarships. Other people talk about through sport, forming friendships with Aboriginal and Torres Strait Islander people, and learning that what they'd read in the media wasn't accurate, and that you know, people are people. And so there were a lot of ways that people were learning this history, and we do think it's not a hopeless story. We have, I guess, a challenge because a lot of people in Australia, first of all, we have older people who weren't educated at a time when Aboriginal and Torres Strait Islander histories were in the curriculum. So we've got older people who have never had the opportunity to learn this history. And we've also got a large migrant community who might not have been educated in Australia and have their own histories that they want to preserve and honour. And so there's a challenge in engaging them, as well as the challenge of engaging, you know, white Australians like myself who might have colonial ancestry and, you know, are afraid of learning, you know, things that might have happened in the past, or afraid that they're going to feel shame, or, you know, that they're going to, and so they turn into denial or turning away. And so there's a lot of things that need to happen to build that historical learning amongst the broader community. And I think there are specific things that could be done. But
one thing we identified is the absence of a space in the national capital that is an educational institution for Aboriginal and Torres Strait Islander histories. We know that was discussed and raised at one point recently, but has largely not been acted upon. So the role of a national place in proximity to all of the other leading cultural institutions would seem vital to advancing a better understanding of the nation's story.
Unfortunately, I feel like we ask questions for a long time, but unfortunately that's all we have time for today. Sorry, with my microphone. I want to thank you both for your attendance here this afternoon. If you've been asked to provide any additional information, would you please do so by the 5th of March. You'll be sent a copy of the transcript of your evidence, and you'll have an opportunity to request corrections to any transcription errors. Thank you very much. We will now take a short suspension until 1:45 p.m. Yeah, no, I've seen that before. Where's my notes? There she is. All right. We will resume, please. Yeah, okay. All right. Thank you very much. I now welcome our next representatives to give evidence today. For the Hansard record, would you please state your full name and the capacity in which you appear before the committee?
Sure. It's Blake Allen Cansdale. I am the National Director of ANTAR.
I'm Jessica Johnston. I'm the Research and Policy Officer at ANTAR.
Thank you. Although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. To assist with the transcription of the public hearing and for those of us who are joining us via teleconference, it would be appreciated if you could please state your name before responding to each question. I'll now invite you to make a brief opening statement.
Thank you, Madam Chair. I'll begin by acknowledging the Gadigal people as the traditional custodians of the land on which we are meeting. I pay my respects to elders past and present and extend that respect to all my First Nations brothers and sisters here with us today in person and online. I affirm on the official parliamentary record that sovereignty was never ceded. This always was and always will be Aboriginal land. Thank you to the committee for the opportunity to appear before this inquiry and to present evidence on behalf of ANTAR. I am Blake Allen Cansdale, a proud Anwin man and the National Director of ANTAR, one of Australia's leading advocacy organisations fighting for rights and justice for Aboriginal and Torres Strait Islander peoples. Today, we're here to discuss the Commonwealth Truth and Justice Commission Bill of 2024. This bill was referred to a parliamentary inquiry to which ANTAR made a joint submission with the Uluru Dialogue. Importantly, whilst our submission was prepared in joint and accurately reflects the views of both ANTAR and the Uluru Dialogue, the evidence I will give today is that of ANTAR's alone. It should not be taken as being representative of the views of Uluru Dialogue or of any of its representatives. Committee members, the importance of the Commonwealth Truth and Justice Commission Bill cannot be overstated. This bill seeks to institutionalise truth-telling, ensuring it is recognised as a matter of national importance and that it complements state and community-based truth-telling processes. A National Truth and Justice Commission must require the Federal Parliament and the wider Australian community to acknowledge and confront Australia's colonial and ongoing injustices. Certainly, there have been many significant moments in our nation's history that have shone a light on our colonial past. From the Yirrkala Bark petitions of 1963 and Mabo in 1991 to the National Apology of 2008 and the 2017 Uluru Statement from the Heart, to name but a few. These were all major milestones that First Nations peoples fought for, and each constitutes an important example of truth-telling and the role that truth-telling plays in raising national awareness. However, Australia has never had a comprehensive national reckoning with its past. In particular, we have never had a fully resourced, enduring and enforceable national truth-telling process that leads to genuine structural and systemic change. Whilst this bill represents an important step forward for First Nations peoples, we must be alert to the perils of truth processes being rendered largely symbolic or performative due to government inaction. For example, the 1997 Bringing Them Home report documented the atrocities of child removal policies in Australia. Yet nearly 3 decades after the report's publication, most of those recommendations remain unimplemented. Equally, the Royal Commission into Aboriginal Deaths in Custody provided clear pathways for justice reform. Yet successive governments have failed to act on the overwhelming majority of the report's 339 recommendations. As a consequence, in the 33 years since the Royal Commission, at least 556 more of our men, women and children have died in custody in Australia. Part of what these failures highlight is that truth without justice is meaningless. If governments are not prepared to act on the truths uncovered by a national commission, then we risk replicating the failures of the past. The Uluru Statement from the Heart called for a Makarrata Commission precisely because past efforts, while significant, have been incomplete, inconsistently actioned or altogether ignored. The Truth and Justice Commission must be a mechanism for both truth and justice, ensuring that First Nations peoples are not only heard, but the governments, institutions and societies are held legally and morally accountable for righting historical wrongs and preventing future harm to our people. The anthropologist W.E.H. Stenner described Australia's national narrative as the Great Australian Silence, a deliberate exclusion of First Nations history, perspectives and truth from our national consciousness. The Uluru Statement from the Heart called for an end to this silence. Whilst First Nations peoples do not need permission to tell our truths, we've been doing so for over 200 years. What we do need is for governments, institutions and the Australian public to truly listen. The path forward must be led by First Nations peoples. Without real action and commitment, we risk repeating the failures of the past. But if we get this right, we can move forward beyond the Great Australian Silence and towards a truthful and a just Australia and a shared vision of the future that all Australians can be proud of. We look forward to engaging with the committee further and to answering your questions. Thank you.
Thank you very much. We'll proceed to questions. And Senator Cox.
Thank you. Can I thank you both for attending today and your submission to this inquiry. Within your submission, you've basically suggested that we take a bit of a different approach to this and that we look at setting up the Truth and Justice Commission that involves legislating a national truth body that would ultimately inform the design, purpose and scope of the National Truth and Justice Commission. Did you want to walk us through what led to the development of that and how you would see that working and why that essentially would be your preferred action that we would take as a committee to organise the process?
Sure. So we had the honour of working very closely with the Uluru Dialogues in responding to the inquiry, and it was very much from a First Nations rights perspective, starting with core principles, our inherent rights under the United Nations Declaration of the Rights of Indigenous Peoples. Whilst all articles are important, certainly the articles, I believe it's 3 and 4, around self-determination and free and prior informed consent, I think are critical elements of the proper design and development of a national truth-telling body. And it goes to the heart of why in our two-tiered model, we believe it would be more effective to begin with a national truth-telling body that's focused on supporting local community-based truth-telling processes as an immediate step to move towards likely a future statutory-based truth-telling commission with royal commission powers. Particularly a National Truth and Justice Commission, if it's if properly designed and fully empowered, it needs to have the potential to drive genuine structural and systemic reform, which is touched on in the opening statement. The risks of running a truth-telling process absent a genuine commitment from not just government but the wider community and engagement with the process to structural and systemic reform, to tangible change for our people, there are some risks that are significant, and there is precedent to show how that can be actually not disadvantageous, if that's a word. Yeah.
Okay.
It can cause challenge. Harmful is the word, thank you, that I'm looking for. So in our view, the Commission's role, it needs to go beyond the mere making recommendations and the production of documentation, and there should be a role, an ongoing role for that body that's not framed to a temporal period of 3 or 4 years where they actually perform critical functions in supporting local and state-based truth-telling processes and complement those, so it doesn't look to come in from a top-down sort of perspective and assert a position within a pre-existing ecosystem of truth-telling processes that, as I mentioned earlier, for 200 years our people have been telling our truths. It's just perhaps not in a structured a way, and the complexity and the sensitivity of those narratives, of those stories that need to be properly understood and responded to, can only really come from working with the grassroots, working from a community level, but equally leaving it to just community under-resourced and stretched individuals and community organisations is a major challenge where a state and national truth-telling process or body can really help connect and complement those activities and amplify those voices and those stories.
Okay. What the committee's evidence that we've heard this morning, thank you Mr Cansdale for giving us sort of that glimpse across that. What the committee's evidence has heard this morning is this real want for it not to be a top-down approach and having right representation and making sure that grassroots communities are involved in its design and scope and the outcomes from all of that, and how we link that to the broader policy initiatives such as Closing the Gap, which Antar were pivotal in securing what we now know to be the Closing the Gap agenda federally. But the importance of the tension between state and territory domain and what is the federal responsibility. And I suppose my question that I pose to Antar is, given that we, from a First Nations perspective, still don't have much in the recognition of sovereignty, how are we to achieve that in the way of ensuring that there's longevity in that process of bringing everyone on the journey in a way that doesn't allow us to get swallowed up into a broader agenda, because it's almost going to be like walking a tightrope where we've got Closing the Gap, Peaks and others coming at it from that direction, and we're trying to get a groundswell from our grassroots communities and our engagement, and we have things like the Native Title Act that absolutely provide some level of cultural authority, and yet we're asking people to tell their truths when we know how broken some of those systems are and the way that they have infiltrated, I think is the better word, and tried to demonise our cultural authority in that. How do we do that without it being attacked, and that we can maintain the political will to actually get this job done? Because we get a change of government and we don't see this have the longevity that it needs, and it gets knocked off course. How do we stop that from happening?
Yeah, it is a significant challenge, and one we've seen play out obviously very recently in Queensland and other jurisdictions. The security of, you've got the goodwill and the emotion and the pouring out of our truths from our people, which has happened historically many times, and the inaction that has flowed from the back of that, of which a couple of significant processes mentioned before, but there's many others. It is a genuine risk, but that is therein lies the rub of the model that we're really putting forward, the focus on working with community, working with individuals on the ground to reinforce, to make sure that the way the Commission is designed, or the body, and whatever its scope of roles and responsibilities of that body might be, it is informed from the ground up. And a further benefit of that is not just that it lends legitimacy, cultural legitimacy to that body, and it will, the idea is increase commitment and support from our communities, from First Nations communities, doing that relational work that happens at the local level, in community, at the local footy club, at the school, down at the pub, at the dinner table, where you're in a position where you can cut through some of the division and some of the othering that keeps us, everyday Australians, too much separated into our particular identity groups. I feel like you're in a better position at the local level, at home, where people are comfortable and they can start to see some of the similarities with the narratives, and we can start to build a stronger sense of collective responsibility. And that's a significant protective mechanism. If we start to bring more, it's critical actually, bringing more of the wider Australian community along in their understanding of truth-telling, what it is, the scope of truth-telling, why it's significant, and why it's not just relevant to Aboriginal and Torres Strait Islander people, but why every Australian that lives on Aboriginal land is intimately connected to and affected by these processes. The more that we can achieve that, we're then in a better position in future when perhaps there's a risk of political intervention or some other factor that might steer us off course. If we have more support and understanding and backing from everyday Australians and constituents, ideally there would be less inclination from politicians to decide perhaps to take the process in a different direction, because it wouldn't win as much favour. So really, it's part of that is also trying to protect the process from that future challenge and make sure that the commitment from our people from the very beginning is respected. And yeah, so it is a slower process. We understand it would take a bit longer, but
how long do you think?
Unfortunately, my crystal ball's not working too effectively at the moment. I asked it a few questions.
Sorry to put the weight of the world on your shoulders, but like that, we've given a time frame of 4 years for this bill.
Like, do we envisage that it would take 4 years, a term of a government, for us to actually get that traction and actually get that level of engagement that's required? I'm getting the evil eye from the chair, so I'm going to share the call in a minute. But you can give that to us on notice if you have any 2 a.m. thinking on that, which I bet you will. It will be helpful for us to understand maybe a bit more of that mapping out of the process.
Yeah, we'd be happy to, because some brilliant sort of pre-prepared answers there that I haven't dipped into. But just suffice to say, we're nearly 250 years into the colonial project, which I would say is alive and well at this very point in time, and the sheer complexity of that legacy and the impact it has on our communities, that's not going to be unwound in a few months or a few years. Building something which has a strong foundation linked back to international human rights and our rights as First Peoples, and taking full recognition of the recognition of the history in Australia, that is critical to make embedded in the national psyche, to make it a part of the future society, that vision for the future that we're trying to create. So it's not a point-in-time exercise or a statutory exercise or a political exercise. It's an exercise in bringing Australians together and creating a stronger future for all of us. And that's the kind of narrative that not we have to build, that should be built, and I think absolutely can be built, but it will take a little bit of time to bring everybody on that journey. Because we always talk about truth listening, but truth readiness and truth action is very much a big part of it from non-Indigenous Australia.
And just to reference your reference to the human rights component of that and UNDRIP, we have zero political capital right now, and will for any of the major parties to do anything in relation to our human rights. It's not a vote winner. Therefore, we're constantly putting UNDRIP in front of them. We're constantly putting human rights in front of them. Even as late as last week, you would have seen Senator Thorpe's bill that she put forward. That unless we get that, we're not going to move forward. So I'll leave it at that and share the call. Thank you.
Senator Little.
Thank you. Thank you for appearing today. I'd like to ask about the value proposition here in terms of, you're representing ANTAR. That's all about facilitating reconciliation. What I'm trying to understand is we've heard people talk about a focus on storytelling by individuals who might come before this entity, but also the actual legislation itself talks about taking recommendations to the Parliament. So there's slightly different tensions in terms of, what is expected to be achieved from it. I'm interested to understand, and we had evidence earlier that you've got what Aboriginal people and Torres Strait Islander people would see as not just the purpose, but what would flow back to them. What do you see in terms of reconciliation for non-Indigenous people to participate in this process, and what would flow back to them, and whose process is this?
Yeah, thank you, Senator. That's a really good question. I'd begin by saying, so it's really important to note, ANTAR, as a First Nations-led ally organisation, our entire remit for nearly 3 decades has been advocating fiercely for rights, justice and respect for First Nations peoples in Australia. I'm fully cognizant, though, that the First Nations individuals and representative organisations that you've heard from today and other days have both more of the lived experience and cultural authority to speak to various elements of the bill with far more weight. Where I believe ANTAR, we bring a unique voice and perspective, absolutely supporting and amplifying those views, and we work really closely with many of the stakeholders that have engaged in inquiry. But it goes to truth readiness. It's a concept I mentioned just before to Senator Cox, and it's in our submission several times. Truth listening and truth readiness. We talk almost entirely about truth telling, and that is critically important to focus on the need of our people to tell our stories. The reality is, though, a story told and no ears to receive that story potentially lacks substance, and it's missing a big part of the picture. So if you don't mind, Senator, I might actually speak to that concept in a little more detail, because I do believe that is something that we can talk to. Who are the key stakeholders here? Are we, who is on this journey of progressing towards a truth-telling body, and what the significance of that body is for wider Australia? So First Nations peoples, as I mentioned, we've been telling our truths for over 2 centuries, yet those truths often go unheard. As Amberlyn Quay-Molina says, there's things that Indigenous peoples have been saying for a really long time. It's just that those things have not been listened to. Truth-telling alone does not lead to justice. It must be truly heard, reckoned with and acted upon. This is the essence of truth listening, which requires non-Indigenous Australians to confront how they continue to benefit from dispossession and systemic inequality. Without truth listening, truth-telling risks becoming performative, offering a sense of catharsis without real structural change and reinforcing the idea that the injustices of the past have already been reconciled. In our submission, we define truth listening as a deeply unsettling political practice that demands action. It requires reckoning with ongoing colonial harm and working towards redistributing power and resources in ways that support justice for self-determination for First Nations peoples. The burden of truth-telling cannot rest solely on our communities. Non-Indigenous Australians represent 97%, give or take, of the population. And those individuals, wider Australia, as I mentioned before, it's a critical component of the effectiveness of truth listening and any truth-telling commission. They must be in a position to genuinely listen and to respond to those truths that are told meaningfully and in a justice-oriented manner. Without this, truth-telling risks being reduced to a symbolic exercise rather than the transformative process that it is intended to be and indeed needs to be for our people. This is why truth readiness is central to our proposed model. A national truth and justice body led by First Nations people could play a crucial role in preparing Australia, one community at a time, to move toward a culture of listening and action. A truth process undertaken in a society unprepared to listen risks being undermined by political resistance, co-optation and superficial engagement. As Gungala woman Dr. Lilla Watson and a fellow activist put it quite eloquently and poetically, if you have come to help me, you are wasting your time. But if you have come because your liberation is bound up with mine, then let us work together. A national truth process that prioritises truth listening and collective action, not just truth-telling, has the power to bring about real and lasting change. So to answer your question, Senator, every Australian has a stake in this process. Yeah.
Some of the indications in the act as it's submitted here suggests that it requires some sort of heavier legal involvement. It talks about lawyers being engaged by the Commission. There's a submitter that talked about having an experienced judge with a First Nations identity participating, which narrows it down quite a bit, right, unfortunately. Can you make any comment about whether that's actually the right approach, having legal people basically involved in this process as opposed to someone else with a different profession? Does it need to have a legal framework?
Do we need to let the lawyers near it? Is that what you're saying?
It's not come out very well when they've got near stuff.
Yeah, you're speaking to one here. I know full well how that works. Look, I understand the heart of this needs to be our community culture and country and our kin, our inherent rights to self-determination and to be strong as sovereign peoples on our land. At all times, that's what this is about. The reality is, though, we don't live in a pre-1788 Australia. We live in a deeply complex colonial nation state with really complex legal and political institutional frameworks. And to be successful in progressing, standing up a body of this nature, dealing with such a complex legacy, I think it would be, what's the word, the opposite of astute. It would not be astute to ignore the legal complexities and to ensure we have the appropriate subject matter experts helping guide the design and development. I would hope, I actually know for a fact, there are a lot of incredible black lawyers around Australia that would be well positioned, I'd say, to be involved in that early consultation process to determine exactly the nature of the body that should be stood up and to anticipate some of those risks, future risks, be it political challenge or legal challenge perhaps, and some of the substantive reforms that you would expect to come out of the back of a national statutory truth-telling process. It would only be wise to use one's crystal ball to anticipate what those might be and think about the legal arguments and some of the challenges to lay the path to get to those places, which I haven't been privy to the process in Victoria with the York Justice Commission working with the First Peoples Assembly of Victoria. Had a couple of exposures and it's amazing what they're doing down there. I could only imagine they had some pretty great legal advice and also economic advice, financial advisors about you know, when money comes in, presumably will at some point, how to manage that, political advisors about how to best set up self-governing bodies to effectively manage that power, about the shift of power and authority that hopefully would come through a treaty process.
So how does the tension between, you know, we've heard as part of these hearings, we see a lot of people in the list of people participating that come from organisations that are sometimes very well resourced, sometimes not, in terms of responding to submissions. How do we have a process that ensures that the discussions, the recommendations aren't simply captured and communicated and influenced by organisations that are often at the table, and how do you manage the conflict between some of those organisations that are currently established, who would see themselves as bastions and experts in their key areas of work and having power and influence in the debate? How do we make sure that those organisations don't dominate a process that from which we're hearing should be a process for not just Indigenous people but non-Indigenous people?
Well, that last bit, whether it's a process for First Nations peoples, but involves intimately every Australian, and would reshape, if effective, would reshape, you know, a sense of identity and sense of place and sense of collective belonging of the entire nation. So in that sense, it is for everybody. But at the core, at the heart of it, is identifying and making good on past injustices that still have unresolved, are destroying our communities. The overrepresentation of our people in all the wrong places is not something that's going to be addressed by playing on the edges of reform. We need really transformative, structural and systemic reform, and that comes from really powerful prioritised investment. So prioritised investment in really powerful, large-scale processes like a National Truth-Telling Commission. How do we, to your question, Senator, of how we oh, geez, lost my track of thought. How do we ensure?
Dominant players aren't.
Dominant players. Yeah, thanks. Sorry, Senator. Yeah, thank you, Jess.
Yeah.
So if you look at the Coalition of Peaks at the moment, right, we've even got them being asked about economic development. They're health organisations representing 800 health organisations and others. There's a couple of others in the mix, but there are other groups that are in the business of business and have been very successful. How do we actually make sure that some of those key players in this space are not dominating the conversation, and others who should be in there then step out?
Yeah, no, so thank you, Senator. I think it comes back personally to the free, prior and informed consent and the nature of the consultation that needs to be undertaken with our communities, starting from the community level, respecting pre-existing self-governance mechanisms, much like the model, as I understand it, of the voice that was proposed, rather than standing up a top-down or unilaterally saying this is what, you know, starting fresh like blank canvas. Okay, well, what can the voice, how can it be constituted, how is it regionally representative? The starting point is going to be within its various states and territories, what are the existing self-governance mechanisms? I'm more familiar with New South Wales, so a prominent part of the self-governance mechanism in New South Wales is the New South Wales Land Rights Network. So coming in, and whilst I understand there's a myriad of representative organisations, and it is incredibly important, a process like this considers all of not just individual and collective rights to be involved in the process, also the importance of every community feeling represented by the process. That is why we're really emphasising in our submission the localised truth, community-based truth-telling, starting with a really effective and rights-based approach to consultation that will build those relationships. And that national body itself, in fact, if it is decided that, look, a more of an ongoing national truth and justice body initially, rather than a truth-telling commission, statutory commission, royal commission powers initially, that might be a subsequent step. That body would do the relational work. It would work in with the community existing truth-telling bodies, and it would support them and provide scaffolding whilst also gaining critical insight about what's going on already, what are those governance mechanisms that exist in the different areas, and would put us in a phenomenal position right now to answer some of these questions around, well, okay, well, how do we design the Truth and Justice Commission? How do we engage commissioners? What's the scope of roles and responsibilities? The idea is we can do great work in the immediacy in supporting truth-telling at a community and state level, and at a critical point where a decision's made, yes, a Truth and Justice Commission needs to proceed. We've got stronger relationships with key communities and individuals, greater insight around how to set that up effectively. And there still will be obviously a consultation process, a design process, but it wouldn't necessarily, but we're not starting far from blank canvas. We're starting fresh. We've probably got a shorter sort of process we can go through, and then strengthens the legitimacy and the support for that body once it is set up. So that was part of the thinking around a national body to do that work at the local level.
Thank you, Senator. You talked about the importance of people being ready to listen, and you're in the business of working with allies. What are the things, I suppose, that this commission or the kind of preparatory work that would need to be undertaken before, or at the same time, I'm not sure, but like, what is it that we need to do to get people ready to listen?
Yeah, that's a question. So I won't profess to have the answers to that right now. It's a really difficult, I'd say at the forefront for us as a First Nations-led ally organisation, where the way in which we envisage our unique value proposition, the ANTAR, is to actually be working with allies to build their awareness, build their capability to advocate on behalf of mob. And at those critical moments, like 13th October 2023, we've got a critical mass of Australians that understand the challenges we're facing, equally understand the beauty of our culture and the strength of having us come closer together and forge a much stronger future alongside each other. And they protect processes like, say, a National Truth and Justice Commission, and indeed they even demand it. They don't just protect it, but it's allies.
It's happening in New Zealand right now, where there's just thousands of people coming out and rallying on the streets, essentially. Yeah, and not that I'm advocating for that, but those are the kind of things that, do. That show that kind of unity and strength. And absolutely, and invisible. And so the big thing around this for us is narrative. Creating that narrative that changes hearts and minds. It can really cut through just the craziness of contemporary life. Everyone, I think, is exhausted. Really, the majority of individuals in Australia are being let down by current systems, and it's harder, I think, to connect with people in their houses when they're hard up, focused on paying the bills, finding jobs, keeping jobs, looking after their kids. So we're at the press with the coal face at the very moment of trying to figure out what is that way to do that community-based relational work, and what is that strong narrative. What are the visuals, the ways to connect with people, so you can start to re-story not just our shared things that you found in kind of ANTAR's experience work in kind of bringing in new people to on the journey, because I think one of the challenges that we've got in the I suppose in the kind of First Nation space is often we're preaching to the converted. How do we engage new audiences in the things that we're doing?
Yeah, I was just going to jump in on the back of what Blake said and your question about, how to build that truth readiness as a non-Indigenous person working under First Nations leadership. In many ways, that's like a microcosm of the larger relationship we have in Australia, right? Like, how do you ready the 97% to not only listen to the 3%, but be prepared to ask yourself really hard questions about the ways you benefit from dispossession, historical and ongoing, and what your responsibility is as a settler in dismantling those systems that continue to oppress. And I think that's exactly what this work is. First of all, you can't be speaking if you're listening, right? Like, if you want to cultivate truth listening among non-Indigenous people need to stop talking so much and listen, right, to create space, and then to do the hard, probably in the beginning, largely internal work of dismantling ways of thinking that they're everywhere. They're in our education system. They're all around us in our institutions. And I mean, I know that sounds abstract and it sounds difficult, and that's why we're saying
But for my
this
mind,
work
that sounds like the advanced class. I suppose. I mean,
yeah, for sure.
What's the soft entry?
Well,
because that is like they're really tough kind of internal questions
Yeah.
you need to ask yourself, and I feel like even the best of allies aren't good at doing that. What are the soft entry points? And maybe it is with tourism and kind of people being able to celebrate the uniqueness of our incredible country and what we've got to offer as the entry point for people to then learn about the injustice.
Yeah.
But I think for me that sounds like definitely the advanced class. As
Sure, yeah, and
entry.
admittedly, like, this is generational work, and we say that, you know, this is not going to happen not only in 4 years, but probably not even in one generation. This is deeply transformative, unsettling identity work. But yeah, I mean, you make a good point there. There might be multiple entry points in terms of engaging with First Nations culture, you know, in maybe initially ways that are perceived by settlers to be less threatening, and that might be, you know, the beginning of a journey in toward understanding much deeper systemic issues that are more confronting for most Australians.
I think, I feel like there's certainly been, this is anecdotal, but you know, examples of, you know, people in kind of my extended friendship group who didn't get their education in this classroom, but their kids are. And so that's actually a pathway, like that's an entry for them to say, hey, I didn't know these things, my kids are learning this in school now. So the education system is slowly catching up. It's not everything that we want it to be, but it is a soft entry for people who otherwise wouldn't actually be that interested.
And I gave myself and the team, I guess, a little bit of an out. I felt a lot of pressure that we need to reach ANTA as a national body, and I guess the same stands for state bodies. Need to reach everyday Australians. We literally need that narrative, that way of connecting, and the relational work needs to happen from us to those people, all Australians. But I don't think that from an operational, from a practical sense, it necessarily is correct. I'm leaning more towards now the systems that are in place. There's different networks. You've got First Peoples Assembly Victoria doing a great job of building a ally offshoot, or I'm not sure what they call it, but like an extension, because they recognise the importance of socialising the amazing and important work they're doing down there with the wider Victorian community. So they come on that journey. South Australia just had one of our supporters at ANTA reach out and mention they got a South Australia Allies Network, which is a connection of, I'm going to say hundreds. I feel like they've got quite, it sounds like a lot though, because they've got a lot of different community reconciliation groups and different kind of groups that they've brought together. Similarly, you've got the REC New South Wales and REC Victoria. Groups like that, I think that makes more sense that ANTA, we position ourselves to understand what kind of supports and tools and touch points can we help create to bring that collective together. And they're the ones, and similarly, our ACOs and our organisations within community, they've got the relationships with our people. They're the ones that have the trust, they're the ones that have the understanding for us to try and develop, and putting aside whether it's appropriate or not, culturally appropriate, to spend the time to try and develop a platform that we can do that work effectively. I don't think that's the place of necessarily a national or a state-based body. It works with the existing relationships within communities, existing governance mechanisms, networks. I think the same applies for the ally side of the equation too. It's the way that we can build awareness, disseminate information, and ultimately mobilise that collective at key moments in our history. Yeah.
And local truth processes do that kind of restorying, right? When non-Indigenous people are in a room, in relationship with and exposed to First Nations truths, that sometimes is a catalyst for rethinking and for humanising a story that might otherwise have been ignored, compartmentalised, not heard at all, which I think is a big part of this model, is creating and resourcing those opportunities in local communities for those interactions to even happen.
Absolutely. I've definitely got more questions, but I need to share the call. I'll go to the Deputy Chair, Ms. Price.
Thank you, Chair, and thanks to Blake and Jessica for being with us. Given time is short, I'll just squeeze one question in. I'm particularly interested in the practicalities of how the Truth and Justice Commission would operate to make sure that it is meaningful. And I note that in your submission, you suggest that the Commission be trauma-informed and culturally safe. I think we'd all agree with that. So with the small amount of time that's left, can you give us your thoughts on what's the type of environment that we might create which is culturally safe for people to be able to, to be able to speak their truth? and what's the type of support we need to be providing individuals at that time and perhaps after the providing of the truth. Thanks very much.
Thank you, Senator.
No,
Miss
I'm not a
Martin.
senator.
Sorry, thank you, Miss. Okay, Deputy Chair. Thank you, Deputy Chair.
50-50.
Not everyone has the privilege.
Melissa Price is my name.
Oh, yeah. And apologies to the transcriber. I realise I haven't saying my name before. Sorry, I think it's you.
That's okay. I get it. You're the guy out of the two. Yeah. All right.
Yeah, good call. Yeah. So, Deputy Chair, not in the interest of time, but it does work to that extent. I would have to say I don't believe we're in a position right now, nor the appropriate entity to speak to what safeguards need to be put in place to ensure that our people are supported, heard and protected, and there's a cultural safe space and a trauma-informed space. We absolutely know the critical importance of having that as a foundational aspect of standing up anybody that deals with truth-telling. It would would go to the heart of the truth-telling process, but it's not it's not our area of expertise. So I know it doesn't give you a great deal there, but I'd probably be reticent to speak to specifics about what that looks like on the local level. That I wish I had any number of examples right now, but the one that comes to mind is Sister Girl Tiffany McComsey, the CEO of Kinchler Aboriginal Boys Home Corporation. I'm sure Tiffany will give a phenomenal answer as to how they do truth-telling at a community level and have those practices deeply embedded within how they do what they do. And
okay.
Yes, so that's...
Okay, that's fine. But I won't get you to rack your brain any longer. That's fine. Okay, thanks very much. Thanks, Chair.
Thank you. All right. Now my job is to thank you for attending here this afternoon. If you've been asked to provide any additional information on notice, would you please forward it to the Secretariat by the 5th of March? You will also be sent a copy of the transcript of your evidence, and you'll have an opportunity to request corrections to any transcription errors that are there. Thank you very much.
Okay.
We'll take a short suspension while we welcome our next witnesses. If we can please take the conversation outside.
Oh, I'm so sorry.
No, you're good.
I thought you said to mingle.
I feel like we don't have sure. Oh yeah, online, don't we?
Yeah.
Oh, great.
It never stops.
We will resume, please. I now welcome our next representatives to give evidence today. For the Hansard record, would you please state your full name and the capacity in which you appear before the committee? I might start in the room before I go to those joining us online.
My name is Dr. Alexandra Gray and I'm a researcher at the UTS Faculty of Law.
Thank you very much. And then I believe we've got Dr. Morris.
Hi, my name's Dr. Shireen Morris. I'm an Associate Professor at Macquarie University Law School.
Thank you very much. And do we have Mr. Hobbs, Dr. Hobbs?
Yes, I'm here too. Thank you. My name's Dr. Harry Hobbs. I'm an Associate Professor in the Faculty of Law and Justice at the University of New South Wales.
Excellent. Thank you very much. Now, although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. To assist with the transcription of the public hearing and to make it easier for those of us joining online, it would be helpful if you could please state your name before responding to each question. I now invite you to make a brief opening statement before we proceed to discussion.
Nini Nalawangun.
Yeah, I was going to say, we'll start in the room, sorry.
Nini Nalawangun Murray Badri Gadi Nirada. I acknowledge where we are in the language of the Sydney Basin, as taught to me by Professor Jackie Troy. I'm an academic researcher and one of Australia's few dual academic experts in linguistics and law. In general terms, through my research, I aim to expand public knowledge about injustices which language policy redresses or, at times, aggravates. I support the establishment of a version of this proposed Truth and Justice Commission, and I'm here to suggest some straightforward but meaningful areas for improvement in regards to the language policy and language practices of the institution proposed in the bill. The first is to proactively facilitate the use of Aboriginal and Torres Strait Islander languages in the Commission as one aspect of improving cultural safety and modelling a concrete practice of redress for centuries of government harms to cultural and linguistic vitality. Second, proactively facilitating Indigenous language could include expressly allowing people to appear using the language of their choice under Section 11.2, and by employing Aboriginal and Torres Strait Islander language interpreters under the existing Section 30 staffing provision. And third, include a requirement to transcribe contributions made in Indigenous languages on the record and to record the name of the languages used. These three suggestions align with Article 13 of the United Nations Declarations on the Rights of Indigenous People, endorsed by Australia in 2009. Article 13 relevantly provides that 1. Indigenous people have a right to revitalise, use, develop and transmit to future generations their languages. And 2. States shall take effective measures to ensure that this right is protected and also to ensure that Indigenous peoples can understand and be understood in the political, legal and administrative proceedings where necessary through the provision of interpretation or by other appropriate means. In perhaps a rare moment of UNDRIP traction, this aligns with Australia's current Closing the Gap Target 16, which is that by 2031 there is a sustained increase in the number and strength of Aboriginal and Torres Strait Islander languages being spoken. And this is a current government priority. Priority Reform 2 for this year, in the Closing the Gap plans released just last week, includes progressing the languages sector strengthening plan. Let me give you an overview of the diversity of language use in Australia based on the most recent National Indigenous Languages Report, which was published by the Australian Government in 2020. There are at least 123 Aboriginal and Torres Strait Islander languages still spoken across Australia, with 12 passed on to children. At least 30 languages are seeing intensive reawakening work by their communities and declared languages spoken at home by the Australian Bureau of Statistics. Many on this inquiry panel may already realise, but in case not, there are in Australia not only traditional Aboriginal languages, but also Aboriginal varieties of English, which are systematically different to the standard Australian English you and I and most government institutions use. There are also languages called new, Indigenous languages, which are systematised and intergenerationally used varieties that have emerged from contact between two languages, usually English and a local language, such as Creole, spoken in Northern Australia, and Yumplatok from the Torres Strait. These new languages actually have the most speakers, and the number of their speakers is growing. When any of these Indigenous languages are not supported, their speakers are excluded from institutions. Many of the submissions I have read point out that the cultural safety provision of the Commission are so far inadequate and need to allow for more diversity and localisation. Most call for increased co-design, which I support in general and in developing my own language-related suggestions if the committee were to take them up. In short, my three key suggestions are: 1, to facilitate the use of Aboriginal and Torres Strait Islander languages at the Commission; 2, to properly record such language use; and 3, to treat this institutional support for languages as part of improving cultural safety and of performing deeds, rather than only words, of redress. It could be an example for other government forums. Revising the Truth and Justice Commission Bill is an opportunity to treat the speakers of Indigenous languages better. Creating a forum which institutionally supports the public use of Aboriginal and Torres Strait Islander languages is important beyond facilitating access to the Truth and Justice Commission for individual speakers.
Thank you. And I'm just checking online to see if anyone else there wants to make a contribution to the opening statements.
Harry, would you like to say something?
Yeah, I can say something. Thank you, Shireen. Well, I'd also like to show my respects and acknowledge the Bidjigal people who are the traditional owners of the land on which I'm calling from, and to elders past and present. And I'm happy to keep my opening statement relatively short. I support the principle of the bill, but along with Dr. Shireen Morris, have some concerns with the current draft. Truth-telling processes are important mechanisms for all Australians to gain a better understanding and appreciation of the impacts and effects of colonisation on this continent. Major public inquiries in Australia, such as those into Indigenous deaths in custody and the stolen generations, demonstrate the value and significance of truth processes. These inquiries penetrated public consciousness and drew all Australians, Indigenous and non-Indigenous, closer together. They help non-Indigenous Australians understand the experiences of and empathise with Aboriginal and Torres Strait Islander peoples. In this way, they not only helped Australians come to terms with troubling aspects of our past, but provided a rationale for legal and political change that would help build a better future for all of us. As this suggests, however, truth-telling must be done for a purpose, and two key points stand out. First, public processes of truth-telling need to be more than an idle historical exercise. They need to be directed in the here and now, drawing a bridge from the past to the present to identify and explain how processes of colonisation continue to reverberate today. That is, how the destruction of country and the displacement of community contributes to the socio-economic gap between Indigenous and non-Indigenous Australians. Second, public processes of truth-telling must be geared towards action rather than sitting books and reports on dusty shelves. And as I'm sure you've heard today and in previous hearings, Aboriginal and Torres Strait Islander people do not merely ask for truth, they also ask that non-Indigenous Australians do something with that knowledge. Truth-telling is not merely about a historical record, it's about working together to build a better future. These points are recognised by the Uluru Justice Commission of Victoria and the Makarrata Commission as envisaged in the Uluru Statement of the Heart. This bill recognises the first point, but it does not connect to a broader project of reform. In short, it does not give Indigenous Australians, and indeed all Australians, the confidence that anything will happen with the evidence that it gathers. And for this reason, whilst Dr. Morris and I support the principle behind the bill, we are concerned that in detaching truth from justice, it will fail in its goals. Thank you.
Thank you very much for those contributions. We'll now proceed to questions, and we'll start online with Deputy Chair Ms Price.
Thank you, Chair, and thank you to our witnesses. This is directed to Dr. Sorry, I'll just get myself off speakerphone. This is directed to Dr. Gray, and appreciate the words you've already said, but I understand that in your submission you're recommending changes to Clause 8 and 11 regarding language, culture, identity, health, etc. I wanted to sort of understand what you think the challenges might be relating to that, to ensuring that transcriptions that they do capture the relevant Indigenous language that's been used to be able to provide the evidence. And then further, what are the challenges with respect to the storage of that evidence? Thank you.
Thank you. Look, in response, I think we could focus on two kinds of challenges. One is a, if you like, more technical challenge of accurately recording the content of the language. This is a challenge that Hansard has already been dealing with and dealing with quite well. It has, at the Commonwealth Parliamentary level, at the state level, in Commonwealth Parliamentary hearings, really improved the capacity to identify the particular language being spoken and to record the content rather than simply eliding the content with a phrase like the member for the Kimberley spoke Gidja, something like that. Now, the actual content is often included. I note in the room we have, but not as a witness, Annika Myers, a researcher from ANU, whose doctoral research underway at the moment and reported in her own submission under number 125 is about the Hansard technicalities and the guidelines for transcribing Indigenous languages. So those technical challenges can and are being dealt with by Hansard staff. There is a related challenge in naming the particular language because, as with non-Indigenous languages, there can be more than one name for a language or in fact no name for a language. Where the boundaries between different varieties of ways of speaking lie may be different for different groups. And this is part of a broader understanding of self-determination, but on a very specific level, to let the person speaking name the language as they wish to name it. The IATSA Centre for Australian Languages has a large program already established for coding Indigenous languages using what are called the AUSLang codes, that's AUSLANG, and those codes are a really stable set of identifiers to use as metadata and as the names, if you like, in language naming. So that sort of technical challenge can be addressed. I also do research on the use of Indigenous languages in parliaments around Australia. And in that respect, I have noticed that some parliaments deal with the process of Indigenous language use in different ways, and one of the ways is to require people speaking an Indigenous language to give advance notice and provide an advance transcript. That's a very onerous and contentious way that has not been popular in the Northern Territory Parliament, for example. Another way, similar to the proceedings here today more generally, is to allow the post facto completion of the Hansard record. So that is another way to allow speakers who use Indigenous languages to speak as they wish and then to ensure that that record is accurate after the fact. That, I suggest, is a lower threshold and a more welcoming approach. I've also seen in the other submissions that the First Peoples Assembly of Victoria, in their very helpful submission about the York Commission, has described the staff that they call truth receivers. And they have a role that goes well beyond language assistance, but I suggest that a kind of truth receiver with a focus to deal with language issues and to assist in the multilingual giving of evidence and participation in proceedings might be a really practical way of overcoming some of the disinclination or hurdle or exclusion that people might experience at this commission, or not experience but fear based on their experience of other government processes.
Okay, that's very helpful. Thank you, Dr. Gray. Thank you, Chair.
Thank you, Deputy Chair. I'll now go to Mr. Perrott.
Thanks, Chair. And my questions are to Drs. Morris and Hobbs. And I note that your submission suggests establishing a Makarrata Commission before a Truth and Justice Commission. Can you please elaborate on why you would make that preference?
Harry, perhaps I can jump in on that. It's Dr. Shireen Morris talking. The point that we make in our short submission to the committee is that this should be a uniquely Australian process. And we think that it is integral and key that Indigenous people, through the Uluru Statement from the Heart, asked for not only a voice guaranteed by the Constitution, but a legislated Makarrata Commission to supervise both truth-telling and agreement-making. So in our view, we shouldn't be seeking here to just copy what happens in other countries, but it would be great, we think, to give this a really Australian flavour. And what better way to do that than by doing this in the way that Indigenous people asked for in the Uluru Statement, incorporating an Indigenous language, and I wholeheartedly agree with the former speaker's comments on the importance of integrating First Nations languages in any kind of Truth and Justice Commission. So, of course, we know the word Makarrata is meaningful, but the fact that that suggestion came from Indigenous people, I think it's a great opportunity to take that up. But the final point I would make is that, what a Makarrata Commission entailed as envisioned by the Uluru Statement, it spoke about both truth-telling and agreement-making, not just truth-telling, right? It talked about a Makarrata Commission to supervise both truth-telling and agreement-making. And that's the key concern that we raise with this bill, is that it sets up a process for truth. But what about the justice? Where are the mechanisms to ensure that justice flows from the telling of truth? That's what's missing. And as Dr. Hobbs said, Australia has had truth-telling processes in the past. Too often, the recommendations that flow from those processes end up gathering dust, unread by most Australians, unimplemented by most Australian governments. For this to be meaningful, it's got to be fundamentally different. And we think that it should be, if a truth-telling process is to be pursued, it should be structurally conjoined with agreement-making processes that allow the parties to work together to make right the wrongs of the past.
So with that in mind, I note that you suggest amending the terms of reference to incorporate a local and regional focus to the truth-telling and agreement-making. Can you elaborate, and without the risk of getting into the legal side of things, what sort of, should I use the term treaty, what sort of legal arrangements, what sort of legislative arrangements, and you're talking to a federal committee, not a state committee and not a local government council?
Harry, do you want to speak to that, or should I?
I can speak to that.
Sure.
So this is Harry here. It's a really good question, right? But I think we need to again be guided by the voices and interests of Aboriginal and Torres Strait peoples. And you would have heard today from Megan Davis and Gabrielle Appleby, who were intimately involved in the regional dialogue process, that Aboriginal and Torres Strait peoples in the regional dialogue said that they wanted a local and regional-based truth-telling process. They envisaged a Makarrata Commission that would oversee that and support that and facilitate it, but wouldn't be directive, wouldn't be top-down, and wouldn't be kind of geared from the national level onwards. And so I suppose what would it look like for the federal government to engage in or to develop a Makarrata Commission, a national truth-telling and truth and justice commission? I would say that it would offer facilitative and supportive processes. And so it could develop a structure, a framework that can be bought into by communities and regions who are interested in doing and pursuing truth-telling processes. Thankfully, I suppose one of the advantages in Australia of being quite late to the party, and this is that there are a lot of examples around the world to draw on, including even the states and territories. We saw Victoria and Queensland that had started to do process like this. Victoria is still going. But of course, we need to take what is relevant and what is useful and what fits within our constitutional context. And for the federal government, that will look quite different from other places. But certainly I would see it as a more facilitative and supportive role.
So,
could I add something?
Sorry, just if I could add, does that mean supportive as in financially creating the opportunity for entities to come together, let's say native title and or local mob, to come together with local and state entities?
So do you want me to continue, Shireen, or did you say you want to jump in there? Sorry.
Oh, I just wanted to add to what you said, Harry. It might help answer this follow-up question, is that in our federal context, it would make sense to have all the parties at the table for agreements that really make a difference. you know. So you would, in an ideal situation, you would have the federal government, the state or territory government, perhaps even local governments, sitting down with the regional or even the local First Nations groups. And in the article that we've attached to our submission, we kind of sketch a picture of how that might work, you know, with, as Harry says, perhaps commissioners from the Makarrata Commission would go out to the region and play a supportive, facilitative role with the assistance of other experts. But it would be very much a local and regional process of truth telling, you know, talking about historical moments, things like that, the impacts on the various parties, which could then flow in. And ideally, perhaps the legislation could even encourage that should not be the end of the process. The documenting of the history should not be the end of the process, and which would flow into stage 2, which could be agreement making. And then again, the Makarrata infrastructure, the commission, or perhaps an office attached to the commission, could again play a facilitative role in the agreement making. So a mediating kind of facilitating role. So in my mind, I sort of imagine this as being a sort of umpire body that really encourages the parties to come together, talk, negotiate, figure out the terms of a fairer future relationship, you know, learning from the history together, discussing the history, but more importantly, setting out, negotiating the terms of a fairer future relationship. And that requires all parties to be at the table.
Dr. Morris, Dr. Morris, Dr. Hobbs, but not the National Native Title Tribunal. Is this a different level of proof? And because that seems to be a slightly different proposition. Are we talking about something parallel, or it does sound like a bit optimistic rather than practical?
Well, the National Native Title Tribunal has a particular function, right? That it's engaged in land justice processes. And we see this as being a broader process that looks beyond land to, you know, if you're going to look at it, the full gamut of what a truth-telling process would include, it would include things like cultural redress. So there would be state apologies from third parties perhaps. There would be aspects of financial compensation. You may say this is optimistic, but again, this is something that exists in Canada, in New Zealand, and has existed in the United States as well, our neighbours. So it's similar to the National Native Title Tribunal, but broader, I'd say.
Sorry, I know they're common law countries, but in all of those countries you mentioned, there is treaties, not a different legal process that we have, which is...
There is, but in many cases they don't relate to the historic treaty processes. In Canada, there's been a long history in the last 50 years where they're negotiating modern agreements with the First Nations that never signed treaties. And so the British Columbia Treaty Commission, for example, is a continuation of historic practices in Canada, but it's an entirely new and novel institution that does not relate to historic treaties. And so the framework is very similar in Australia, where the framework of colonisation in British Columbia was that First Nations had no rights to land. The government has changed its position and the courts agreed, and they've embarked on a new sort of mature relationship, I suppose.
Thank you. Thanks, Chair.
Mr. Brown, I understand that Dr. Gray has got something to add to the previous question. Is that right?
Yes, thank you, Senator Stewart. The question from the Honourable Melissa Price MP on practical difficulties. Upon reading my notes in front of me, I realised I had a second paragraph that I just wanted to mention if it's still of interest. So I had flagged in my answer 2 kinds of technical difficulties. One was with the content and the naming of the language, which I spoke to already, but the other is qualified staff to do the interpreting. And I have spoken to this briefly in my own submission, but there is scope under the existing bill for employment of staff. I suggest that be expanded, or the bill be directed specifically to interpreting staff as part of the Commission's set of human resources. There is already a body of literature around Australia on 2 related aspects. One, the difficulty of pathways to qualified interpreting in Aboriginal and Torres Strait Islander languages, and secondly, the need for paid employment that relies on Aboriginal and Torres Strait Islander language skills as a sector to develop. And so in this regard, there is an opportunity for the Commission to further those pathways to create more of that employment. I also just wanted to mention briefly on this overcoming these technical challenges, which, as I have said, I think can and are already being overcome in other parliamentary bodies. This may relate to Senator Little's question in the earlier part of this afternoon on getting more voices at the table, actually allowing for people to properly participate in the language that they feel either is their best language for expressing themselves or the language most appropriate for expressing this kind of truth-telling content is, I would say, a really practical way of overcoming one of the hurdles to having more diverse voices at the table. Institutional processes in Australia are very monolingual for the most part, and that may be one of the reasons why we do have a domination by certain voices at the table other than others, although I would note there's a lot of effort in some areas to expand that. I'll leave it there in case there are further questions.
Thank you. I'll now share the call. Senator Cox.
Thank you. Dr. Morris, Dr. Hobbs and Dr. Gray, and thank you for your submission. You touched on in your submission, and I know that I think it was Dr. Morris just mentioned the use of the word Makarrata in relation to the importance of bringing agreement making into the concept of the Truth and Justice Commission. And just picking up your point there, Dr. Gray, around ensuring that we have not only the resources but also the appropriate qualified people who can do the translation of language, given what we know about Indigenous languages, around there are some words that aren't translatable into English or into other languages. But there is a concept of what we as First Peoples know in relation to what we mean when we talk about it in the context or in the frame of explaining. It could be about country, it could be around kin, it could be around time and the essence of time. But I'm just interested in your reference in particular, in which you placed emphasis on the use of the word Makarrata. Did you want to say any more about that specifically?
So that was Dr. Morris who placed emphasis on that.
Sorry, Shireen speaking here. Look, I think I've said it already. You know, that request, the request for a Makarrata commission, which is a variation of what this bill is talking about, came from Indigenous peoples. I think it would be fitting and an honourable thing for the Australian Parliament to do would be to build on that approach and to obviously design the institution in a way that has the First Nations of Australia as equal participants. And what better way to show cultural recognition and respect than by using a word that comes from Indigenous Australians themselves. And as you've mentioned repeatedly throughout this session, the importance of incorporating one of the original Australian languages, you know, one of the most ancient Australian languages in the title of the Act and the title of this institution, and a word that speaks to reconciliation, that an Aboriginal word, I think, would be really symbolic, and it would be getting the institution off on the right foot.
May I speak to that question
Yes.
as well, Senator Cox?
Yeah.
Yeah. The question you raise, or the issue you raise about the difficulty of translation of concepts, is something that occurs between any two ways of speaking, but it is particularly profound, I agree, in the Australian context, because there is such an epistemological separation and such a history of disempowerment of certain knowledge holders and certain concepts. And so, in fact, while perhaps there's not a direct equivalence between just one word in Noongar, for example, and one word in English, the beauty of all languages is that you don't have to use just one word. You can take the opportunity in translation and interpretation to explain the underlying concept or the meaning, the kinship relationship, the embedded relation to country of a particular term, for example. And people who are in a position to speak Indigenous languages, say in Parliament or in public, do this often. They use what we might call an expansive interpretation rather than just a very narrowly constrained interpretation. And so on a practical level, there is an opportunity for an interpreter in a commission such as a truth-telling body to take that expansive approach. And the flow on from that, I think, is that then through the mere fact of using different languages, you also then have a channel for these different epistemologies, these different knowledges and concepts to actually come into the discussion because a particular word, a particular anchor, if you like, came up in the discussion. And Makarrata is perhaps a really good example. We don't translate it into one English word. We translate it as a coming together after struggle. It is a particular word.
That's disputable.
Okay, sure.
Dr. Gray, from
sure.
the Prime Minister's point of view. He
Point
may
taken.
not actually interpret it in that way, and I think that that's the point that we get back to, is that it's intended in a particular way, and I think it's a gift.
Yes.
And I think that everyone can agree that as part of what happened in the Uluru Statement from the Heart. It was a gift to the nation to then understand and try and unpack what Makarrata means is then openly interpreted in a different way. And I think we've seen that as a political football, and we don't want to go back there. And so rather than us get bogged down, sorry to cut you off, but I'm just concerned that language and the use of language in the way that we want to see just outcomes for all First Nations people and to move the dial for reconciliation and healing in this country is such an important just outcome, I think, that we can all agree we want to do. It's our pathway to get there. And I think the language you use is ever so important to ensure that we all have a shared understanding of that meaning and making sure that we progress that. Yes, sorry.
Can I reply? Yeah, I agree, and I also agree with your disdain for the political footballing over the particular term. But I do think it is overall very important that we have that as part of the public Australian discourse. That word, even that contest over its meaning, allows for important Aboriginal interpretations of that word to have more space than they ever did before. And I think it's actually, at least from my perspective as a researcher, and I would be very happy to to acknowledge that I'm not the only person with a kind of authority here, and there are people with different cultural authority here. But in what I can see through my research lens, for the most part, the use of Indigenous languages in Australia in public forums does not become a political football. It's the exception rather than the rule. So, for example, coming back to my study of parliamentary language again, we have seen across Australian jurisdictions, the parliament in which you all sit and in others, increasing use of varied Indigenous languages. And this, on the record, appears to be celebrated across party lines. In fact, propositions to support Indigenous languages come to the Parliament from across party lines. And so this perhaps is, to use Senator Stewart's phrase from earlier this afternoon, one of those soft entry points to people seeing different points of view and being able, as non-Indigenous people, to become more ready to listen. There is, in general, if you like, a celebration of linguistic diversity and interest, a sort of happiness to hear that aspect of culture. It is not for all and not at all times, but often taken in a more celebratory and less threatening way.
Within the submission that you made, you've also talked about the inclusion or including text in the bill around health, healthcare and wellbeing. Can you explain to us why you think that's important?
Yeah, sure. Look, I put this in to preempt that there might be more that people want to talk about that's sort of related to health and healthcare, but which we might think of more generally as wellbeing. And I base this on a history of a number of government reports that have really brought to the fore this concept of wellbeing. In my own submission, I reference even the Federal Treasury now has its own sort of its own concept of how to measure wellbeing based on Indigenous knowledges, and from a number of Indigenous researchers and health organisations and community organisations, there has also been a history of explaining how wellbeing is both wider than health and healthcare and perhaps not as Western. It doesn't have to be as Western in its knowledge. And so my particular own connection to that research is work I did under the leadership of Indigenous colleagues from the UTS Jumbana Institute on well-being in relation to language revival for the New South Wales Aboriginal Languages Trust, and our 2021 literature review is a public document on that trust's website. But that's an example of where well-being, it's very important in relation to people's health, but it is more than people's health. And so I thought it was important, given in so many other contexts we now are willing to understand well-being as more than just health and healthcare, that the Commission also be open in its very terms of reference, open to that wider understanding.
Great. I don't know if anybody else online wanted to contribute anything, but I know that that was your point. Dr. Hobbs or Dr. Morris?
Look, just to add, it's Shireen Morris here. One of the most powerful things about the agreement making and settlements that are pursued under the Waitangi Tribunal, which I kind of envisage as being a sort of similar kind of body to a potential Makarrata Commission, is that when an apology, a settlement is reached after negotiation, the apology by the Crown or representative of the Crown is often delivered in Maori. The Act, the piece of legislation that enacts the agreed settlement, is often enacted both in English and Maori. And it becomes the sort of the ceremony, the settlement ceremony, can have song and dance. It can become a real moment of cultural exchange. And those aspects to this process are what can potentially make it so meaningful and healing, and can result in the real learning and growth by all sides. So I think there's a lot we can potentially learn from New Zealand in that regard, in the way they've used those processes to embrace their Indigenous cultures there.
Thank you, Senator.
Sorry,
Mr.
Sorry, I have to say, sorry, yeah, this is Harry speaking. Sorry, Senator. I would just say, similarly, to agree with Shireen, similarly to the case in Canada, you see the Truth and Reconciliation Commission from 2015 that a lot of the calls to action that is issued not just to government but to civil society and to other actors are about restoring the pride in language and culture and giving a much greater understanding and appreciation within the broader Canadian context of broader Canadian community. And so that's one of the really powerful aspects of a conjoined process that is not just a matter of truth, but truth and action.
Great, thank you. I'm going to share the call to myself and ask a couple of questions now. I'm keen to understand a bit more about the international experiences of meaningful truth-telling process, and I heard your point earlier, Dr. Morris, about not wanting to kind of do a copy and paste to the experience here. So what are some of the kind of international experiences you think is worth kind of cherry picking for us here in Australia?
I think there's a lot we can learn from the Waitangi Tribunal processes in New Zealand that have been occurring for a while there. The Waitangi Tribunal balanced membership is sort of an umpire body. It presides over inquiries into historical breaches of the Treaty of Waitangi. Experts, historians, anthropologists, lawyers, of mixed Maori and non-Maori membership. And the committee will produce an account of the historical record, drawing on all the evidence, and will make recommendations for how the breach of the treaty might be rectified, right? And then the parties are sort of encouraged to go off and negotiate a settlement. And I should say that is settlements can also happen independently of the Waitangi Tribunal truth-telling process, but that is one pathway. And then a process of negotiations between the Indigenous group and the Crown happens, and there is, I think it's used to be called an Office of Treaty Settlements. I'm not sure if the name has changed. And then the settlements can involve a whole array of things. There can be some financial compensation, although it is acknowledged that the financial compensation can never be commensurate to the actual losses experienced, right? So it's sort of symbolic amount of financial compensation, some return of land, a Crown apology if there was a Crown breach of, if there was a Crown past wrong, there is often a Crown apology. And I think the first settlement, the Queen of England came and delivered the apology. If I'm not mistaken about that, Harry, you can correct me if I'm wrong. And the delivery of the apology is an important part of the settlement, an important part of the healing. And then another really important part is the sort of cultural and language redress. So it might be an agreement about dual place namings or language revitalisation programs. The recognition of Maori as an official language of New Zealand actually flowed from a recommendation of the Waitangi Tribunal, for example. So I think, of course, we don't want to copy New Zealand. Our history and our constitutional structure, our politics is very different to New Zealand. At the same time, I think there is a lot we can learn from what has happened in New Zealand that we can adapt to Australian circumstances. And I think there probably needs to be a much deeper process of designing with Indigenous Australians a Makarrata Commission for Australia that really takes the best lessons from New Zealand and perhaps a country like Canada to design the best Makarrata Commission for Australia.
Yeah, I suppose that leads me to my next question, which is, this is my last question because we do have to get on to our next witnesses in a second. But I'm not sure what information you've been able to gather about, I suppose, the processes undertaken in those international examples for community engagement, consultation. Like, where do you see that some of the best practice examples, I suppose, for getting that buy-in, I suppose. And maybe that's not quite the right words, but you know what I mean. Like, how do you get?
Yeah, I know what you mean. Yeah, I actually don't know the answer to that question. Harry, do you know?
I would say, just to echo what Shireen has said there, and the question, community acceptance and community support is the most important thing we need in any successful Makarrata Commission in Australia. And that's not only just because of the particular legal, historical, political framework we have here, but even in New Zealand, even in Canada, these processes only work if you have community support, community ownership, and a broad political consensus for it. You see even now in New Zealand with the principles of Treaty Waitangi Bill, although there is contestation around what the Treaty Waitangi means in New Zealand, it isn't affecting or doesn't relate to the settlement process. So the settlement process that Shireen has described maintains community and political support. So the protest or the contestation does not affect the settlement process. That is seen as a valuable and effective and meaningful truth-telling and agreement-making process that can bring all New Zealanders together. What happens in Canada as well is that it has broad community acceptance. And again, it didn't always have this. There was a great period of contestation in the first 10 years in British Columbia before it gradually reached some acceptance. And that took a lot of hard work by people going through communities, allowing communities to take part in the negotiations and the community processes. So it was going on country and opening up to not just First Nations people in Canada, but non-Indigenous Canadians as well. So they could see what was going on in these negotiations and in these discussions and kind of come to some understanding that their interests were not going to be negatively affected by this. And in fact, they could buy into the system and see that this was going to produce great benefits for all Canadians. And so I'd say sort of doing stuff on country, doing stuff and inviting people and making them open and transparent is really important. You see Victoria, they're doing a lot of this stuff already with the Euro Justice Commission and the First Peoples Assembly. So some of these things are happening already in Australia we can draw on, but it's about trying to, as much as possible, allow people who might think that they will be negatively affected to be part of the process and see that there is value in it for them as well.
Thank you very much. That is all we have time for this afternoon. I want to thank each of you for your attendance here this afternoon. If you've been asked to provide any additional information or you want to provide any additional information yourselves, would you please forward it to the Secretariat by the 5th of March? And you'll be sent a copy of the transcript of your evidence and have an opportunity to request any corrections to transcription errors. Thank you very much. We'll take a short suspension while we welcome our next witnesses.
Thank you. Thank you.
Individual.
Oh, yeah, great. That's a great idea.
Oh, that's the share.
Give you a moment to get yourselves in order. Ready to go? Excellent. We'll resume, please. I now welcome our next witnesses to give evidence today. For the Hansard record, would you please state your full name and the capacity in which you appear before the committee today? I might start over here.
Oh, I'm Auntie Glendra Stubbs and I'm a Wiradjuri woman, but I'm here as an individual with my co-presenter.
And I'm Elizabeth Rice, also here as an individual.
Great. Yeah. Thank you very much. So although the...
It's important to have individuals instead of, you know, people that are representing an organisation. I think you get a different...
different perspective.
That's correct.
Yeah, absolutely. It's good to have all types of voices and experience to have input into.
And a bit older too.
Lived experience.
Yes, very important. Is this the point at which we make our opening statements if we wish to?
I've got to read a little spiel first, and then you can get to your opening statements, and I'll let you know at the point which you can do that. So although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard, who sit over here, and attracts parliamentary privilege. To assist with the transcription of the public hearing, it would be appreciated if you could please state your name before responding to each question. And now I invite you to make a brief opening statement.
Hi, I'm Auntie Glendra Stubbs, Yallamandu Marung, Galindara. I think this is a real honour to be here. It's a real honour to be able to have a yarn with like-minded people, because otherwise you wouldn't be here. And I think, you know, it's very brave too. I got this idea that you're a bit nervous. I said, don't be nervous. This is really important, really important. I mean, and people will come forward. People will yarn to you. I mean, when I started to work with the Royal Commission into Child Sexual Abuse, I said to the commissioners, no one's going to talk about this. No black fella's going to talk about this stuff. And we had 50% of our mob came forward and talked about the most private stuff that's happened in their life. So you'll have this. You'll got it.
I'd like to acknowledge that I'm giving witness today on the land of the Gadigal people of the Eora Nation, and I pay my respects to their elders past and present. I also acknowledge the other First Nations people here today, including my friend and colleague Auntie Glendra Stubbs, who is the principal author of our submission. In my statement, I'd like to focus on the issue of awareness raised initially by Mr Stewart at the first hearing and then taken up by a number of witnesses after that. And by awareness, I'm referring to the matters that we who are not First Nations people need to understand and accept if all Australians are to be able to exist in a unified nation. Some of the matters include, and this is a very cropped list, understanding First Nations identity as First Peoples. We need to understand that the First Nations are not simply another multicultural group. They are the First Peoples of Australia and have never ceded sovereignty over their lands, their seas and their lives. First Nations rights is another matter we need to be aware of. As First Peoples, the First Nations of Australia have the rights outlined in the United Nations Declaration on the Rights of Indigenous Peoples. This declaration does not grant fresh rights, it simply recognises rights that already exist. There is also a need for negotiation, not just consultation. Given their rights as Indigenous peoples, we should be negotiating with the First Nations, not just consulting them on matters that affect them directly or might affect them disproportionately. Western governance barriers also need to be understood. At present, First Nations have to retrofit their proposals into a Western governance system, and these government systems can also have very different concepts in critical areas such as health, for example. A better option would be for First Nations proposals to be recognised as valid in their own right, and for Western law and governance to adapt its systems to remove the barriers to the implementation of First Nations approaches to First Nations issues. First Nations expertise is critical. First Nations are the experts in how to work between two worlds, and we need their expertise. The contributions already made to this inquiry demonstrate this expertise. Another example is the last third of the recommendations of the Bringing 'em Home report, which provided a blueprint for Aboriginal self-determination with local autonomy within a national framework in the areas of children's and young people's wellbeing. Tragically, no government has acted upon this. We also need a better understanding of culture, and I'm talking culture generally here. Culture is not just formal public activities. Culture is embedded in what we do every day. It is how, within our families and communities, we become people of our culture. This is one of the reasons why the removal of First Nations children from their families and communities and the extraordinary rate of their removal has such devastating effects. In closing, I stress that this is not a comprehensive list of matters, as it's based only on my experience of what I have needed to learn, and I'm still learning. I also recognise that it does not address how to help people move from denial to acceptance, and I'm referring here to the 60% who voted no in the voice referendum. I would also like to emphasise that no matter how much learning we do, it does not make us experts in these matters. We might end up knowing about various aspects of First Nations life, but we do not know from lived experience. We need the political will and the civic humility to recognise this and to remove the barriers in our systems that impede the implementation of First Nations governance for First Nations people. There is a much longer version which I can provide if you'd like.
Excellent. You're very welcome to provide that to the committee on notice.
I mean,
and there's 48 pages.
They've got that.
Yeah, we've definitely got the submission.
Grateful for the short version.
Thanks,
hour of the day.
Yeah, that's right. Especially for our WA colleagues who had to come very early on their time today.
Oh.
Yeah.
Yes.
We'll proceed to questions, and we'll begin with Mr. Perrott.
Thank you very much, and thank you for your evidence. And I probably should declare, Chair, that my wife and Auntie Glenda used to work together at No More, so I met Auntie Glenda a few times.
Yeah.
And
she's deadly.
I'm a big fan. But with that in mind, I'm going to ask this question. Can you see any challenges in requiring the majority of the Commission's staff, including senior management, to be Aboriginal and Torres Strait Islander peoples? And that's for Ms Rice or Auntie Glenda.
I think we work best when we work together, when we hold hands and walk on this journey together. I mean, we're the minority of people, so our pool of expertise is smaller. So we'll use you up and get all your expertise. Oops.
Yeah, no.
Yeah, because, there's more to choose from. There's more to choose from. Like me and Elizabeth have been doing stuff together for 43 years, and we're just about, we're getting older. But, you know, we're still passionate about the stuff that's important to us. I'm passionate about the number of our kids that are in care, the disgusting number of our kids in care that never go home, you know, and there's no, you know, so it's about trust. You know, you take a couple of kids from a community and no one trusts anybody in that community again, because, you know, if you put the systems in place to support the kids and the families, you'll get much better results, and you know, people will want to work together. That's just one example. I could go on, but we.
Ms. Rice, would you like to?
I think
you've seen an arc.
Yeah, I think my position on that was that very often you might get First Nations employees brought in at lower levels within the hierarchy. I'm not talking about their skills and expertise, but structurally lower levels. You do need First Nations leadership at the top in senior management rather than non-First Nations. Or as one Aboriginal friend of mine, not Auntie Glenda, says, Aussies. He refers to us as Aussies. Yeah, so that was...
Any comment on the power of a commission to compel First Nations people to take evidence, you know, to summon witnesses and appear before the commission, in terms of the commission informing themselves, which is a slightly different power.
Yeah.
You're familiar with it from the Royal Commission, but it's not a power that is used very often in our common law system, I would suggest.
Sounds damn scary to be compelled to come.
Like someone knocking on your door and say, Auntie Glenda, you need to appear here tomorrow, we're going to ask you questions.
Yeah.
What's your thoughts on that? So,
well, I'd probably think, what the hell? But, you know, if it's my choice to come, I'd gladly come. This is really important. This is really important. So I didn't get dragged along. I came here willingly, and I think it's an honour and a privilege to be part of this.
what about a body having that coercive power, which is, as I said, not something we use very often? I think we occasionally use it in the criminal justice system. Yeah. The robo-debt process, but
I wouldn't be selling that as a point to get people in.
No, well, I'm interested in your views on people being compelled, and you started by talking about the reluctance of First Nations people to come forward, but no more, as you, the Royal Commission
50%.
had an incredible number of people come forward from prisons and all sorts of places.
And we're still getting those people coming, because it's about the redress scheme now. So people are still coming, and we are very heavily involved in the prisons.
And everyone is coming forward willingly. No one is being coerced.
But I think that's about the trust that people had that this wasn't going to be a difficult process, and that you weren't going to be, you know, shamed and felt uncomfortable. It was really a one-on-one, like having a yarn about something that was really important, and you did it like really gently at the pace of the person, not like you've got 45 minutes now, tell us
So something, I'm putting words in your mouth here, but something slightly outside the judicial process, maybe sitting in a yarning circle, rather than a court of law with people with wigs and, you know, brandishing Bibles and all that sort of thing.
Yeah, I think so. That if you're looking for best practice, I think that would be a good practice. Not that I'm expert, but...
You've seen a bit over the years, I would suggest. Ms. Rice?
My concern when I was reading through those is the potential intersection of cultural safety and those provisions, and it was the trust issue that was governing me, and that was my first big learning area with Auntie Glenda when I was writing a funding submission for Link Up for her. And
I didn't want it. I didn't want it because it was from docs. But then I changed my mind. She won me over.
I was never a caseworker. So I just thought, well, there may be issues for some Aboriginal people called to appear, where they do not feel culturally safe to do it. But you know more about that than I do.
But you've seen over time how the rules of evidence. We can have oral traditions. It's not just a case of, you know, academic writing submissions. You know, there's different ways to acquire information for tribunals and courts, as Auntie Glenda saw with the
I
note.
just raised a concern, but as I say, Aboriginal people are the experts and they know the answers.
As your darling would know, that we people brought a painting because they couldn't say the words, but the painting was what told the story of what had happened to them, or you know, the fellow with the guitar who sang a song that was, you know, had everyone crying. So it was a different way of obtaining evidence, which was outside the box, but it worked.
And I know in Queensland we have Murray courts and different ways to approach the legal system. It doesn't have to be something straight out of the Old Bailey in the UK. So
we have Youth Koori Court here in New South Wales.
Okay. Thanks, Chair.
Thank you. We're going to Senator Little.
Thank you for coming today, and thank you very much for your service in the area of trauma and children for such a very long time. And I congratulate you on your recognition on the Australian of the Year Awards as part of that process. Can I just ask you about, it's great to see people coming in here as individuals and making representation. I asked questions before about the processes that would enable greater resourced organisations, organisations whose voices are amplified, and the risk of the process and them being dominated in that process. Have you got any ideas about how to ensure that people are actually participating and everybody has a chance to participate?
I think, you know, by us two being brave enough to come, other people will come forward as individuals. I totally agree with you, Senator, that we don't want the big multi-million-dollar organisations, the ones that are giving the evidence how wonderful everything is.
This committee has been asked to look at an act that has been put into the Parliament to consider this, and it talks about a 4-year time frame, and the people who would be appointed to whatever this structure looks like, either being appointed for 2 years, but there's potential to appoint them for a further 2 years. You mentioned about the redress scheme, and we know that we've seen the redress scheme extended because people have not been able to work to that time frame. A time frame, do you see this as a structure that is a 4-year time limited, or do you think that that's unrealistic?
I think the 4 years is only going to be 3 years, because the last year will be about winding up and making sure you've got all your paperwork and everything in order. So I think it must continue. That's my opinion. I mean, I guess it'll be people like you with more knowledge than me would know, but I just know from the Royal Commission, it got extended. The redress has been extended. The stolen gens in the territory's been extended. Everything gets extended, because I think what happens is people think about it and they go, oh yeah, I'll do that, and then they're scared. But then word spreads that it's not such a bad process to go through this, and then at the end, when you should be, you know, tidying up, you get this influx of people that don't want to miss out. Yeah.
The topics that could be covered as part of this are not actually dealt with in the reference to the Act, which means that it could be everything at large. Is there anything that you think should be prioritised or shouldn't be part of the conversation, the truth-telling?
I think the truth is about everything that's the truth. Yeah, so I think it should be big.
So how do you deal with, how do you think you step through dealing with issues where there might be a conflicted view, even in the same families, even in the same communities, about truth? And I'm not suggesting that people are intending to lie, but their ability to reflect a consistent experience is hampered by a whole range of things. How do you actually deal with those things?
I think you just have to take each person's, because people say story, but I say it's an account, because if you say story, it could be fictional. If you say it's an account of what happened, it's like, I think it sounds like it's the truth. And I think, you know, even if it's in two families, the same truth is different. Like, do you know what I mean? People have different memories or different experiences about what the truth is. So I think everybody's truth has to be honoured.
So what's the outcome? What do you think should be the outcome?
I've got no idea. I was just so excited about this first step. I hadn't thought about outcomes. I just think that, you know, we're in good hands here. The outcome will be what the community wants.
Do you mean the outcome from the Commission bill if enacted?
Yeah, what's the outcome? Because there'll be different people.
Yeah. I would hope it
see this differently.
Ultimately ends up in Aboriginal control and over Aboriginal lives. I mean, I don't know any Aboriginal people who wants to govern my life. I know they do want to govern their own. And I don't know how that should work, which is why I defer to Auntie Glendra. But if on a couple of other things you touched on, I was very impressed by the evidence given by the witnesses at the first couple of hearings on that time issue. And we touched on resources, but in a sense that's also a function of the time. And unless a lot of work goes into that front end before you even start, which is what they were saying, it's not going to end up with a satisfactory outcome, I don't think.
Thank you. Thank you, Chair.
Is any outcome better than no outcome?
Well, the fact that this bill even got onto the parliamentary agenda and let alone actually got onto the floor of the House and then was referred to committee is a huge achievement.
You should all be proud of yourself.
I used to work for a minister in the New South Wales government, so I learned a little bit about parliamentary procedure.
Would I hand to Senator Cox?
Thank you, and thank you. It was no mean feat in drafting this bill, can I tell you?
Yes,
on behalf of my staff. And thank you both for your submission and also acknowledging your work and recognition that you have a very important legacy, which I think everyone should be reminded about, both your work but also your vision.
We all want to keep kids safe.
In your submission, I just wanted to draw some attention to some of the things that you wrote that we picked up, that you were asking for context on how the relevant stakeholders would be identified in subclause 7.3. Is that because you weren't sure about what sort of stakeholders? I think just alluding to Senator Little's point around what sort of things would be presented in evidence to...
That's a key issue.
Yeah. Well, I think, you know, we had a few key stakeholders here today that seem to, still hear some of them, that would like to have their voice heard, you know, and I think people will put their hand up to say, I believe I'm a key stakeholder, and I think we've addressed that we don't want, you know, it top heavy. We want a, you know, mixture of everybody. Yeah.
And I think the point that was made earlier today in evidence is this is a commission for everybody.
That's correct.
And that it's for Australia's future and making sure that we get that right. I just wanted to pick up the point of clarification on the commission's concurrent functions and powers, and particular the intent of the word may in clause 9, and picking up Mr Perrott's comment around the powers of a commission to compel people to give evidence and the legal way in which that's used. And I think the intention of that clause is really around not necessarily, and I think his point was not using it against mob to knock on their door and say, come and give evidence. It's actually more for government officials and the outcome of justice.
Oh, we need to.
And that it
I think too often we all know that there are many royal commissions, and you alluded to the inquiry on child sexual abuse, institutionalised child sexual abuse, and that there is no outcome, there's no justice. There's certainly no peace from any of that for our people, and that the compelling of witnesses and ensuring that the function and powers exist to actually get them to come and front the committee. I can't even begin to tell you how difficult it is for us to get government sitting in front of us as Senate and joint select committees because they refuse. And so the powers, to just clarify that, exist mainly to get some compliance from governments who have been responsible for the history and responsible for the actions and the outcomes that follow that. So
can't you name and shame them?
We could. It lasts about 5 minutes in the media we've done that on successive inquiries. But I just wanted to make that point. I know that was really something that you had stated in your submission.
I also think, you know, I've been commissions or royal commissions and stuff since the Wood Royal Commission when I gave evidence to that. So I think your words were really important, that we want something that's got teeth.
Yeah. Sick of the toothless tiger, right? You also put in there that you would suggest that we amend clause 34 around public communication. So it's just interested in like what you would like to see, that the Commission, you've put that the Commission must communicate information. Can you tell me why you think that's necessary? And do you think it's for all information to be publicly
That was about cultural safety.
Yep.
And I think the other must might have been too, there is one area of the bill where it talks about the states transferring powers to the Commission to act in certain ways, and it wasn't clear from the May whether all of that would be governed by the cultural safety provisions in the bill, I think. And I think it was the same, we had the same concern there.
So that's
that any authorities who are acting as part of the Commission's activities or related to them would be bound by the same cultural safety laws.
So that's in clause 9, the one around May, the transfer of powers. But in clause 34, you've talked about.
Oh, I haven't got the full one in front of me, right? Yeah.
No, you've talked about like that it must communicate information. Yeah. Why do you think that's important?
Sorry.
On why you think it must be communicated about the communication of information by the Commission. I don't know.
Oh yes, I think this was the bit where it refers. It was the bit where it is referring to other bodies, other jurisdictions. I think, is that correct? I haven't got the full bill in front of me.
Clause 34.
I've only commented on 34 itself as a whole, I think, but I think again the concern is just if other bodies are brought into the process, are they going to be compelled to observe the cultural safety provisions in the Commission bill?
Yeah, my question says you suggested amending clause 34. Commission may communicate information. So
it might.
And that you've recommended we change it to the Commission must communicate information.
Yes, I think you might have touched on that as well in the cross-cutting issues. But we can certainly get back to you on that.
Yeah, that would be great. Yeah. That's it from me, Chair.
Thank you. And like I'll ask these questions, I think it kind of builds on what Senator Cox is talking about, I think, which potentially might be why you're talking about it, changing the word may to must. I suppose my kind of questions go to public education in the broader Australian context. So I think lots of people have misinformed ideas about Aboriginal people's history and place in this country. How important is education for the Australian community broadly?
I think we're in good hands if you go into a preschool and the little Chinese boy's putting his arm up and saying, "Can I please be Aborigine, Mummy, please?" I think we're in good hands. with the young ones coming through, they're all really interested in our culture. You know, they're not taking on the stereotype, you know, that used to be in the news every minute and in every paper. I think they're, you know, put their effort into dehumanising other marginalised people than us at the moment. So, yeah, I think...
Yeah, I agree with Auntie Glenda about the public education, at least going from my granddaughter's primary school. There is a lot going on. Kids automatically know things that...
There's lots to be hopeful for with the next generation
but
coming
we can't
through.
wait that long to fix things.
So I agree. There's lots to be hopeful for with the next generation coming through. But what do you think can be done in the meantime? I suppose. Look, for the kind of older generation now. I say older, but you know, anyone who's in kindergarten.
I was interested in Karen Mundine's comment, the CEO of Reconciliation Australia, to the welcome to country controversy currently, and she said she's confused by the rancour, and I am too, and I don't understand where it comes from, because, you know, no Aboriginal person I know or have heard of wants to threaten me or my life. So I really don't understand it. So I said at the end of mine, I just outlined some of the things I've had to learn, and I don't imply I know them thoroughly at all. I don't quite know how to help people move from denial to acceptance. One of the things I think in the voice referendum for some people was that they could not distinguish between First Nations Australians as First Peoples and other multicultural groups and we're all multicultural because whether our ancestors came here in 1788 or recently, all of us, except for the First Nations, are immigrants. But when multicultural policy came in, I suppose it was introduced from a majority, probably Anglo-Celtic view, that anybody from anywhere else. And I think one of your witnesses early on, possibly in Victoria, said something about, we think everybody else is like ourselves. And people were saying everybody needs a voice. Well, yes, they do, but not everybody in this country has the rights that accrue to First Peoples. And that's why First Peoples need a voice, because with that comes a different culture, a different governance system, a very experienced government system, and one we can all learn from. In fact, I'm very heartened that there is a trial of cultural burning in the South Coast currently on the, I think it's on the Hume Highway through, to try and avoid trees falling down in bushfires and blocking the road. I mean, it's a long time coming, but there is just so much wealth, and it's based on science, and it's a pity that it's not until science proves that something that Aboriginal people have been telling us is correct that people will sit up and listen. But I actually don't know how you get that. I've tried to reflect on my own life and, you know, what has led me to acceptance. And there's just so many things, including the time with Auntie Glenda, and in fact working through the work I was doing for her. Okay, well, how does this impact on you? Or she might say, no, we can't do that. We don't work that way. But I can't answer the question of how, and I think there is a good piece of work to be done there, because we do want that 60% to reduce significantly.
And maybe if we kind of think about it kind of more, I don't know, personal experience, and maybe you surround yourself with like-minded people, but how do you, like when you're interacting with other people around you who might not share your same views, how do you...
You don't want to talk to the converted.
Yeah, how do you engage people who might not already share your view? Like now, like how do you do that? How would you do that if you were on the tram today? You know, how would you start that conversation?
Well, at dinner at our place one night, one of the guests said, this was more in the native title, it's probably after the legislation, but good 10 years and we'll go, well, are you going to give your house and land back to Aboriginal people? And I said, well, no, I'm not, but I am going to work as hard as I can for structural reform that tries to remedy the injustice that's caused by the taking of the land.
But it was only Crown land that was to be protected. It wasn't people's backyards. And I think, you know, that's the message. Sometimes I think our messaging just needs to be a bit like that. When people were ringing up and saying, I'm going to lose my backyard, I said, no, you're not going to lose your backyard, mate. No one wants your backyard. It's just full of privet, you know. Like, you know, we just want to protect the Crown land so that our kids will be able to walk in this beautiful bush.
Actually, Glenda, I've just remembered that we did a memo together, remember, at one stage,
Oh,
and
darling,
we used an
you've worked
analogy.
you've worked me so hard.
At one time, yeah.
In response, I would say, if Auntie Glenda tags you, you're tagged forever. And we were trying to explain why Auntie Glenda couldn't just hand over her contact list to the non-First Nations lawyers in a given area. And so we started off saying, well, even Auntie Glenda, as an Aboriginal person, can't just rock up to any Aboriginal community in the country and say, here I am, you know, I'm going to talk to you. And then we went on to develop analogies between, especially as Australians are avid travellers, between Europe, which is a nation of continental Europe, which is one continent and multiple nations, all of which have border controls. Well, guess what? So do Aboriginal peoples. And then we went on, I've forgotten, there were a range of things that we went on to explain. And I think that an analogy is quite useful. Concrete, I think people need concrete examples, not just, you know, airy-fairy stuff.
Thank you. I feel like there's probably some more questions, but I have to share the call, and I'll go online now to Deputy Chair, Ms Price.
Thank you, Chair. There is a question to Auntie Glenda, and this is possibly the last question for this session. Noticing, just looking at the overview of your experience, and I know you're an experienced counsellor providing advice to survivors of trauma. So I want to go to sort of like the practicalities of the setup of the Truth and Justice Commission. And just wanted to get your views on, you know, what are the lessons that you've learned through your years of experience with helping survivors of trauma? What are the things that we need to take into account when considering how we might support people that are telling their story to the commissioners? And what's the support that we ought to be providing after they've told their truth? Thank you.
I think that's really important what you said, because the aftercare is really, really important. You just can't get people to talk about their most difficult times and not provide good aftercare. So I think, you know, and it needs to be done gently, because people, you know, we're not all the same. We can't fit into boxes, so it needs to be individualised for each person that's brave enough to do this. Yeah, and it was lovely seeing you in Parliament.
Hello?
Yeah, I said it was lovely seeing you
sorry.
in Parliament.
Oh.
I think we've lost her.
Yeah, sorry, I'm back again. And Auntie Glenda, what about during the course of someone telling their story?
Well, it has.
What sort of support should we be anticipating?
Well, sometimes people.
This all really goes to making sure that the Commission would be, you know, truly financially capable of doing the job.
Well, I think people have to own their own pathway. So if it's a family friend that they want there with them, or if it's their counsellor or their support person, it has to be whatever suits them, because word will travel quickly if there's a bad experience. You know, the good experiences you won't hear about much, but the bad experiences you'll hear about them. So individualised, no time limit, and aftercare. So fabulous that you were raised about the aftercare.
Okay. Okay, thanks very much, ladies. Thank you, Chair. That's it from me.
Thank you, Ms Price. I think Mr Perrett's got a couple of follow-on questions as well.
Just further to the Deputy Chair's question, Auntie Glenda, could you mention some of the processes that occurred in the Royal Commission, but when it came to dealing with the Royal Commission into institutional child abuse, when it came into commissioners dealing with First Nation or interacting with First Nations people, because that might be instructive.
We had to do a little bit of training with the commissioners, because they're not used to doing gentle, easy.
So they were lawyers and police commissioners and all sorts of people, weren't they?
Yeah, but they took their role really seriously, and they listened deeply, and they were open to like that wasn't really nice. We've lost that one. Yeah, because you just want people to not be more damaged. People have been damaged in this country, and we don't want people to be more damaged.
So there can be training for judicial officers or representatives.
Yeah.
An old dog can learn new tricks.
That's correct. And yeah.
Yes, thank you.
Excellent. Thank you so much. Now my job is to say thank you so much for appearing before the committee today. It has been an absolute joy to listen to your stories and to your evidence. If you've been asked to provide any additional information, or you might want to add some more information to what you've already provided, can you please forward it to the Secretariat by the 5th of March? And after today, you'll be sent a copy of the transcript of your evidence, and you'll have an opportunity to make any corrections to errors that you see in there as well. Thank you very much. We'll take a short suspension while we welcome our next witnesses.
Keep up the good work.
We will now resume, please. I now welcome our next representatives to give evidence today. For the Hansard record, would you please state your full name and the capacity in which you appear before the committee? I'm not sure where we should start.
Daniel Wild, Deputy Executive Director of the Institute of Public Affairs.
And I'm Margaret Chambers, Research Fellow at the Institute of Public Affairs.
Thank you very much. Although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. To assist with the transcription of the public hearing, and for those joining us online, it would be appreciated if you could please state your name before responding to each question. I now invite you to make a brief opening statement before we proceed to discussion.
Well, thank you for the invitation to appear before the committee today. Today we are being asked to consider the Truth and Justice Commission Bill 2024. While we all want better outcomes for Indigenous Australians, it is the opinion of the Institute of Public Affairs that this bill is not the answer. Rather, the IPA finds that it would undermine our national culture and way of life. It would further divide Australian society, hand a powerful tool to activists, and pave the way for reparations payments by rewriting Australian history. This proposal is being considered against the context of a commitment by this government to implement the Uluru Statement from the Heart, which included the threefold demand of voice, treaty and truth. The first element, voice, was presented to Australians at a referendum in October of 2023, where over 60% of Australians voted no. Despite this clear and unambiguous vote of the Australian people, the Parliament is pursuing the other elements of the Uluru Statement, namely truth, by way of the Truth and Justice Commission. Our research, and indeed the October referendum result, shows that Australians do not want to be divided by race. In July 2023, the IPA commissioned exit polling into the voting decisions of Australians during the referendum on the 14th of October 2023. In the largest and most comprehensive study of the referendum result, 3,256 Australians were asked about their voting decisions regarding the October referendum. When asked to nominate any of 8 reasons for voting no, 70% of respondents said that they voted no because of their belief that the voice would divide Australians by race. This is significant. It shows that Australians reject policies that divide people by race, which is what this commission would in effect do. They believe that all Australians, regardless of their racial or ethnic origin, are in fact equal. This is what defines the Australian way of life. But the activist impetus behind this bill would seek to completely overhaul this. Far from establishing the truth, the Commission would be set up in such a way to prosecute the false and divisive argument that Australia is a racist country and that a dramatic overhaul of our society is required to reverse this. The terms of reference reveal deep flaws. They require the Commission to prove allegations of historical and ongoing injustice rather than test their veracity. Clause 8 mandates that the Commission must inquire into and make recommendations to the Parliament on historic and ongoing injustices committed against Indigenous Australians. The terms of reference include poorly defined terms, including, for example, cultural violations such as breach and denial of First Peoples law and law, practices of structural and systemic exclusion of First Peoples from economic, social and political life, and ongoing injustices in economic, social and political life. That is, the terms of reference actually tell the Commission what it must find. This reveals that there will be little genuine discussion paid to different perspectives in the community. Another feature of the bill is its race-specific provisions. For example, Clause 11 outlines that hearings should be conducted with consideration to the rules and legal systems of First Peoples. It is unclear from the bill what this means. In another example, Clause 14 provides that arrest warrants would be issued with consideration to the negative interactions between First Peoples and the justice system and the best interests of First Nations communities. This seems to establish a different treatment of people based on their race and would therein function to fuel racial division in our country. The aforementioned deficiencies of this bill are compounded by its harsh penalties. For example, the bill outlines a 12-month prison sentence if a person makes statements that are false or defamatory of the Commission. This penalty is far harsher than, for example, similar offences within the Royal Commissions Act of 1902. Such harsh penalties restricting the freedom of expression of Australians will function only to fuel race-based resentment. As I come to the end of my remarks, a final point is that the bill would pave the way for the advancement of a treaty process and reparations payments. The terms of reference in Clause 8 clearly outline that the Commission is to provide recommendations on how historical injustices can be effectively and fairly acknowledged and redressed in a culturally appropriate way, and consideration of how the Commonwealth Government can be held accountable for addressing these injustices and preventing further injustices. It is not clear from the bill what that means, but it is likely that it will lead to the development of a system of reparations payments, which will serve only to fuel race-based division in Australia. Based on these findings, the IPA finds that the proposed bill is fatally flawed and divisive. It should be abandoned. Thank you.
Thank you very much. We'll now proceed to questions and we'll start online with Deputy Chair Ms Price.
Thank you very much, and thanks to Daniel and Margaret for appearing before us today, and thanks very much for the Institute of Public Affairs submission. A few of the questions I think you've already addressed, Margaret, in your opening remarks, so thank you for that. But how about we talk about the composition or membership of the Commission? So I think IPA's opinion is that the composition or membership of the Commission was inappropriate. Can you give us your reasons why you think it's inappropriate?
Sure. So, as you would know, this commission is proposed to be a 10-member body with representatives from each state and territory, plus an additional 2 chief commissioners. I would just draw your attention to certain parts of the bill, namely that in no way, shape or form does the bill suggest that this is meant to be a representative body. However, it's established by members who are appointed per jurisdiction in a way that would suggest that it's somehow meant to be representative. But if that was the case, it doesn't make sense. As they're appointed, they're not elected, so it's not a representative body in any way, shape or form. The other point to make is that there's a provision that specifically establishes that the two chief commissioners, only one can only ever be a man, whereas two could be a woman. The IPA finds that this is a violation of meritocratic principles and the egalitarianism that makes our country great, and it just seems to be an arbitrary requirement that doesn't make sense in this law.
Okay. And do you have a view on the Commission having the power to summon witnesses, take evidence or issue a search warrant?
Yeah, so a couple of things there, Senator. The first is, as Margaret outlined, the powers of the Commission are pretty wide-ranging. The idea that they could issue a search warrant really goes beyond the normal bounds of what any similar body would be able to follow. I think the normal process in our society is for example, search warrants to be issued by judges, but for this Commission to have that power seems quite extraordinary to be able to do that. And also I believe there's the revocation of the privilege against self-incrimination, which is within the bill, which is concerning from a legal rights perspective. And so, there's a significant amount of power that would be conferred upon this Commission that goes, well beyond what would ordinarily be expected. Plus, as Margaret outlined, a number of the penalties there within are beyond, anything that's remotely similar, such as a Royal Commission. So I think it's quite extraordinary at how, the reach and the penalties associated with this Commission, how far-reaching they are.
Okay. All right, I'll just leave it there for now. Thanks, Chair.
Thank you. We'll go to Senator Little.
Thank you. And thank you very much for appearing before us today. I think it's fair to say that you're probably one of the only people that we've heard that has been really unambiguous in your objection to this Act. Why do you think that is?
I think there's probably a couple of things. I mean, the perspective that we come from is just basically all Australians should be treated as equal. That doesn't mean that everybody's life is going great. And as we say many times, and we've talked about this for many, many years, we want better outcomes for Indigenous people. But for that to be focused in a way that's practical, jobs, better policing, better social infrastructure, economic opportunity and so forth, this bill doesn't do any of that. There's absolutely a role to play for understanding our history, and I think Australia does a pretty good job of that overall in terms of being honest and upfront about the good, the bad and the ugly of our history. To hold, I think, the present generation to account for wrongdoings of the past is inconsistent with what our nation is about, which is people should be treated as individuals, not as a part of a group. So our perspective is that it's just based fundamentally on principles that are inconsistent with what our democratic society is about. So that's, I mean, in terms of why are we the only ones that have an unambiguous objection to it, I think it's because the basic foundations of our institution are such that everyone should be treated as equal, and this just isn't consistent with that.
So there's been some evidence that we've heard today with people saying, well, this is an inclusive process. Your reading of the terms of reference and the Act, does that suggest that it's an inclusive process? Do you see that in any way that could be the outcome because of the way that is actually written up and the thinking that's gone behind it?
Well, I think as Margaret outlined, it sort of presupposes the conclusions, and I find it hard to see how it's inclusive of our society more broadly, because it does start with the premise that Australia is structurally racist or has structural foundations that are wrong. And so if you're starting from that basis, you're going to be excluding large sections of our society from participating in this. It also seems to, I think, have the perspective that people need to be compelled rather than having a conversation about having better outcomes. As Margaret outlined, we went through this with the Voice to Parliament referendum, and the community had an opportunity to think about this and to consider whether they wanted a voice entity within the Constitution, and they voted no to that after about 15 months of a campaign. So that was a very well-informed campaign. I think it was one of the most well-informed referendums we've had. By the time we got to voting day, everyone knew about the Voice to Parliament and what it meant. and it was rejected on the basis that, as a society, we don't want to go down the path of having separate treatment for people based on their race or their ancestry. So, on that basis, I don't see it as something that includes the broader Australian society.
Now, we've heard people giving evidence that talk about this being a tool for reconciliation. We've heard about it being a tool for people to actually tell their stories and some healing from that. But when you actually have a look at the words that are in the bill, it suggests that the bill is to give effect to inquire into and make recommendations to Parliament and on matters particular to historic and ongoing injustice. We've heard references to the statement from the heart. Does this sound like a legislative voice to you?
It does, yeah. It sounds exactly like a legislative voice. And as a tool to expedite treaty and, in our view, reparations payments, the word redress is used in the draft legislation, and sure, that can mean different things to different people, but I think an ordinary interpretation of the word redress often refers to some kind of financial compensation, which I think can only be interpreted as reparations payments. And as we just talked about before, the voice to Parliament was on the ballot and it was defeated. I'm all for people having the opportunity to share their stories and share their opinions, but to effectively circumvent a democratic process, the most democratic process, which is a direct vote of the people, not just through parties, but a direct yes or no vote, I think is profoundly undemocratic. And to pursue it in what is, sort of a secretive manner, or a manner that's not well understood by the public, I don't think is going to serve reconciliation. This is the wrong way to go about reconciliation, by ignoring what people have said. Australians have said, yes, we want to have better outcomes, yes, we want to reconcile, but we don't want to do it through a racially divided mechanism. To go down this path even more is only going to set reconciliation back, not take it forward.
So in some states and territories we've seen different approaches to this, and some have started and then abandoned the process. Is this a duplication? How do you see this actually working if those processes are already in place? Is there anything at a federal level that you think that people could come up with that would be different to what people are hearing in other submissions, in other royal commissions, in other inquiries that have been held?
Well, it's certainly just duplicate, for example, what's happening in Victoria, as to take one example. In terms of, will it provide any additional information? I don't know. But, I think in terms of, going down this path, as I mentioned before, I just don't think is going to serve our nation's best interests.
The references in some of the clauses are to talk of the Commission being able to appoint lawyers. I've heard criticisms myself directly from people who've participated in other processes to say, well, it felt like I was in a court. Does that signal any concern for you that there seems to be a significant weighting on legal participation in these processes, as well as we're hearing from many organisations that are key stakeholders in Aboriginal affairs, Aboriginal sector, who are supportive of this?
Sorry, in terms of are we concerned about the legal powers and so forth?
I'm more concerned about the references right at the very beginning to legal involvement in this, and the involvement of really well-resourced organisations.
Yeah, well, certainly. There's the risk with this that, rather than being sort of a body or a commission of inquiry, it becomes something where they're, using these and deploying these resources to target certain people in a very activist manner. And that would potentially have the effect of silencing people or using the commission as a cudgel, which would be a massive concern. So if it's, a forum to air views and perspectives, well, that's one thing. But if it's going to be, a well-resourced, organisation that's designed, or at least has the capacity to target Australians based on their views or based on what they may have said in the past. I mean, clearly that's something that would be, enormously concerning. I think from our rule of law perspective, and the confiscation of democratic rights. Did you want to add to that?
Yeah, I think my concern with this bill has always been that it seems to me that its purpose is to prosecute a certain historical argument that it's a racist country, and it asks questions to that end in terms of references set up in a way to advance that argument. So it asks a question, but it already knows what the answer is, and that is that Australia needs to be dramatically overhauled, that it's structurally unequal, that it's racist, and it will summon witnesses, in my view, to achieve that end and further that cause.
Do you have any thing to say about, we saw the voice referendum, to which my personal position is very public. It has been devastating for Division in this country. I wanted to ask you about, we heard people after who were campaigning on the yes side who said they needed time to recover and mourn the result. They went quiet for quite some time. The country, I think it's fair to say, was exhausted by that whole process, including the amount of money that went into the Voice campaign. Where do you think we are in terms of timing for this proposition to even be brought forward at this point in time? How do you feel people would view that, even, just the timing of it?
Well, I think it's insensitive. Like I mentioned before, Australians have been through this, and we were asked what we thought of these kind of proposals, and Australians voted no to that. And as I said, it wasn't a no vote to Indigenous people, it wasn't a no vote to even necessarily constitutional recognition, and it certainly wasn't a no vote to recognition. It was, reconciliation, but it was a no vote to having this sort of ongoing separatism between Indigenous and non-Indigenous people. And I think that's what Australians don't want to do. We don't want to see a situation where we're further sort of pushing this idea that we need to have separate treatment for people based on their background. Clearly, the current approach to Indigenous affairs is not working. There's tens of billions of dollars that are spent on this matter, and you just have to look at the Closing Gap report released a week or two ago to see that we're not getting the outcomes that we want. But I think the idea of having more power within a Commonwealth bureaucracy is simply not going to fix those problems. We already have bureaucracy after bureaucracy, so we need a fundamentally different approach to how we improve the outcomes of Indigenous people. So I think a lot of Australians would find this surprising, they'd be concerned, and also the timing, I think, is highly inappropriate and insensitive to that democratic process.
Thank you. That's all the questions from me. Appreciate it.
Thanks.
Have you got questions, Mr. Parrish?
Yes, I just wanted to clarify. In 1967, I think 91% of Australians said we do want the Commonwealth to make decisions based on race, and had actually amended the Constitution. Is that right?
Well, I interpret the 1967 as the opposite, which is it removed references to race in the Constitution, and that was critical. I mean, the voice...
I'll read a bit of the Constitution to you if you like.
Go for it, but it removed yeah, if you want.
No, it took the race power from the states and gave it to the Commonwealth.
Yeah, but a reference, the key part of that referendum was to remove a reference to race within the Constitution.
Well, I must have a different Constitution to you, Mr.
Well, you can have a look at the Constitution before and the Constitution after,
I've got
and you will see
in front of me.
And you will see that there are fewer references to race as a consequence, in recognition that we're all equal. So 91% of Australians said we're an equal country, and the voice to Parliament would have undone all the work that was done in 1967.
Hold on. Just stick back in 1967 in terms of that amendment, in terms of giving the Commonwealth that race power. You're saying it's a different... It removed the Commonwealth's ability to make decisions based on race, did it?
No, what I'm saying is it removed references to race in the Constitution. If you look at the actual question that was put, it was fairly clear that it was to make the Constitution more colourblind.
It said Aborigines not to be counted in reckoning population was repealed by the 67 amendment. So as if 91% of Australians were happy to make a vote with the concept of race in their mind. Would you agree to that proposition?
No, I don't.
So there was race was not a consideration in 19...
Making us more equal was a consideration, yes.
Okay.
Do you think the 1967 referendum made us more equal or more divided?
Mr. Wild, I'll ask.
That's fine. It's just a pretty
you can write to the committee if you've got a question to ask us.
If you can't answer that, then
it's
quite revealing, I would have thought.
Well, and so do you think that race exists as a concept? Concept?
Yeah, I do, yeah.
But you're saying in Australia that race is not a concept?
It's a concept, but people want us to be equal. People don't want race to be a fundamental component of how our society is.
No, I'm not saying fundamental. If I identify as Irish or Anglo-Saxon, can I say that's a part of my identity and my race is something I can discuss?
You can say whatever you want in this country because we're a free country.
Yeah, but is race a part of my makeup? I don't mean scientifically.
It's up to you whether you want it to be or not. But our point is a very simple one, which is all Australians are equal and we should be treated as equal before the law, and that's why Australians voted no.
So does that mean we shouldn't provide money for multicultural events that are connected to the race of certain people?
No, not at all, because I don't think they're connected to the race. They're connected to the fact that many are new migrants to our society, and that's a wonderful thing.
But isn't that treating them differently to the Australians that are born here?
No, because the Australians that are born here aren't migrants. So it's a provision for migrants.
Yeah, but isn't that treating them differently?
I don't understand the question.
That's all right.
It's a bit confusing.
One more question.
Oh, no, that's fine. That's fine.
You good?
Yeah.
Senator, did you have a follow-up, or are you okay?
No.
No, that's okay. I was just checking in. Okay. All right. Thank you very much for your attendance here today. If you've been asked to provide any additional information, would you please forward it to the Secretariat by the 5th of March? You'll be sent a copy of the transcript of your evidence, and you'll have an opportunity to request any corrections to transcription errors. Thanks very much. We'll now adjourn for the day. Thank you very much to Hansard and to the Secretariat.